Mm. Switch it on. Good morning. This is
ಈಗ ಯಾವತ್ತಿಗೆ ಅಲ್ಲ ಈಗ ಯಾವಾಗ ಬೇಕು? ಫೈಲ್ ಸಿಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆನೂ ಹಾಕಲ್ಲ. ಅದೇ ಫೈಲ್ ಸಿಕ್ಕಿದ್ರು ಅದೇ ನಾಳೆ ಹಾಕ್ತಾರೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ.
ವಿಡ್ರಾವಲ್ ಮೆಮೊ
ನಾಳೆ
ಅಲ್ಲ ಮೊನ್ನೆ ಬರ್ಲಿಲ್ಲ, ಫ್ರೈಡೆ ಕೊಟ್ಟಿದ್ದೆ.
ಯಾಕೆ ಗೊತ್ತಿಲ್ಲ, ಅದು ಫೈಲ್ ಸಿಕ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಹಾಕದೇ ಇಲ್ಲ ಸರ್.
ನಾಳೆ ಬರುತ್ತಲ್ಲ,
ನಾಳೆ ಕಳಿಸ್ತೀನಿ, ಗೊತ್ತಿಲ್ಲ ಬರೋದು ಬಿಡೋದು.
ಮೆನ್ಷನ್ ಮಾಡು ಅಂದ್ರೆ ಮಾಡಿ.
ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಪಾಸ್ಪೋರ್ಟ್ ಎಕ್ಸ್ಟರ್ನಲ್ ಗಡಿ ಕೊಡೋದು ಎಕ್ಸ್ಟೇ ಕೊಟ್ಟಿರ್ತಾರೆ. ಲಾಸ್ಟ್ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಈಗ ಪೊಲೀಸ್ ಇನ್ನೊಂದು ಎಕ್ಸ್ಟರ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಅದು ಚಾಲೆಂಜ್.
good morning. May I know if I'm audible?
Yes, madam.
Thank you very much.
ಅದನ್ನೇ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ. ಅಲ್ಲೂ ಆಗಿದ್ರೆ ಅವ್ರು ಮಾಡ್ಬೇಕಾಯ್ತು. jurisdiction, question of jurisdiction. Jurisdiction entertainment. I'll stay quoted.
1 kg ಕಮ್ಮಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಅದರಲ್ಲಿ ಅಪೆಲೇಟ್ ರೆಮಿಡಿ ಇದೆ. PDS ತಾನೆ ಅಪೆಲೇಟ್ ರೆಮಿಡಿ ಇದೆಯಪ್ಪ. ಯು ಕ್ಯಾನ್ ಕಮ್ ಟು ದಿ ಹೈಕೋರ್ಟ್ ಫಾರ್ ದಟ್. ಯಾರು ಇಲ್ಲಿಗೆ ಹಾಕಿರೋದು? ಬೇರೆ ಯಾರೋ ಹಾಕಿದ್ದಾರೆ. ನೀವು ಹಾಕಿದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ? ಅಪೆಲೇಟ್ ಕೊಡಿ. ಯು ಆರ್ ಲೂಸಿಂಗ್ ಟೈಮ್.
My property has been attached in a case where I'm not even a party to proceedings. For recovering those two proceedings, they've attached my property.
Give it tomorrow.
My passport has been withheld and rejected by the authorities, stating that I'm Bangladeshi, not able to travel. Notice has been issued to the respondents.
Indian passport has been. Passport is Indian passport.
My lord.
Tomorrow, you serve it on Mr. Aditya Singh or Ms. Reshma.
My lords, the petitioner has filed an application for exit permit, my lords. She's citizen of Thailand.
Application for
Exit permit.
exit permit.
Yes, my lords.
Ah.
Her tickets are booked for 23rd, my lords. We have filed an application for exit permit on 4th of this month, my lords. Till date, my lords, application is not processed. That called for an
Put
inquiry.
on Mr. Aditya Singh
Please, my
or
lords.
Ms. Reshma
For
tomorrow.
2:30, my lords.
Tomorrow, they'll have to get instructions.
For 23rd, my lords.
Who asked you to book, madam?
For 2:30, my
They
lords.
did not ask, we did not ask.
Please, my
They have to
lords.
get instruction. Can they get it by afternoon? They can't.
Please.
Tomorrow.
My lords.
But serve it on them, otherwise they won't get instruction tomorrow also.
Fresh matter, authorization issued to the rent, fair price depot has been suspended without giving an opportunity of hearing. 2 ration depots have been suspended at Padarayanpura, Bangalore.
Kodi. But do you have an appellate remedy? You have an appellate remedy. Yes.
For a sum of rupees 3.5 lakhs, a lien of 36 crores had been imposed, my lords, and we approached this honorable court. This honorable
Two
court-
extra zeros have been added. Yes.
Honorable court reduced it to 10 crores, my lord. I've further filed an application to reduce it, my lord. There's some difficulty in statutory payments. Thought we have it tomorrow.
It's from outside Karnataka or?
Inside Karnataka. Within Karnataka. For a sum of rupees 3.5 lakhs, my lord, 10 crores, this honorable court has directed us to maintain as the minimum balance.
There must be some reason why the coordinate bench is directed.
Filed an application to reduce that amount. My lords may have it tomorrow and
Then that is a modification of the order. It can't be taken up by us. That is why.
lords may
It's
have
a pending matter. You
Pending
want a modification of an order passed by a coordinate bench. We can't do that. You'll have to move that bench.
filed
Yes.
an application. my lord.
Application for including because petitioner obtained a stay order without completing the necessary party. So kindly have it next week.
It's a pending matter. It'll come in seniority. It'll come in seniority. ಏನಕ್ಕೆ? Fresh matter? Yes.
RBI has filed application for vacating stay. Stay was granted ex parte, my lord. My lord, may kindly hear the matter.
It'll come in seniority. Yes, Vasant?
My lord, I directed the matter to be listed today, but it has gone to Court Hall 40A regarding service of the hand summons, my lord. Hand summons has been served, may it
You
be
place
taken.
it before the registrar. They'll accept it and they'll post it tomorrow before us.
May it be taken this afternoon.
We can't do like that when it is before the registrar. You place it there.
No, I mean at 2:30, if I,
Mr. Vasant, it can't happen
Very
like
well.
that. The list is before the registrar.
then tomorrow I'll inform them or file a memo. my lord.
They'll pass an order and it
They
will
will pass.
Okay. Yes,
At 2:30.
tomorrow.
My lord, we have filed a vacating stay application, my lord. My lords have given-
Pending matter will come in seniority.
My lord, last week date ಕೊಟ್ಟಿದ್ರಿ but list ಆಗಿಲ್ಲ.
Date ಕೊಟ್ಟು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
List ಆಗಿಲ್ಲ.
ಚೆಕ್ ಮಾಡಿ. ಡೇಟ್ ಕೊಟ್ಟು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ ಅದು. Auction by? So it's a sufficient matter.
No, not a surface matter, it's application, buses are being seized.
Hmm.
And they've been typically under value instead of 1.7 crores, we're selling at 95 lakhs.
Even that, if the bank is doing it, would be sufficient. There will be excise, hypothecation is also sufficient.
Surfacing proceeding. Only a 7 days statutory notice issued, no provision is mentioned.
Posted before the appropriate bench and third.
My lord, fresh matter.
Just a moment. We have doubt about whether it will come before us. We can't fix a date. Appropriate
Matter has
bench.
already been taken up last week, not by my lord. Now, very same matter, the previous option was challenged.
Check ಮಾಡಿ. If it is ನಮ್ಮ bench ಅಂದ್ರೆ day after tomorrow.
Tomorrow,
Yes. Pending matter, madam. Pending matter. It will come in seniority. Day after tomorrow.
Fresh matter.
There's a train petition against certain appeal member to petition not being a member of, they are listed in the FIR. Their debit fees both the parties are.
Wait,
Fresh matter. Election matter.
don't try to come in between.
Fresh matter.
Yes, what is it?
Election matter.
It come in the regular course. Fresh matter, you don't need to move.
One disposed matter, my lords, your lordship may recall relating to Kannada Sahitya Parishad, my lords. We filed IA for recalling of the order, my lords, and we are seeking to withdraw the petition, my lords. May kindly be taken up. My lords, it was dismissed for non-prosecution, my lords.
Then let it be dismissed. Why you want a withdrawal?
No, my lords, with liberty, my lords, to approach the honorable. Please, my lords. My lords, if it is dismissed for non-prosecution, my lords, we won't have the liberty. Please, my lords.
Next week, क्या होता है रात? Yes.
It's for an adjournment. I'll just take my turn. Requesting for an adjournment.
Yes. Pending matter will come in seniority. If it has seniority, it will come in seniority. We are not fixing any date for pending matters. It will come in seniority.
Adjournments, list number 1, page number 6, serial number 28 to 33. Page number 7, serial number 34 to 36.
My lords, serial number 36, my lords. I am for the petitioner. My lords, my senior is not well, my lord. That's why I want to seek a short accommodation.
Not well, you can't oppose.
No, my lords, last date also they opposed it, my lord, but then there was some mediation, I mean, talk was going on. Yes, ma'am.
No settlement happened.
No. My lords.
It's submitted that the arguing counsel for the petitioner is unwell. Hence, as a last opportunity, released on 27th July. It is made clear that no further adjournment would be granted. The interim order earlier granted is extended till the next date only.
My lord, serial number 2, my lord.
Has it been called? Yes.
Page number 8, serial number 37 to 41.
Not 41.1.
41.1, my lord. 41.1. Respond number 2 for proxy, my lord. Respond to big gun shoot agide. Next date ಅಲ್ಲಿ
There is 41 connected matter ಇದೆ. ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಗೆ ಗನ್ ಶೂಟ್ ಆಗಿದೆ.
No, 41 has the council been informed. It is Mr. Sharath Doreraj.
ಇನ್ಫಾರ್ಮ್.
ಏನಾಗಿದೆ?
ಗನ್ ಶೂಟ್ ಆಗಿದೆ. ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 71 ಇವತ್ತು ಬಂದಿದೆ.
No. Mr. Mohan, who is the counsel of
NC
record,
Mohan.
is unwell. He's informed it to me. That is why I can't have him.
He used some word we could not understand.
No, what he's saying is serial number 71 listed before Lordship. He is the victim of a gunshot wound.
Gunshot.
Gunshot.
That matter.
Gunshot.
Sorry.
41. ನೀವು ಯಾರಿಗೆ? Mohan, respond number 2. 41. It is submitted to the arguing counsel for respond number 2 is unwell. ಯಾವಾಗ ಬರ್ತಾರೆ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಶಾರ್ಟ್ ಡೇಟ್
ಎಷ್ಟು ದಿನ ಆಗುತ್ತಪ್ಪ ಬರಕ್ಕೆ ಅವ್ರು ರಿಕವರಿ ಆಗಿ?
10 days.
10 days. Released on 5th August. Interim order earlier granted is extended till next date of hearing.
Page number 9, serial number 42 to 46. Page number 10, serial number 47 to 51. Page number 11, serial number 52. Page number 12, serial number 53. Page number 13.
53. 63 is 53. ಇನ್ನ ಕರ್ದಿಲ್ಲ.
13, serial number 54. Page number 14, serial number 55 and 56. Page number 15, serial number 57 to 61.
Serial number 59, my lord. 1 week adjournment, my lord. Senior is.
You are for whom?
I'm for petitioner, my lord.
Have you informed the respondents?
Yes, my lord.
59 at the request of counsel for the petitioner released on 11th August.
Interim order extension, my lord. Interim order extension.
Interim order earlier granted is extended.
Page number 16, serial number 62 and 63.
Serial number 63. I appear for petitioner. I'm a proxy counsel. On record, I object with an accident. I object for any accident.
You can't
But
oppose.
inquiry is held up. That is.
But if he's, madam, when we are dealing with one matter, you can't interrupt like that. Please wait till we finish this.
Not
63, it's submitted that the arguing counsel has been involved in an accident. When will he come back?
I don't know, my lords. I got this instruction now, so I came here. ಈಗ 5 ನಿಮಿಷದ ಮುಂಚೆ
Small minor accident, he could not reach in time.
I don't know, my lords. Then let him confirm that 2:30.
Confirm ಮಾಡಿ ಹೇಳಿ ಏನು ಅಂತ, ಯಾವಾಗ ಬರ್ತಾರೆ ಅಂತ. Yes, madam.
Case number 60.
60. You are Ms. Kevani. 60. Inform ಮಾಡಿ ಪೆಟಿಷನರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ಪೆಟಿಷನರ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? Have you informed the petitioner? Then no. Wait till it reaches.
Page number 17, serial number 64 to 70. Page number 18, serial number 71 to 74.
One submission memo for posting fresh matter.
ಏನು urgency?
RBI issued notice. RBI has issued a notice.
Notice reply. Regular course thought. Every fresh matter will come in 3 days' time. It's coming in 3 days' time.
List number 1, fresh matter, serial number 1.
Second list, your lordship, I had a submission. In second list, serial number 1, regarding that PDS removing of cards and all. Second list, first matter.
Yes.
Yeah, it seeks a short accommodation. They have not served the amended petition on me also.
They'll serve. They have to file a report. Let them file.
List number 1, serial number 1, Vijay Shekhar Gowda.
Vijay Shekhar Gowda.
I represent respondents. This petition become infectious now. There is an order for eviction under the Public Premises Act.
Possession has been taken.
Possession, my lord, it is already demolished. Entire structure has been demolished after the order passed by the.
None appears for the petitioner. Learned counsel for respondent would submit that the possession of the premises has been taken over and the property demolished. If none were to appear for the petitioner, the next date of hearing, petitioner would be liable to has been demolished, rendering the above petition infructuous. If none were to appear for the petitioner on the next date of hearing, the petitioner would be liable to dismiss for non-prosecution. Relist on 30th July.
Obliged.
Serial number 2, Bharatiyam.
Ms. Bharati.
For the petitioner, my lord.
Yes.
My lord, requesting for a short adjournment, my lord. I'm a proxy counsel for Bharati. She is currently unwell, my lord.
She is unwell. It's submitted that the arguing counsel is unwell. Relist on 11th August. Shri Gautam Dev Ullal is directed to accept notice for the respondent.
Published.
Serial number 3, Shivaji Yajmane.
In this matter,
Yes.
the proceedings have been initiated under the Pramamana, old act, where the petitioner is one of the director of one company called AGS, where they have availed a certain facility. Company has availed a certain facility from the bank and imported the software in the nature of a soft nature, madam, CD. But the CBI conducted an investigation on the basis of that. Whether the software comes or not is to be investigated, and thereafter investigation they filed a criminal complaint before the.
You bought a software for 18 crore 76 lakh 34,000.
It's a loan availed. After availing loan, madam, software has come, my lord. Software there, CBI is conducting alleging that it is a software is in the hard form, where the records are revealed before the trial court, which is a pending adjudication in the special CC 137/2014, where yet to be adjudicated whether software is not comes to the India or not. Unless until they comes to conclusion saying that the software comes or not, they cannot straight away adjudicate the matter in the civil proceedings like my lord under the FEMA old act, come to the conclusion that there is a violation of law without there being any form of investigation. Lordship,
A is only a complaint where you can file your objections.
no, no, my lord.
There is not an order passed.
No, order already been passed.
You are asking for stay of Annexure A.
Yes,
Annexure A is a complaint.
Oh, yes, Mala. Apart from that whole action of FEMA authority initiating action, because my lord, very self-same material, consequently after amendment, my lord, they have also initiated under the section 4 of a PML Act. Self-same material, enforcement directive.
They are entitled to because.
Yes, ma'am. I'm not coming in any. Till those authority has yet to be decided whether I am imported a software or not. Until unless the beyond reasonable doubt that I have imported a software or not, they cannot come to the wrong conclusion that there is a software without there being any inquiry.
That is why they have filed a complaint. You can go and give all your defense there for that person, that particular issue to be adjudicated.
That's what
you want us to adjudicate that as to whether you have been imported.
My question, may I go to the page number 13? What I have been contended before this honorable.
You have contended, but what they have initiated is page 37.
Please.
Complaint therefore submit that the above notice appears to have violated the provisions.
Order also came to be passed.
To be taken on record, notice be dealt with in accordance with law. That is what they have said.
No, my lord. Subsequently, they have also passed an order, my lord. Page number 65. They impose a penalty of 1 crore.
65.
Page number 65, my lord. Second paragraph. Petitioner is
order in which matter?
Operative portion of the order, my lord. Second para, my lord, is petitioner. Dhananjay Reddy so and so, violation of foreign exchange.
Annexure C is 2019.
Please, ma'am. 19.
The complaint was filed. When was the complaint filed?
Complaint came to be filed in the year 2017.
17.
17.
So you are challenging 2019 now.
Relief because why I am challenging these proceedings, my lord? Because there is based on these allegations, the same CKI and as well as ED authority has filed a complaint.
You are challenging at 2019. We can't grant you any interim.
My lords, we have not been served with the copy of the petition.
Obviously, we haven't issued notice. You want to be served before that. Who is going to appear now?
Anuparna Bordoloi.
Anuparna Bordoloi is directed to accept notice for respondent counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel. Released on 4th August.
I'm pleased, my lords.
Or a 2019 order in 2026.
Why I am making the reason that proceedings are pending before the court.
Mr. Counsel, you have waited 7 years to come before this court. You can wait for 14 days.
Okay, please.
I'm pleased, my lords.
Serial number 4, Rajendra Desai.
It is senior citizens case.
Yes.
Cancellation of a gift deed made.
Your petition has been dismissed.
They are not.
Learned AGA for respondent number 1 and 2. Issue notice to respondent number 3 and 4. Returnable by 24th August. The respondent 3 and 4 are restrained from any manner dealing with alienating, encumbering, or changing character of the subject property till the next date of hearing. Process fee and copies to be furnished by end of day 22nd July, failing which the interim order will stand automatically vacated.
Serial number 5, Ashok and Party.
This is the writ petition filed by the barred by limitation.
Barred by limitation.
Section 166 of
Barred
Motor
by
Vehicles
limitation.
Act.
Disposed. Yes.
Much obliged.
Serial number 6, Lakshmikant K.
Lakshmikant.
I am for the petitioner, my lord. This is the writ for mandamus, my lord, to consider the annexure H, my lord, at page number 57. My lord, earlier, it is a KPID Act, my lord. Earlier, there was a writ petition filed by
KPID.
Please, my lord.
Shri Viresh Budial is directed to accept notice for respondent, post the matter before a bench of which SGRJ is not a party.
Read from my
7, Sandesh Kumar.
I'm for the petition, my lord.
That's the bank has freezed the account, my lords, to the tone of 19,000 I have received from 5 transactions, my lords. But we have made a request before the bank, my lords, to for what reason it has been freezed. The bank has not furnished any details. Then they have shared one screenshot, my lords. It shows that, my lords, it has been seized. The reasons for seizing is, my lords,
Page.
MAACP ಅಂತ ಹೇಳಿದ್ದಾರೆ. Except that, my lords, no information has been provided, my lords.
MH Maharashtra ACP.
Even that has not been furnished the details about the case and all.
Cyber Command is trying to help out with all this.
23rd.
And AGA for respond number 1, RBL Yarama.
RBL.
Srividya Zirali.
Srividya Zirali for respond number 2. Approached the Cyber Command on Thursday 23rd, released on 13th August. You carry these papers, serve it on Ms. Srividya also, so that they can also carry what they've received.
This month,
time agate. To get information from outside, it takes some time.
Serial number 8. Samit, yes.
It's challenging the order passed by the SCST Commission, my lords, and it's an injunction order that they have passed at annexure K, page 89, my lords.
Page 89.
89.
Yes.
Now, my lords will see that on the basis of a complaint by my vendor's legal heirs, the order, the impugned order has come to be passed, my lords, stating that I should stop construction on the scheduled property. In fact, I'm not undertaking any construction. I'm clearing the property. It is a vacant site. Now, my lords, the commission does not have the power of a civil court to grant such orders. In fact, there is a judgment passed by the coordinate bench.
We are getting so many matters of this commission. They are getting involved in all civil matters. They are directing government to disforest and denotify forest land.
Your police protection is also given additionally, my lords.
And this is, where is Mr. AC Manjunath? He is not coming only. Please ask him to come. In his absence, then we'll have to pass some serious orders.
May I make one submission?
Yes.
Yesterday's matter, if it is taken up again, if the Lords pass a reported judgment is there, my Lord, then it will be a precedent for all the matters. That could be done.
We will pass that orders next week when it is there. We'll do that.
Please, ma'am.
But, virtually every day we are getting one matter now.
Please, ma'am. In fact, my Lord, I got information that, my Lord, the commissioner was asked to be present in other court, my Lord, because all the orders are passed without jurisdiction.
We don't want to ask the chairperson to be present, but he was asked to be present by another court.
Another
What happened?
that is coming up on 21st. I'll ascertain, my Lord, what happened.
Shri AC Manjunath is directed to accept notice for respond number 1, issue notice, emergent notice to respond number 2, returnable by 17th August. Counsel for the petitioner is also permitted to take out hand summons on respond number 2, as also serve the counsel for respond number 2, who had appeared before respond number 1. Considering that respond number 1 has virtually passed an order of injunction and a complaint filed by respond number 2, the further proceedings in case number 207 of 2026 at Annex K are stayed till the next date of hearing. So also is the order dated 11/6/26 passed in the said matter, stayed till the next date of hearing. Shri AC Manjunath is directed to file the affidavit of the member secretary of respond number 1, indicating as to how and on what basis respond number 1 has excised jurisdiction when there is no particular allegation which has been made as regard the violation of the Scheduled Caste and Scheduled Tribe Atrocities So-and-so Act. Process fee and copies to be furnished by end of day 22nd July, failing which the interim order will stand automatically vacated.
I'm grateful, my lords.
Serial number 9. Jaisimha KP.
For petitioner, my lordship.
Yes, please.
It's a writ of mandamus, my lordship. Consider the representation.
What is your representation?
Representation is a permission to sell fish products by the respondent number 3.
Karnataka State Cooperative Fish Marketing Federation, Yarama.
Yes, my lordship.
Who is the standing counsel? Who is the standing counsel for respondent number 3?
I don't know, my lordship.
Siddharth P. Desai.
You have to find out before you come.
Oh, like-
And AGA for respondent number 1, Shri Pawan Kumar for respondent number 2 and 4, Shri Siddharth Desai.
Yes.
For respondent number 3, counsel for the petitioner to furnish 2 sets of the petition along with annexures
My lordship.
on the said counsel relist
Humble
on
submission, my lordship. So this is say as fish products. So he is obtained the license from the
Don't
respondent
you want
number
us to issue notice to them?
3. My lordship, interim order, my lordship.
Yenanta interim order.
Interim order not to evict without due course of law.
His lease term is expired.
ನೀವು ಹೇಳಿದ್ದು to sell ಅಂತ.
Yes, my lordship.
On what basis do you claim to be in the property?
On the license basis, my lordship. You obtained the license.
Where is
and
the
BBMP
license?
also issued a joint.
Where is the license?
That is annexure.
See page 20.
See page number
20.
C.
C 20. my lordship.
16/1/2020. It expired in 2025.
Yes, my lordship.
How can you stay after the expiry?
So without due course of law, my lordship.
Here is expired.
So my petition is pending. My application is also pending, my lordship.
Sorry.
So they are not replied that.
Your license expired, it is for you to vacate. Without extension, you can't stay there.
My lordship, they are not replied, my lordship.
Learned counsel for the petitioner insists on an interim order being granted. The possession of the petitioner is only on the basis of a license which is already expired. Hence interim order stands rejected.
So the BBMP also issued a joint agreement. So that
And
is
you have
a
rejected your interim prayer. You can't be there. Next.
humble request.
Serial number 10. Girish R. General.
Petition this case, my lord. Chandra Perwa, my lord.
General
First time matter.
General parole. Lord AGA for respondent relist tomorrow.
Page 18 may kindly be seen. Again, they have sent a mail, my lord.
18.
Please.
Girish, you are doing this in every matter. We have, how much do we tell you?
Rectify, my lord.
Nothing, doesn't require. We'll reject it tomorrow.
11. Arvind N.
My lords, my bank account has been freezed, my lords. My lords, the reason is that, my lords, annexure B, page number 17, my lords. One unknown person has transferred amount of rupees 18,500 to my account, my lords, based on which the complaint was given. My lords, and I have also write a letter to the
Yeah.
cyber cell by way of representation,
AGA
my lords.
for respondent number 1, Kotak Mahindra,
Francis Xavier.
Francis Xavier. Notice to respond number 3 is deferred. Cyber command, 23rd you go to cyber command.
My lords, one request, my lords. My lords, in page number 20, I have also transferred to amount to that person. I have found out, my lords. My lords,
They'll
4
try
lakh
and
rupees
help you
amount
out.
is
We
there.
cannot decide this.
That's the interim order.
What interim order can we grant when there is a debit freeze?
My lords, that
You'll have to go
18,000.
to Bihar to get that order. So go to cyber command now. If you get that, it's good.
Date may be given.
Thursday hogi, 23rd.
Much of.
Serial number 12. Dashank Nagendra.
Yes.
Krishna, my lords. My lords. So we have filed a writ for mandamus, my lords, seeking for the direction of the court with regarding to the objection that has been raised by the passport authority, my lords. So in this
What is the objection raised?
my lords, produced as annexion number C, my lords, page number
Page number?
24, my lords. So wherein, my lords, so they state there is a crime number registered in your name. So for those reasons, you get a NOC from the concerned courts they have said, my lords.
Yes.
wherein, my lords, the said case has been stayed against me, my lords, a criminal petition, my lords.
Yes.
So, which has been produced as annexure number E, my lords, page number 31, my lords. So, wherein, my lords, the case has been stayed against me, like, my lords,
Yes.
with regarding to the crime what they have registered, my lords, and now the, my lords, my passport has been expired, my lords. So henceforth, I made an application before the authority to get it renewed, my lords. So wherein they have again asked me to get a concerned NOC where it is.
When you have to travel, get the permission, not for the renewal of the passport.
My lord, earlier round of writ petition, if my lord can see annexure F. Under
Annexure?
annexure F, page number 33.
Hmm.
The similar circumstances when that same petition was pending and the stay was granted. My lord, the passport was renewed for 1 year. The short-term passport was issued. Now, my lord, they're in absolutely similar circumstances this time around as well.
The same thing.
The passport has already expired. They have filed an application for the renewal. It is the circumstances.
You renew it for a short validity, but the travel will be subject to permission.
My lords.
And another 2 writ petitions also they have filed, my lord, where a LOC was issued. The LOC is still pending. But in that, my lord, they have filed affidavits. If my lord sees annexure G, there are orders passed by this court where they have filed an affidavit given the itinerary of their travel. Thereafterwards, the court has permitted them to travel on 2 occasions. Similar circumstances exist this time around as well. So, though they have not indicated specifically when they want to
We
travel.
are not seized of that matter to give them permission. We will only direct you to renew the passport, short validity for 1 year. Travel would be subject to the orders. 482 or in the criminal proceeding, they can
My
get
lords,
the permission.
the only submission is, my lords, in order to get a visa from the concerned from the country, my lords. So visa required 6 months of valid passport, my lords. So after the existence of these 6 months, which I get it now, my lords, after the 6 months, I can apply for the passport, wherein my the passport validity will be of 6 months only. So again, I am supposed to come to the court, get it permitted, my lords.
Yes.
So at least extend it for the 10 years, my lords, as at least for the longer duration, more than 1 year, my lords. That is
Only
why
1 year, you as soon as you get it, apply for your visa.
my lords, at
So
least
also accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following leaves. The petitioner was holding a passport which expired on 27/6/2026. An application having been made by the petitioner for renewal stroke reissue of the passport on 7/5/26 came to be rejected on the ground that there was a case in crime number 8 of 2017 registered against the petitioner, which was pending. And as such, proof of clearance of the case or travel permission from the concerned court was sought for. Learned counsel for the petitioner submit that the said proceedings have been stayed by this court in criminal petition number 2059 of 2024, while order dated 21/3/2024. And as such, the petitioner could not obtain permission from the trial court. Taking into account the peculiarity of the matter, where the court, the further proceedings in crime number in crime number
Annexure D, my lord. Page
8
26,
of 2017, which is now registered as CC number 26840 of 23 and pending on the file of the 17th Additional Chief Metropolitan Magistrate, Bengaluru, bracket Special Court for CBI cases. If an application were to be filed in the said matter, the said application is directed to be considered by the said court on merits. In view of the decision of the Honorable Apex Court in Mahesh Kumar Agarwal, where the Honorable Apex Court has categorically held that issuance of a passport cannot be withheld on the basis of any criminal proceedings which are pending, the respondents could not have withheld the same. However, the travel of the petitioner abroad would always be subject to obtaining permission from the court seized of the matter, which this court has here and above directed the court to consider such an application as and when filed. In that view of the matter, this court passes the following order. Writ petition is partly allowed. Respondents are directed to respond number 3 is directed to process the application of the petitioner for renewal of the passport, albeit for a short validity, and issue the same within a period of 15 days from date of receipt of a copy of this order. It's however made clear that the travel of the petitioner abroad would be subject to obtaining of permission from the court seized of the matter.
My lords, the only submission is, my lords, with regarding to the findings, my lords, there is a clear judgments wherein, my lords, it can be extended for the 10 years. So there is no repercussion on the part of the trial courts to get him like absolute right to travel at any time, my lords.
We are not doing that. Otherwise, they won't even know. Short validity passport is the one which puts them on.
After 2 years, because, my lords, after 6 months of validity only, I can apply for the
Look
visa,
at
my lords.
increasing the short validity from 1 year to 2 years. 1 year is
The purpose of me filing.
Short validity passport is valid for 1 year usually.
My lords, it's,
you need to probably look at 2 years.
My lords,
because as
the
he rightly
notifications-
says, just a moment, we are trying to tell you a story there. As he rightly says, we need a validity of 6 months of the passport for applying for the visa. By the time this whole process happens, if you change that thing, thereafter get your instruction in other matters.
We'll put this, I will suggest this to you.
2 years at least if you do, then they'll have that 1 year free time to travel.
I will suggest this.
This time you do 1 year, next time we'll see. Yes.
13, Narasimha Murthy.
Lordship, appearing on behalf of plaintiff petitioners.
Yes.
We're challenging the Annexure T, Lordship, order of passed by Assistant Conservator of Forest. This is actually the page number 84, Annexure T. This is a quorum non-judice.
Annexure page number?
84, ink page.
Yes. Yes.
Seventh respondent passed this order, respondent number 7. Lordship, kindly notice that's Karnataka Aranya Adhiniyama 1963, section 64A. Lordship, section 63A, only when the 63A Assistant Conservator of Forest pass an order, first the land must be considered as reserve forest in the first place. This is not reserve forest state. What they have is section 4 notification, which is passed in 1992. And that too, they have not provided us the section 4 notification, my lord. What they have provided us, initial notification of 1991. Based on that, they've shown us the number. Let's give them benefit of doubt. There is section gazette notification of 1992. Based on that 1992, but we don't have a copy yet. Probably they might be having it. We don't have a copy yet. Based on 1992 order, what his cited is, I draw your lordship attention to paragraph number 1. The same, it's unnumbered paragraph. Last line, second last line. Sarkari Rajya Patrada Nalakane Bhaga 42C Putta Sankhye 2418 ರಿಂದ 2422 ವರೆಗೆ ದಿನಾಂಕ 37/92 ಪ್ರಕಟಗೊಂಡಿರುತ್ತದೆ. This we have not seen this notification yet.
It's a gazette notification.
Yeah, it's a gazette notification, but they have not provided us. But even if this gazette notification is there, this is only section 4. Section 4 of Karnataka Forest Act very clearly said, decide to constitute certain land into reserve forest. It's only decide.
Then come to the next para.
Yes.
Section 17 notification has been issued on 29/3/23.
This is exactly is the question. This is section 17 ಅಡಿಯಲ್ಲಿ ಮೀಸಲು ಅರಣ್ಯ ಎಂದು ಅಂತಿಮ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. What he has cited is, here is respondent number 7. He cited section forest settlement officers Naduvali, that is the proceedings as section 17. Forest settlement officer cannot pass an order under section 17. Section 17 is only the gazette notification that has to be passed by only the government.
Where do they say it is the FSO?
FSO, it is, I'll take FSO's order, and page number 79, your lordship. Annexure, yes. Even in this order, your lordship, FSO, nowhere he has mentioned this is section 17. If you look at Karnataka Forest Act, it is very clear. Section 17, only the gazette notification that has to happen through only from the government, not
Yes.
FSO.
Yes.
FSO's position ends on section 12 itself. He publishes the report on.
Is there a gazette notification at 17?
My lord, copy is not served to us.
Copy is not served.
Please, my lord.
Why have you not served copy?
State of Karnataka, copy serve.
Government served the stamp as well.
GS served until illa. Serve a copy.
64A notice, my lord.
64A notice, but
Eviction order is already passed. They can make,
but he is raising a plea on jurisdiction.
let them serve the copy.
17 is not there, then you have no jurisdiction.
Please, my lord, let them serve the copy.
And AGA for respond number 1 to 12. And AGA is directed to obtain instruction and place on record the final notification which has been issued designating the under section 17 of the Karnataka Forest Act 1964, designating the above land as a reserve, the land of the petitioner as reserved forest. Relist on, when will you get it, madam?
A week's time may be given.
Then you should not take any action to dispossess.
Lordship, tomorrow that 30 days period ends.
My lord, my instructions.
Wait till the last moment to come and create
Lordship,
disaster.
there's one more thing. I'll
Except
just-
coffee plantation, my lord,
Lordship, I
nothing
draw
is
your
there.
lordship attention.
Get it tomorrow. Tomorrow.
Serial number 14. Venkateshappa.
ಸ್ವಾಮಿ ಪಿಟಿಷನರ್ ಲ್ಯಾಂಡ್ ಎಕೋ ಸೆನ್ಸಿಟಿವ್ ಝೋನ್ ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಬಿಟ್ಟು ಕ್ಲೋಸರ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೋಮ್ ಸ್ಟೇಗೆ. ಸೊ ಅವ್ರದ್ದು ಏನ್ ರೆಫರ್ ಮಾಡ್ತಾರಲ್ಲ ಆ ನೋಟಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಅನೆಕ್ಷರ್ ಬಿ ಪೇಜ್ 58 ಅಲ್ಲಿ ಈ ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ ಸರ್ವೆ ನಂಬರ್ ಇಲ್ಲ ಈ ವಿಲೇಜ್ ಅಲ್ಲಿ. ಚಿಕ್ಕಮುದ್ದೆ ವಿಲೇಜ್ ಸರ್ವೆ ನಂಬರ್ 48, 47, 46, 30, 29, 27.
Page number?
Page number 58.
58.
Annexure B.
Eco sensitive zone.
ಅಲ್ಲಿ
ನಿಮ್ಮ ಸರ್ವೆ ನಂಬರ್ ಏನು? ನಿಮ್ಮ ಸರ್ವೆ ನಂಬರ್ ಏನು?
ನಮ್ ಸರ್ವೆ ನಂಬರ್ 81/2 ಚಿಕ್ಕಮುದ್ದೆ ವಿಲೇಜ್.
ಚಿಕ್ಕಮುದ್ದೆ ವಿಲೇಜ್. ಎಸ್.
ಇದರಲ್ಲಿ ಬೌಂಡ್ರೀಸ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಿದೆ ಸರ್. ಚಿಕ್ಕಮುದ್ದೆ ವಿಲೇಜ್ ಸರ್ವೆ ನಂಬರ್ 48, 47, 46, 30, 29, 27, 35, 101, 80 ಅಷ್ಟೇ ಸರ್. ನಮ್ದು 81/2 5 ಕಿಲೋಮೀಟರ್ ಡಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಚಿಕ್ಕಮುದ್ದೆ ನಾಯಕನಹಳ್ಳಿ 81, 82, 81.
ನಮ್ ಚಿಕ್ಕಮುದ್ದೆ ವಿಲೇಜ್ ಅನೆಕ್ಷರ್ ಎ.
RTC ಅಲ್ಲಿ
ಅನೆಕ್ಷರ್ ಎ 49, page 49.
Yes, madam, it's Chikkmudde village.
Chikkmudde.
Lordships may kindly peruse page 78, my lord.
78.
That is the notice.
Yes. This is
Similar
again
mail
in
ಕಂಡು ವಿಷಯಕ್ಕೆ
81/2.
81/2
ಗ್ರಾಮದ ಸರ್ವೆ
ಕಂದಾಯ.
ನಂಬರ್ 81/2.
This one. More.
ಅವರು
CRG, sorry, eco sensitive zone ಅಲ್ಲಿ ಚಿಕ್ಕಮುದ್ದೆ 81 is not there. 47, 48, 47, 40, 30, 29, 27.
81, my lord.
ನಾಯಕನಹಳ್ಳಿ ಅಲ್ಲಿ ಇದೆ.
ನಾಯಕನಹಳ್ಳಿ 81.
ನಾಯಕನಹಳ್ಳಿ ಇದೆ, ಬಟ್ ಚಿಕ್ಕಮುದ್ದೆ ಅಲ್ಲಿ ಇಲ್ಲ. And their land is in Chikkmudde.
Up to survey number 80 is there, my lord, in Chikkmudde.
You come to page 58. 80 is there. 81 is not there.
Could it be passed on? Because it's only a notice.
Pass on.
Please, ma'am.
Serial number 15. Vivek Holla.
The freezing order, on an earlier occasion, your lordship had passed similar order, my lord, at page 19.
Page 19.
19. There they said, my lord, 4 lakhs had come into our account. Therefore, your lordship said, my lord, only to that extent.
Let's take the marking.
Correct.
Now, which is the bank?
My lord, the same bank, my lord. It's quoted
Again, why have you come again?
No, this is a different company.
Company is different.
Please come to my lord, page
So
17.
this company will have to find out how much money has come.
Correct. That's all right. There,
And AGA for respond number 1 and 2. Kotak Mahindra, Francis Xavier. For respond number 3. So this is in Karnataka only. Learned AGA is directed to secure instruction as to what is the lien which has been marked on the account of the petitioner. Learned counsel for respond number 3 is also directed to place on record the communication and or information received by respond number 3 from the concerned authorities as regard the debit freezing and or marking lien over the bank account of the petitioner, released on 24th July.
16, Manoj here.
Petitioner. Lord, police notice under section 35 class 3 has been issued, my lord, against me. Annexure A, page 13, my lord.
Yes.
This, my lord. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ನಿಮ್ಮ ಮೇಲಿನ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಿಮ್ಮನ್ನು ಕೂಲಂಕುಷವಾಗಿ ವಿಚಾರಣೆ ಮಾಡಿ ಮಾಹಿತಿ ಪಡೆದು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕಾಗಿದೆ. Lord, in the notice they have said, my lord, there is allegations against me.
Where the complaint? Where the complaint?
Complaint, my lord. Page number 25, my lord. 24, annexure C. In that, my lord, page number 25, my lord, the relevant facts. Shri Venkata Giriyappa bin Late Muniyappa Doddabanahಳ್ಳಿ ಗ್ರಾಮ ಸೋನ್ಸೋ ರವರು ಉಲ್ಲೇಖಿತ ನಕಲು ಅರ್ಜಿಯಲ್ಲಿ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದರಹಳ್ಳಿ ಸೋನ್ಸೋ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 31/3/1995 ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ 14,964 ರಂತೆ ಕೆಆರ್ ಪುರಂ ನೋಂದಣಿ ಉಪನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ನೋಂದಣಿಯಾಗಿರುವಂತೆ ಹೇಳಲಾದ ದಸ್ತಾವೇಜಿನ ನಕಲು ಪ್ರತಿಯನ್ನು ಒದಗಿಸಲು ಕೋರಿರುವ ಮೇರೆ ಬಗ್ಗೆ ಈ ಕಚೇರಿಯಲ್ಲಿ ಅಭಿಲೇಖಾಲಯದಲ್ಲಿ ಲಭ್ಯವಿರುವ ಸಂಪುಟವನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ದಿನಾಂಕ 31/3/1995 ದಸ್ತಾವೇಜು ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ನಕಲು ಮಾಡಿರುವ ಸಂಪುಟ ಸಂಖ್ಯೆ 1070 ಪುಟ ಸಂಖ್ಯೆ 41-44 ಕೃತ್ರಿಮವಾಗಿ ತಿದ್ದಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. My lord, in this case, my lord, the FIR only registered against the, my lord, accused persons who are already been dead, my lord. In that, my lord, what is my relevancy is, my lord.
You are now sitting on that property.
Yes, my lord.
So you don't have, it's a government property.
No, my lord. The alleged sailed in, my lord. What are
it's a government property. Your predecessors have changed the survey number to take over possession.
No, my lord.
Go give your
Muniyappa,
documents.
one Muniyappa, my lord. One Muniyappa, the accused number 2, is the original grantee, my lord. The land was granted to him by originally, my lord, the land was granted to one Marappa, who is the
His son Muniyappa became the owner. From the Muniyappa, you purchased the property.
Yes, my lord.
So your title is traced to a fraudulent document.
Yeah.
So you
My
have to go
father,
and
my
give the
lord.
documents.
I am the son of the accused number 1, my lord, who is Balakrishna.
Correct. It's a government property. 195 is this one. You have to go and give your explanation. If your explanation is satisfactory.
ಅಲ್ಲ 2-3 ಸರಿ ಆಲ್ರೆಡಿ ಹೋಗಿದೀವಿ ಸ್ವಾಮಿ. ನಮ್ಮ ಕಡೆ ಇರುವಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಾವು ಕೊಟ್ಟಿದೀವಿ. ಬಟ್ ಆದ್ರೆ their intention is to, my lord, implead me as an accused, because, my lord, in the notice also, my lord, nowhere in the complaint, no, my
That is a hypothetical presumption. The AGA accepts notice for respondent number 1 and 2. She seeks for and is granted 2 weeks' time to obtain instruction, make a submission as to whether the petitioners have submitted all the documents or not. Released on 5th August. If you have submitted, fine.
It's offense under Registration Act, my lord. Offense under
Yes,
Registration.
Offense and Registration
Yes,
Act and
please,
17.
Petitioner, my lord. The writ of mandamus has been filed, lordship. The FIR registered on 23/8/2024. FIR has page number 25, my lord. For the offense alleging forgery, impersonation, misuse of documents, wrongful receipt of benefits to vehicle. Even after nearly elapsed 2 years, lordship, they are not has been completed investigation.
Investigation is not
completed. I several times approached the police station. Even after
My-
Through ITA, I filed application and even I.
My instructions
the
are that, my
commissioner-
lord, investigation is completed, my lord, but they are waiting for FSL report.
My humble submission, your
ಒಂದು
kindly.
ನಿಮಿಷ ಇರ್ರಿ, ಅವ್ರು ಹೇಳೋವರೆಗೂ ಇರ್ರಿ. This one is not completed, that's all.
No.
Yes. Investigation is
It's
completed.
completed,
FSL
my lord, they are just waiting for FSL report. As
When
soon,
will you receive the FSL?
Lord, that I have asked them when they will get it, my lord. As soon as they
Give us
get,
a date. As soon as is. Oh, no use. Pass over.
pass over, my lord,
Get the
please.
details.
Please, my lord.
Serial number 18, Badri Vishal.
Yes. Third respondent, my lords, was offered employment at the petitioner institution as a senior general manager. Based on the offer, after giving the offer, my lords, he made some additional demands, which we did not accede to. Thereafter, he goes and files a complaint before the first and second respondents. And at annexure A, my lords, there's an order which is passed. Page, my lords, 25. Last para, my lords, they say, hence we direct you to revoke the offered position to so-and-so and take required steps towards the same and report the steps taken within 15 days of the letter received by. There's no notice issued by this authority to us. We have never put forth our case before them. He takes up a contention that before the authority that because he was disabled, we revoked the offer. But the revocation, my lords, is at annexure H at page 59.
So no notice has been issued.
No, my lords. Nothing.
Didn't it appear to be that they've so and so received?
That's all.
Revoke. See, these are all beneficial, this one. If it gets misused, it becomes a problem.
They should at least follow the principles of natural justice.
Wherever it is due, please give them the dues. And follow the procedure.
Yes.
And AG accepts notice for respond number 1 and 2, issue emergent notice to respond number 3. Written, now we'll state it is 1 month. Gone.
This happened in November, my lords. So November 2025
Order is
was the
passed
offer.
now.
Someone else has taken the place.
20 written up by 17th August. The operation of the direction issued by respond number 1 dated 7/7/26 at annexure A is stayed till the next date of hearing. Since ex specie, it appears that the petitioner had not been heard before the said order had been passed, thereby resulting in violation of the principle of natural justice. Process fee and copies to be furnished by end of day 22nd July, filing which the interim order will stand automatically vacated.
Great.
19, yes, Kalyan Basuraj.
Okay, for the petitioners, my lord. Petitioner number 1 is a minor child. In fact, my lords, there are a bunch of other writ petitions before this one, pending before this honorable court, where I've sought for a citizenship, my lords. If my lords may kindly see annexure A, my lords. This is an order passed by the Superior Court of California, where it actually restrains me from applying for citizenship, OCA or anything. My apprehension is that on the basis of this, they won't grant me any citizenship or passport. That is the reason I filed. In fact, my lords, I had made an application for seeking citizenship. And
you are a citizen of which country?
As of now, my lords, I am a citizen. The petitioner number 1 is a citizen of United States, my lords. Petitioner number 2 is the mother.
Have you given up that citizenship?
I have applied for citizenship here, which was rejected, and I have challenged us before this honorable court, my lords. That is pending before this honorable court. There's an interim order granted to me not to.
Where is the father? Father is in America.
Father lives in America.
That is why you want the citizenship to be changed.
My lords, there are allegations of sexual abuse by the father on the child, my lords.
Now all kinds of allegations are coming. Every allegation has lost its value. Earlier we used to at least believe. Now,
if my lords may kindly see annexure H, my lords.
If you want to fight amongst yourself, go on fighting between the spouses.
Let's
don't use the
there
children.
is no dispute as regards divorce agide. It's only the minor's custody, my lords. The minor is in India. There are GNWC proceedings which are going on in the family court in here. In fact, there's a no contact order which was granted by the courts in California also in the not to. If my lords may kindly see annexure H, my lords, this is the domestic violence order. Page 68, my lords.
Ms. Swamini Mohanambal accepts notice for respondent number 1 and 1 to 4. Indian Embassy in the USA, why do you want the embassy?
This is, my lords, because I was still when there was threat of deportation, I think, but then I have a protection, my lords. Maybe
Issue
called along with
notice.
4847 of 2025.
Notice, you have to issue notice to respond
Certainly.
number 6. Issue notice to respond number 6, returnable by 16th September. Has he appeared in that matter?
Yes, my lords.
He has appeared.
Yes, my
Then
lords.
Connect with
4847 of 2025.
4847 of 2025.
It's there on 11th of August, my lords.
Released on 11th August.
Lovely.
Serial number 20. Chandan, yes, and connected matters.
Therefore, petitioners counsel in this one. We were told they're filing their objections today.
Lordship, I pray for a short accommodation. I received certain documents, it needs to be looked into before taking a decision, Lordship. There are certain discrepancies in the documents produced by the petitioner in the memo that I want to point it out. Today morning I received it. In fact, there
The
are.
service is complete in all this matter?
I have filed my objections, Lordship.
20. You are appearing for respond number 3.
Please, Lordship.
The others is government. R1, 2 and 4. How many respondents are there?
My lords, one submission. We, SH Prashant, we are appearing for R3 in 20.1 and 20.4.
We are now at 20, madam. We'll come to that later. 20, let us see. Yeah, Rama.
And 20.4.
4 responses.
Registry is direct correct the appearance of Ms. Sumana Baliga as that appearing for respond number 3. In this, you have filed your objections.
No. The other matters are.
Other matter will come. In this one, you want to file?
Yes, Lordship. Yes, Lordship, I want to file.
When will you file it?
A week, Lordship.
When counsel for respond number 3 seeks fund is granted a week's time to file a statement of objections. 20.1. Ms. Sumana Baliga has entered appearance. Who will appear in this?
SH Prashant, my lords, 20.1
You
for
will appear.
R3, we are appearing and we have filed our objections for this.
Mr. S.H. Prashant has entered appearance for respond number 3 and filed a statement of objection. Registry is direct delete the name of Ms. Sumana Baliga as that appearing for respond number 3. Shri Chandan as Mallapur has entered appearance for the petitioner. Delete the name of Shri Pratik Rath as that appearing for the petitioner.
That's in 20.
These objections are filed. 20.2. You filed your objections, madam?
Yes, Lordship.
Chandan as Mallapur has entered Pratik Rath delete. Counsel for respond number 3. Submit that she has filed a statement of objections. 20.3, what is this statement of objections? What is office objections? Chandan as Mallapur has appeared. Benki Srinath Gurubasappa delete. They not complied with the office objection raised long ago on 8/1/25.
As I'm informed, they've made a council submission. One of the notice was issued in the name of the company as well as the managing director. An objection is raised why the managing director is not a party. We have said that it is only the company that needs to be a party and they have filed as a petitioner.
That is only one of them.
Please.
The other one is date of annexure, typed copy of the manuscript. Those are also there.
As I'm informed that the order typed copy is already filed, Manoj. It's already on record.
Counsel for the petitioner submits that the notice having been issued in the name of the managing director was actually to the company, and as said the company has filed the above petition. In that view of the matter, office objection at CL number 3 is overruled. Counsel for the petitioner submit that the other office objections have been complied with, registry to verify. Idrili, you filed your objections?
Yes, Lordship. Last one.
Ms. Sumana Baliga and counsel for respond number 3 submits and she has filed a statement of objection. registry to verify. 20.4 IA 1 of 25 is allowed. Who is going to appear in this?
My lords, we are appearing. For 20.4, we will file our objection.
You will file your objection. Mr. S.H. Prashant has entered appearance for respond number 3. Delete the name of Ms. Sumana Balika as that appearing for respond number 3. And counsel for respond number 3 seeks for and is granted a week's time to file a statement of objection. Relist on 5th August. Interim order earlier granted is extended till next date of hearing.
Deeply obliged.
21.
Here for the petitioner in this month. Arises out of an order passed in a section 34 petition. I challenge the award.
34 of the Arbitration Act.
Please. I filed an interim application for production of documents.
Yes.
As briefly stated, the dispute is in relation to a construction agreement over a villa. The dispute arises out of two issues. One is, I say, when I initiate the claim, I say it is not completed in time. And the second issue is that the square footage that has been constructed is less than what was promised to me. In the proceedings, an occupancy certificate is produced by the respondent saying the village panchayat has issued an occupancy certificate. The construction is completed. I deny this document. They do not lead evidence. That document is not marked into evidence. In the final award, the tribunal relies on that document to say construction has been completed on April 20, 2017. After having suffered the award, I make an RTI application before the village panchayat. I am informed that no such OC has been issued, no procedure has been followed. Their records do not reflect any such procedure. Thereafter, an inquiry is conducted by the panchayat. They decide that this is a fraudulent document and decide to initiate proceedings. I file an application in the 34 to say these documents have come into play after the award has been passed. They go to support my case under 34(2)(b) that the award is against public policy. These are fraudulent documents, could not have been produced by me before the tribunal, and are produced now to show the fraud that has been played on the tribunal. Now, there are two judgments on this point from this honorable court. One is of your lordship, which is under 34(2)(a). Under 34(2)(a) in 2019, the Arbitration Act was amended. To change the words, furnished proof was removed and replaced with the words established on the basis of the record before the tribunal.
Actually,
your lordships in this judgment have held that under 34(2)(a), the unamended act prior to 2019 applies if the award was given before 2019, and subsequently the unamended act which provided for furnished proof may not apply to subsequent petitions. A coordinate bench of this honorable court has held that under 34(2)(b), documents can be produced by the petitioner to support their case. And that is not affected at all by the amendment because there was no amendment under 34(2)(b). That judgment was subsequently upheld by the Honorable Supreme Court. All three of these judgments are produced before the trial court. The other two judgments are ignored, not even referred to in the judgment. And the court holds that since this is post-amendment, no documents can be produced. I'll take your lordships through those judgments.
Yes, please.
Lordship, may kindly turn first to the second judgment in my compilation, which is of the coordinate bench of this honorable court. The written submissions that I just handed over, starting at page 26. 26.
Ashok Dariwal.
Ashok Dariwal, please, Manoj.
This is the one which went to Supreme Court.
Please, Manoj, and was upheld.
Yes.
The facts are briefly stated and at page 28. Civil court has rejected the petitioner's application to adduce evidence, opining that the scope of review of the award dated so and so under 34 is confined to the grounds urged and the petitioner cannot be permitted to file frivolous applications. Your Lordship may then turn to page 32. Para 6. Shri so-and-so, the learned counsel for the first respondent, submits that the exposition in FISA developers will have to be seen in the light of subsequent decision in MK and the 2019 amendment to A of the Act are amended in the year 2019 to substitute the expression furnished proof with the expression established on the basis of record of the arbitral tribunal. This amendment is intended to limit the scope of judicial review under section 34 of the Act to only exceptional circumstances enumerated under 34(2)(a) of the Act on the basis of records. Therefore, even if the ground urged relates to 34(2)(b) of the Act, the applicant cannot have a right to produce additional evidence.
Is submission.
The submission is that the amendment would apply to 34(2)(b) also.
Yes.
Your Lordship may then turn to page 37. Sorry, at the bottom of page, 36 itself. After extracting the paragraph from FISA developers, the Honorable Court says, the Honorable Supreme Court, when section 34(2)(a) of the Act enabled furnishing of proof, has declared that routine procedures to permit an applicant under 34 to file an affidavit of his witnesses to place proof with a corresponding opportunity to the respondents to place their counter evidence, where the case so warrants. The court would also permit cross-examination of the persons who have sworn to affidavits and hear arguments to decide the matter. This would be the routine procedure, but the courts may, depending on the facts and circumstances of a particular case or the local rules, vary the procedure. This enunciation is because 34(2)(a) of the Act, as it stood prior to the amendment in 2019 by Act so-and-so, enabled an applicant to furnish proof of any of the grounds mentioned therein. As regards the grounds contemplated in 34(2)(b), the Act read that the courts may set aside the arbitral award if the court finds any one of the circumstances enumerated therein. With the amendment by Act 33 of 2019, the enabling expression of furnished proof is substituted with the expression establishes on the basis of record of the arbitral tribunal, but without any change in 34(2)(b). The question in the present proceeding, which is prior to the Act, would be whether the petitioner who has impugned the arbitral award under 32(b) should have an opportunity to file evidence by way of affidavit with liberty to the other side to cross-examine. This question is examined.
Amendment was carried out on what day? When did it come into effect?
30th August 2019.
30th August 2019. Yes.
Page 38. This question is examined in the light of the
Did your
decision.
arbitral proceedings commence?
The amended Act will apply to me squarely.
Amended Act. So it's after
There's
the
no-
amendment.
It is after.
Yes. There's no doubt on that.
Our submission is that the amendment only applies to 34(2)(a), and whatever the law was under 34(2)(b) remains unsettled. The question is examined in the light of the decision of the Honorable Supreme Court in both FISA Developers and MK Global, wherein the Supreme Court has exposited that in the proceedings under Section 34, the courts would not ordinarily require anything beyond the record that was before the arbitrator, and that the evidence and cross-examination of persons sworn to the affidavit should not be allowed unless absolutely necessary and exceptional circumstances are made out to justify the grant of opportunity. The Honorable Supreme Court has held as follows. However, this judgment must now be read in the light of the amendment to 34(5) and 6. So read, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such record and are relevant to the determination of issues arising under 34(2)(a), they may be brought to the notice of the court by way of affidavits. Cross-examination of persons swearing to the affidavit should not be allowed unless absolutely necessary, as the truth will emerge on a reading of the affidavits filed by both parties. Then your Lordship may turn to para 13 at page 40.
This was held in FISA or MK?
This is FISA minutes. Just double check that. I'll just clarify minutes.
And give us the para number also. Yes. This decision in MK.
But para 12 says this decision in MK is reiterated.
This must be MK.
It must be MK. It's para 13 at page 40.
Because FISA gave the, if you remember right, FISA gave a right to lead evidence in 34. That came to be restricted in MK to this extent. That only affidavit, no cross-examination. Yes.
The decisions in FISA and MK and Canara Nidhi and others do not make a distinction between the applications filed under 34(2)A or 2B. And of course, in all the decisions, the Honorable Supreme Court is engaged with proceedings prior to the amending act. The court in the present case must also opine that the application of the exposition, this was also sorry, I didn't read that. The court in the present case, which relates to a period prior to the Act 33, must also opine that the application of the exposition, that an application for setting aside will not ordinarily require, etc., cannot be excluded only because the ground urged by the petitioner could perhaps relate to a ground permissible under 34(2)B of the Act, and the provisions thereof do not contemplate furnishing of proof as in 34(A). If the civil court is to find out whether the impugned award is liable to be set aside on the ground that the contract is frustrated because of a legal requirement and therefore unsustainable under 34(2)B, all the necessary material will have to be available to the civil court. The petitioners did not, for that reason, will have to be examined by the civil court, contest the award, and certain endorsements are already permitted to be brought on record to buttress their contention that there cannot be a composite development of the property because of the requirement of a buffer on either side of the Nala. Para 16, in light of the above, this court is of the opinion that there must be interference by this court with the impugned order, but this court must also issue directions for expeditious disposal. Petition is allowed. Therefore, my reading of this judgment is that even though the words furnish proof were never there in 34(2)B, in order to determine whether a ground is made out under 34(2)B, the court is empowered to take fresh documents. Therefore, the distinction that has now crept into 34(2)A of prior to amendment and post amendment
will not apply to
34(2).
There is no amendment.
There is no amendment.
Yes.
And the power to take fresh documents is already read into the statute without that. Then your lordship may kindly turn to your lordship's judgment, which is the last one in this compilation, page 57 onwards.
Yes.
The Supreme Court judgment of
Mr. Nishant cannot have any objection to this. Yes.
I'm relying on law that he has espoused.
Yes.
The Supreme Court judgment also is the first judgment I produced. I'll take your lordships back to that. Your lordships have referred to it in this judgment.
Alpine.
Yes.
It's 63 of that compilation.
At the bottom of 62, para 10 onwards, your lordships have extracted Alpine. Then your lordships may turn to paragraph 20. 19. The essential difference is in clause A, where the words furnishes proof that was substituted by the words establishes on the basis of record of the arbitral tribunal that. This substitution has been interpreted by the coordinate bench of this court by holding that in proceedings filed under section 34 prior to the amendment, applicant could furnish proof of any particular aspect which would satisfy the requirement of 34(2)A. Thus, in view of 34(2)A as it stood prior to the amendment, provided an opportunity to the applicant to, in a section 34 proceedings, to furnish proof of any particular aspect which would, in my considered opinion, go beyond what is available on the records. Then para 24. Somewhat similar facts in that case, though the petitioner had produced a ledger extract with a journal entry Arbitrator came to a conclusion there is no independent document which has been produced to establish such a direction or observation by the CAG and rejected this contention. Perusal of the award and cross-examination would indicate that at no point of time was the petitioner put to notice as regards the production of the said report, even though R26 relating to ledger entry and journal entry had been accepted by claimant witness number 2 in his cross-examination. Such being the case, the petitioner under the bona fide belief that the journal entries made also the balance sheet produced, where a chartered accountant had certified that withholding was an account of report of CAG would be sufficient and not produce the report. There is some substance in the submission made by the learned counsel for the petitioner. In this regard, the petitioner having produced the balance sheet, the document now which is sought to be produced would indicate a specific reference at item 10. Thus, in my considered opinion, this aspect would have to be considered in detail while dealing with the section 34. The parallel that I would draw to this particular case, my lords, is that when the respondent themselves have not led evidence, have not marked that document, and I have denied the document, the tribunal could not have relied upon it.
It's an unmarked document.
It's an unmarked document. Their witness has not entered the box. They have not. Nobody has spoken about
But
this
that document or has not entered the
has
box
not entered
at
the
all.
box at all. Now, this document, as I said, there were two facts that we were at dispute on. One was whether the property had been constructed completely or not. The other was whether there was a shortfall of 409 square feet. In this document, which I denied, I pointed out in final arguments that even as per their document, it is 409 square feet less. Therefore, that admission I relied upon without prejudice to my contentions. The tribunal has taken that to say I have admitted that document in my arguments and has proceeded on that basis.
Where is the para?
Your Lordship may take the award. Page 316, minutes.
316.
Sorry. It's 306.
Non-volume media.
306, the award starts. It might be, did you find? I think there were 2 volumes.
There are 2 volumes. 306.
306.
Relevant portion.
The issues are set out in page 311. Issue number 6, whether the claimant proves that there was delay of construction, and if so, whether claimant is entitled for 36 lakhs as damages. Para 12, claimant has got himself examined as PW1, exhibited several documents to substantiate his claim. On the other hand, respondent has not led any evidence.
Yes.
The learned counsel for respondent on 9-3 has filed a memo where he has stated in light of there being no issues cast upon him to prove, he would not be leading evidence. On the other hand, he would rely upon admitted documents produced by the parties as a stage of evidence. Arguments. Then para 13, learned counsel for the respondent had no objection for the claimant's documents being exhibited, whereas learned counsel for the claimant has made a submission that except 3 documents, he has no objection for the other documents being admitted in evidence. In other words, he does not dispute that the documents filed with respondents along with the statement of objections, except annexures 4, 12, and 13. These documents are annexures 4, 12, and 13. R13 is this OC, which I have rejected, which I have denied. R13, which is mentioned here as not admitted by me, is the occupancy certificate, which I say is fraudulent. Then issue 3 starts at page 314. Sorry, I didn't read that out. I'll just read it without taking the code back. Whether the claimant proves that completion of Schedule B was delayed by the respondent in violation of the agreement. Issue number 3, burden of proving which is on the claimant.
Yes. All the issues are on you only.
All the issues are on me, clearly. Then the portion at which the tribunal relies on that R13, your lordship will take page 316. As far as the first citation, your lordship has about 5 lines down. The learned counsel, though, relies upon this judgment for the proposition that unexhibited documents cannot be looked into unless it is marked as an exhibit, but not only relies upon R13, not admitted by the claimant, he gives a go-by to his submission that he has no objection for other documents except R4, 12, and 13, thereby admitting all other documents. Otherwise, the claimant could have said that the annexures of the respondent are not admitted by him. Thus, it is clear that all that admitted facts need not be proved, and though are not marked as exhibits in the peculiar facts of this case, where it is not disputed, there is no hurdle in these documents being relied upon. The claimant cannot blow hot and cold at the same time because he wants to rely upon one document at 13, which he himself has not admitted for the purpose of establishing the area, found in shortage, and for the proposition that the villa became complete for occupation only when the occupancy certificate was issued, which is at R13, is not admitted but relied upon to show that even completion certificate indicates shortage in the built-up area and also showing completion. Thus, it is not made out by the claimant that the completion was delayed by the respondent in violation of the terms of the agreement, as by the time Annexure R13 was obtained, the construction had been completed, and this time is well within 42 months.
Yes.
Then once again, then your lordship may kindly see my application. Page 50, my lords.
50 of
50 of the first volume.
Yes.
For reasons stated in the accompanying memorandum of facts, petitioner humbly seeks to place on record two documents. Document 1, true copy of the RTI application dated 9th December so-and-so, and subsequent reply, which states that the Aneshwaram Gram Panchayat does not have the occupancy certificate issued by respondent number 1 in its records. Document number 2, true copy of the RTI application filed by the petitioner with the Panchayat Raj Commissioner and dated so-and-so, and the subsequent reply along with a translated copy. Reply includes the inspection report of the Executive Officer, Taluk Panchayat. According to the report, the document submitted by the respondent alleged to be an official occupancy certificate for Villa 127 in the house of so-and-so undertaken by respondent number 1 was not found to be officially issued in the records of the Gram Panchayat as per reference number and date mentioned in the said document. Additionally, reports stated that the issuance of the document purported to be official occupancy certificate did not adhere to the necessary regulations and lacked the required documentation for issuance of an occupancy certificate. Consequently, as of 15 May 2023, no occupancy certificate has been issued.
Yes.
In para 4, I have stated that the arbitrator has relied on this false and fraudulent document produced by them and set out why it is necessary for me to show that it is a fraudulent document. The impugned order, your lordship will find at page 39.
Establishes on the basis of record.
Please.
Yes.
Paragraph 9 at page 43. At the bottom of 43, during the course of proceedings of the petition, the present application has been filed by the petitioner seeking leave of the court to produce two documents, that is, true copy of so-and-so, so-and-so. According to the petitioner, these two documents have not been obtained and produced by him before the arbitrator while passing the order. Now the said documents are very crucial to decide this dispute, and as such he intends to produce the same. On the other hand, the respondent has specifically contended petitioner is neither the author of the said document nor the recipient of the same. Petitioner has not stated the existence of the said document in the petition and cannot be permitted to produce it at this stage. These are the only grounds on which it is objected. Obviously, an RTI application and the response with documents from the government I will not be a party to.
Yes.
Then the Honorable Court looks into Lakshmi Nirman judgment, your lordship's judgment, looks at 34(2)(a) of the Act as it stood prior to the amendment. Then para 13 talks about the essential difference in the amendment. Para 14, this substitution has been interpreted by the bench. All of this has been extracted from your lordship's judgment.
This is actually the extract. 12, 13,
That's
14
right.
are extract.
Please. Then para 16, at the bottom of 47, the above said principles laid down in the said decision is aptly applicable to the case at
15
hand.
is also extract.
Please.
Only 16 is the reason.
Please. Does not permit the petitioner to produce any other document other than what is already available. Does not consider 34(2)(b. Admittedly, both sides produced the Alpine judgments and relied upon them.
Thirty-four two B, what do you want to use in 34(2)(b)?
My lords?
What do you want to use in 34(2)(b)?
Both those grounds, my lords. The court finds that the subject matter of the dispute is, that the arbitral award is in conflict with public policy of India. Explanation 1, for the avoidance of any doubt, it is clarified that an award is in conflict with public policy of India only if the making of the award was induced or affected by fraud or corruption was in violation of Section 75. It is in contravention of the fundamental policy of Indian law. It is in conflict with the most basic notions of morality or justice. A document which is produced by the before a tribunal and relied upon is a forged document purporting to be one issued by a public authority in the country. It would fall under explanation 1 and 3. In fact, in 2 also.
Yes.
While we may have disputes before a tribunal, perjury and production of forged documents would certainly fall under all 3 of these clauses.
Yes. List of dates filed along with? You filed your written submission. When did you file that? 6/7/26. Yes. Yes.
In this case, we have filed a statement of defense on 18/2/2020, third date. On the said date, we have produced the occupancy. That is annexure R30 use.
Yes.
This document was relied upon by the AMC. The arbitral award minutes going to be passed on 12/10/2021. After the arbitral award minutes, between 18/2/2020 and 9/12/2021, they kept quiet. Subsequently, they made an application, which they could have done in that particular period.
Yes.
Then in February 2022, the document is issued saying that they are not forthcoming in the original. Then on 23/8/2022, they challenged the arbitral award. We also challenged the arbitral award. They also challenged the arbitral. Therefore, my first submission they were very well aware of the document way back in the year on 18/2/2020. They kept quiet and they filed the application under the RTI post.
Yes.
They could have showed more diligence.
Diligence won't help you if it's a fraud. The fabricated document. How will their diligence help you if you produce They rely upon it only to say that even in respect of that document, the measurement is so and so. That's all. They have denied that document.
May I request my lord to kindly see issue number 4 and 5 in the article, page 317. Issue number 4 and 5 is allowed relying upon this document.
Yes.
Page 317, issue number 4 and 5. These issues are again to be proved by the same. a sum of rupees so and so is to be reduced from the demand and consequential interest thereon. The claimant relies upon the premature demand in violation of the terms of contract. Issue number 2 is already held in favor of the accused. Therefore, naturally, the claimant is entitled for interest on payment on the payment made even before it became due to and the interest as already stated has been calculated at 18% per annum totaling so and so, as stated in para 21 of the case statement. He is entitled. The remaining amount is for reduced areas, which is the subject matter of issue number 5. Issue number 5 is raised because there is a shortage of 490 square feet in the built-up area from out of the sales consideration. Here, rupees so and so is the amount calculated for the reduced area. The claimant has stated that on observation of the villa and on measurement, it was found there was shortage of 490 square feet in the built-up area. The claimant, though in his cross-examination, is unable to make out when the measurements were made convincingly. Nevertheless, it is found this brought to the notice of the respondent to exhibit B30, for which there is no response. But significant factor is that the occupancy certificate, annexure R13 dated 7/4/2017, issued by the respondent for Villa 127, Schedule B property comprising of ground and first floor. The net built-up area is 398.67 square meters, which approximately comes to 4,291.24 square feet. This conclusively establishes the case of the claimant. Though the agreed built-up area is 4,770 square feet, it is actually 4,291.24 square feet and shortage of 478.76, which may be rounded off to 479 square feet. Is to be made good. Further, the calculation is on the basis of the price in exhibit P6 and P7. The total consideration of the two agreements should be rupees 1. Therefore, this has to be reduced by the respondent. Hence, issue 4 to the issue are therefore to be payment to the extension. Relying upon this document, majority be granted their plea.
It's been granted because you have produced the document. Your production of a document can be held against you. Your production of document cannot be held against them who have denied that document. If you had produced a document saying 1,000 square feet is less, it would have been held 1,000 square feet less. If you produce 1 square feet less, 1 square feet. It's because you have produced, you are admitting that document. They are not admitting that document.
Even in the section 34 petition, there is no plea of fraud.
The question is this document a genuine document or not? It should have to be looked into by the section 34 court.
The application is not by an affidavit. There is no plea of fraud also by the petitioner. Nor of the memorandum of facts.
If that document is a fabricated document, it's a fabricated document, Nishant. You can't rely on it at all. It goes to the root of arbitration. The restrictive reasons for interference cannot be done away with by producing a fraudulent document.
They don't say that this document is the only response given by me under the RTA member. In the files, these documents are not there.
So that would have to be considered until you produce something else. You will also be at liberty to produce something to establish that.
If that it's already a fraudulent document, then
If you have not produced, then it's a fraudulent document only when they have issued that endorsement. That endorsement clearly says so, unless you say something else.
can you see the endorsement?
Hmm.
That is at page 62.
Yes.
61 is 62 is the endorsement which is given in fact along with the application. The last two lines, ಈ ಮೇಲ್ಕಂಡ ಮಾಹಿತಿಗಳ ಬಗ್ಗೆ ಕಡತಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕಡತಗಳಲ್ಲಿ ನಾವು
Page? Which page are you looking at? 62 alillappa.
I'm sorry, of the petition papers.
Adralilla. 60 starts with Annexure B. 62 is the 61 and 62 is the application. 62 is the document number 2. Where is the document? You want to refer to document number 1 or document number 2?
Document
That is at page 68. Third page
This
is
is by Aneshwar.
Aneshwar Gram Panchayati Karyalaya.
This is dated 14/2/20.
Yes.
The last two lines.
Hmm.
This is an endorsement which is issued.
Hmm.
ಈ ಲೇಖನ ಮಾಹಿತಿಗಳ ಬಗ್ಗೆ ಕಡತಗಳನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಡತಗಳಲ್ಲಿ ತಾವು ಕೋರಿರುವ ಮಾಹಿತಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಿದ್ದಾರೆ.
Hmm.
They don't say methods, they say it's not available in the records.
ಅವರೆಲ್ಲ ಅದೇ ಹೇಳೋದು ಲಭ್ಯವಿಲ್ಲ ಶಿಥಿಲಪಟ್ಟಿದೆ ಅಷ್ಟೇ. We have not issued ಅಂತ ಯಾರು ಹೇಳಲ್ಲ. That's how they respond. If there's a document, then it should have been available on the file. OC especially. Yes, anything else? Heard Shri Pradeep Naik, learned counsel for the petitioner, Shri A.V. Nishant, learned counsel for respondent number 1, reserved.
Serial number 22.
Interim order earlier granted is extended.
Interim order.
22. Yes, Mujassim.
I take finance from the they signed me no but they deposit into wrong account of the showroom person. And after that, they are proceeding against me for NPM and apart from that, NI proceedings.
Your Lordship, we have already filed an OA before DRT2. They have been placed ex parte. They are very well aware about it. Their contentions, they can take.
There is first I have paid the cash to the claim chief for the increase the vehicle. The contact bank transfers money to NPA account of the Alphagen Malot. Though I have given instructions to deposit in Bank of India Malot. They deposit in Canara Bank which was the NPA account Malot. They have clearly admitted at page number 24, 26 Malot.
Yes, but we should give them a time to file objection. We'll give them a week.
2 weeks, 2 weeks, Your
We'll give you only 1 week's time, madam. You have the 2025 meter. You have.
Respondent number 6, my lordship.
You want to file it in 1 week, please file it. Otherwise, it will be taken as not filed.
2 weeks, Your Lordship. There's few documents that we need to yet to receive. That's the only reason.
Then we'll give you 2 days time.
I leave it.
You have been sitting on this for last 1 year.
I leave it to this.
Learned counsel for respond number 3 to 5 seeks for 2 weeks time. Or considering that service on respond number 3 to 5 has been effected long ago, no such indulgence can be extended.
Lordship, respondent number 6, I am hearing.
When the contention of the petitioner is that in pursuance of the rejection of the application by the ombudsman, respondents are proceeding for recovery. Hence, 1 week's time is finally granted to the respondent to file a statement of objection. If the statement of objection is not filed by 29th, it will be taken as not filed and matter proceeded with, relist on 31st July.
Lordship, respondent number 6, I am not served with the petition copy, my lordship. In this
Respond number 6.
Yes, there is no specific prayer against me as I am seeing from the web website.
Respond number 6 is who?
Canara Bank, my lordship.
You have filed anything against them? Serve a copy on him.
Already
Why?
some Malot, police only come Malot. It will come to police, all that. All respondents were served.
Yes, you have been served through the police. How can your client must be having a copy?
I will verify, my lordship. I have recently got this color. I will verify.
Give the copy, Malot.
Give one more copy.
I will give.
Your seal is there.
Yeah, no issues, Malot. Give the copy.
Give him a copy. You were to be served through the police because you did not accept it.
Malot, what happened, Malot, in this matter, Malot, we went, hand summons was given. The Kalpyan Motors, they had restrained us from going out, they had taken all the documents, we went to police station. Then again, when we mentioned this honorable court directed.
What What is this for service if you do these kind of things? List on 31st. Yes.
Serial number 23, Bharat Kumar V.
Chandrasekhar.
Chandrasekhar was supposed to place some information.
There are PV Chandrasekhar.
Yeah, PV Chandrasekhar.
ಅಲ್ಲ ವಿಡಿಯೋ ಅಲ್ಲಿದೆ ಬಿಸಿಯಲ್ಲಿ ಪಾಸು
Please.
ಯು ಆರ್ ರೆಡಿ
Please. On last question, they had missed the matter. That is why, that's what time.
He must be in another court.
Please.
24,
This case on petitioner,
Petitioner.
last occasion, the government advocate instructed to take adjournment to take instructions. My lord. I am challenging the annexure A, page 11, my lord.
Place the details on which basis Annexure A was issued.
Page 11, my lord.
Kindly pass over. My colleague has taken it.
Pass over.
Because 27th is become infractious.
Pass over.
55. And then I.
Appearing on behalf of S. Balakrishnan, my lords. My
What is
lords,
this impleading application?
my lords, we are appearing on behalf of Mr. Jayant, against whom serious allegations have been made in this case, my lords. The IA number 2, we have served the copies to the state. The petitioner is not served the copy. We'll do the needful in a couple of days, my lords.
What is
My lords, I
You have to
appear in
understand the
IA
question
number 1.
first and then answer. What is IA 1 of 26? Who has
Please,
filed?
my lords. My lords, I appear in IA 1.
Yes.
Please, my lords.
Who
My
is the
lords,
impleading applicant?
The impleading
Who wants to be
applicant is a senior citizen. She's a social worker. Her name is Rama Nagraj. This matter deals with the various concerns that have been raised over now a period of time since last year regarding the recovery of bodies in Dharmasthala. The writ petitioner has made multiple U-turns, multiple complaints. My lords, I am not mentioned in any of his complaints earlier. Now in this writ petition, my lords may straight away take para 30 at page 24 of the writ petition. May I read, my lords?
This application has been filed by you, madam, this IA 1 of 26.
Please, my lords.
Have you filed objections to that application?
Yes, my lord. I will file, my lord. Pray for time for file a objection, my lord.
And what is this other IA 2 for another impleading
But 2 is filed by us, my lords.
filed by?
Mr. Jayant, we are representing Mr. Jayant.
It is filed by you.
Yes.
We don't know who your client is. We don't want to know. Who is the counsel is what we need.
We have filed the IA number 2.
You have filed that.
Let's see
And
one
what is
IA.
the office objection on IA 2?
IA 2, it is not served on the petitioner, but we have served it on the state.
You
So
received
we'll
a copy?
serve it on the petitioner.
No, my lord.
Petitioner
Not
will
received the
serve.
copy.
Let's kindly give us 2 days time, we will serve it.
Have you served IA 2 on the petitioner, madam?
No, petitioner we have not served, state we have served, my lords.
Answer.
My lords, we have served.
If he says something, you will not like it.
I'm sorry. We'll do the needful
you
in
have to
in
serve?
couple of days.
One submission. May make one submission, my lord.
Yes.
I am appearing for R3.
R3.
Yes, my lord.
Who is
The
R3?
SIT, my lord.
SIT, yes.
Yes, my lord.
Hmm.
Now the prayer, my lord, is to complete the investigation.
Hmm.
There is no other prayer.
Take action and
Now the-
so on, so. Complete the
Yes,
investigation.
yes, madam.
Yes.
So we have completed investigation, filed a report in November 2025 itself.
Hmm.
Additionally, FSL report which was required to be filed, we have also filed that. Therefore, nothing survives in this petition. It need not be pending here, my lord. Let them agree by the report, my lord. Let them challenge that report if whoever wants to challenge it.
Yes.
My lords, may I just make one submission?
Yes, madam.
Please, my lords. My lords, I am not aggrieved by the report in any way. What I'm pointing out to the court, if I may just be allowed to read para 30, can the process of the law
Para
be
30 of
used
the
to
petition.
of the writ petition, my lords? May have para 30, page 24.
Hmm.
The petitioner submits that he informed the chairman of SIT about the alleged conspiracy orchestrated by the aforesaid persons. I'm not amongst the aforesaid persons. Reposing trust and confidence in the officers of the SIT, the petitioner disclosed all relevant facts before them. At this point of time, it is relevant to state that out of curiosity, the petitioner asked so and so and so and so about their source of income to conduct this frivolous litigation. It is further submitted that initially they were reluctant to discuss
about the same, and even they did not inform the sources. However, later on, when they realized that the petitioner would give statement against Shri Kshetra Dharmasthala, Dr. Hegde and his family members, they disclosed that they are receiving funds from Kerala and their major source of income is from one Shrimati Rama Nagraj from Chitradurga. Subsequently, the petitioner came to know that so-and-so and so-and-so are in regular contact with the said Rama Nagraj. And she
Why
used
are
to
you
send
giving out
funds.
those two names but reading out all the other names?
No, I can read both. I can read both. I have no difficulty. It's on
First
record.
time we thought
Know
it
that-
was okay. Second time also you missed out.
No, only for sake of brevity, my lords, for nothing. I'm sorry if it communicated something else. Petitioner
Yes,
came to know that Girish Matanavar and Mahesh Shetty Thimarodi are in regular contact with the said Shrimati Rama Nagraj, and she used to send funds to them so as to bring disturbance to the sanctity of Shri Kshetra Dharmasthala. This kind of completely strange allegation is made. I am supposed to be some financer, no material particulars. This man from 3rd July 25 makes a statement, lodges an FIR, says a set of facts. The SIT is set into motion on 19th July. He does a U-turn and say, no, there are a bunch of people amongst whom he names these two, Girish and Mahesh. Then he does one U-turn and another set of investigation. The SIT arrests him. He secures bail from the Sessions Court by saying, I stand by my original statement. Alongside, he's giving 183, the 164 statements to court. None of this. His last complaint to the 8 is on 18/12/2025. I am never named. There is no whisper. Now, I come in this suddenly in this writ petition, and who am I? I am a social worker. My life's campaign has been against the very exorbitant interests that are being charged by the Shri Kshetra Dharmasthala Rural Development Project, which charges usurious interest, which they have called the meter interest colloquially. And pursuant to my work and others, the state has taken acknowledgement of these practices. The state has passed an ordinance. There is an order of the Director General of Police to look into all such exorbitant interest. Now I am being targeted in this manner so that I do not continue my work. Can the legal process be used in order to both malign me as a person?
In this petition by impleading you, even if we were to implead you, what
Please,
can we
my
do in
lords.
this petition insofar as a respondent, what are the reliefs that you can claim in a writ petition?
My lords, I would only
If you
want to place
want
my
to file
objections
any
on record.
proceedings, if you want to file any proceedings, you can file the proceedings against the petitioner. Now that the investigating report, final report has been filed, you can lead your evidence if permissible, which is not.
My
What
lords,
do we do in
presently,
this writ petition?
my lords,
Even if
I am,
bringing you on record.
my lords, I am simply saying that can the legal process become a way in which this sounds like some kind of not only reputational damage, but it's sounding now like an extortion racket. I don't know what he's doing.
And, we
Why
can
is he
advise
making
you.
my name after over a year? Suddenly I am in the picture.
We are not in the
My lords,
advisory
I would like,
jurisdiction, we
I'm
are in
sorry.
the adjudicatory jurisdiction. You know what is to be done. Please do that. And there it will be considered. In this
My lords,
matter, it
if in
cannot
this
be
manner,
considered.
if in this manner people who are engaged in public service find their names maligned, and then there are others' interests that are getting served.
Madam, we are not
No,
saying this way or we are not saying that way, but in
I'm
this
grateful.
petition it cannot be done. You'll have to do it in the appropriate proceedings, whatever you choose fit. Now that the report has
originally
been
writ petition
filed,
prayer has become
nothing
infectious.
survives in this petition. The report will be taken on record and proceeded with.
Yes.
Lords, in fact, my lords, I have instructions to my lords file impleading application insofar
Who
as
are you for now?
temple, my lords, Kshetra Dharmasthala temple.
required.
Now, since my lords final report is filed, I have my lords
Nothing is
advised let them not to file, my lords.
Petitioner is before this court seeking for the following reliefs.
Withdraw ಮಾಡ್ಕೊಳ್ಳಿ, since filed.
IA 1 of 26 has been filed by a person against whom allegations have been made in para 30 of the writ petition.
IA1 and 2 both, my lords.
IA1 and 2 have been filed. The submission of Ms. Vrinda Grover, learned counsel for the impleading applicant in IA1 of 26, is that there being false allegations which have been made against the impleading applicant, necessary action is to be taken. If at all the impleading applicant is aggrieved by any false statement made in the writ petition or otherwise, it would always be available for the impleading applicant in IA1 of 26 as also in IA2 of 26 to initiate such proceedings as may be advisable and permissible under law. It is made clear that this court has not expressed any opinion on the allegations made in the petition. Learned SPP would submit that a final report has been submitted on
November itself, November last year itself.
Last year?
Yes, my lord. And then additional FSL report which was required to be filed, we have also filed that
November 25, and FSL report has been submitted on
this month.
15/7.
Date code
15/7
to November.
15/7.
FSL report has been submitted on 15/7/26. In that view of the matter, it submits that the reliefs which have been sought for have been rendered infructuous. The reliefs which have been sought for have been extracted above. And what has been essentially sought for is a mandamus directing the completion of the investigation. The petition having been filed on 8 June 26.
Lords. Initially, my lords, they have filed preliminary inquiry report. That is what
Final
is
report when did
final report 15/7. They have 15/7, my lord.
Preliminary report was filed in November 25. Final report along with the FSL report was filed on 15/7. The above petition having been filed prior to the final filing of the final report on 8 June 26. The final report having been filed on 15/7/26. The prayers which have been sought for in the petition stand infructuous. Placing the said submission of learned SPP on record, petition stands disposed.
One clarification. In fact, according to us, my lord, we filed a final report in November 2025 itself. The forensic report which required to be filed, that was filed now.
Learned learned SPP submit that according to the state, the final report had been submitted in November 2025 itself.
The
What
forensic
was only pending was the filing of the FSL report. His submission is that the FSL report was filed on 15/7/2026. Thus, the entirety of filing the final report is completed, rendering the above petition infructuous. So on, continue.
Grateful. Grateful.
Please, my lords.
In those matters, if you are there,
My lords,
who are you?
Same application for impleading which was
No.
filed. The allegation-
Impleading applications stand disposed.
In one of the prayers, they are seeking that there has to be a direction that is given as against one complaint that he filed.
You file a certified copy, they'll give it. Otherwise, there will
Even
be
though-
10,000 people who will ask them for copies.
My lord, accused number 1, petitioner is filed application, copy application before the learned magistrate court, my lord, but they have not provided the.
That you take it up there, not here.
Please, my lords.
Serial number 26, Vijay Kumar T.
Yes. Mr. Usman?
Your Lordship, I kindly see the prayer, my lord. I think the petition does not survive.
Does not survive, my lord.
Consideration.
The program for which they have sought permission was held on 18 and 19 of this month, my lord. That is what they have.
My lord, the matter listed on 17th, my lord, and my lord directed me to serve the copy on the
Yes.
advocate, my lord.
You did not serve it on them. No, 18th and 19th.
18th or 19th, any other date may be permitted, my lord.
They'll make an application for another day.
Like a fresh application. It cannot be done like.
No, my lord, what
No,
has
that
happened
is,
is
the
that.
date is fixed, I suppose, but not the, whatever they are talking about, that Ganda Parva, my lord, either it's called as Sandar.
That's why we asked on the last date, is there anything specific of importance of the dates?
Next date
The submission made was the dates are not important.
Saturday
No, in
Sunday,
fact, what has
coming
happened is
Saturday or
that
Sunday.
they have sought for the permission for them to conduct the program, my lord. Then thereafter, my lord, a letter was written by the circle inspector, my lord, considering the law and order issue, my lord, to the Waqf officer and to conduct the program at the behest of the Waqf officer. That communication was challenged before this honorable. So therefore, my lord, it is not as though that program, the permission for the program is denied. My lord, earlier the president of the managing committee, my lord, they had sought for the permission to conduct the program at their behest, which was earlier granted. Thereafter, it was withdrawn and the program was conducted by the district Waqf officer.
Adhikari, Waqf Adhikari ಅವರು ಉಸ್ತುವಾರಿಯಲ್ಲಿ
under his Ustavari is under his
Annexure B, my lord, earlier permitted to
under the
conduct
supervision of the
program,
district
my lord.
Waqf officer.
Yes.
Is to be conducted under supervision of the district Waqf.
That's a committee not in existence.
This is to be conducted under supervision of the district Waqf
My
officer.
lord, assigning the reason in passing the revocation,
Lord,
order of revocation. my
But
lord.
this is that annual birth of the saint whoever is there is to be performed on specific date. If there are two warring groups, my lord, the work officer is designated to perform this one. Now, in this case, it is over. Now, if at all they have any dispute for next year only, they can.
My lord, only this
It cannot
time, my
be,
lord,
date cannot be changed like my, oh, my lord.
this is the first time raising this question, my lord.
Let them go
Every
before
year conducting the Dargah festival, my lord. Only this year, my lord.
Submission made by council on that day was, the dates are not relevant.
ಪ್ರತಿ ವರ್ಷನೂ
It
ಕೂಡ
could be
ಮಾಡ್ಕೊಂಡು
done
ಬರ್ತಾ
anytime
ಇದ್ದೀವಿ.
ಅಂತ
This is
ಹೇಳಿದ್ರು.
not a first time, my lord.
ಇಲ್ಲ ಅದು ಉರ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ಇಟ್ ಇಸ್ ದಿ ಬರ್ತ್ ಸಂದಲ್ ಗಂಧ
ಅಲ್ಲ.
ಅಲ್ಲಲ್ಲ ಗಂಧ ಅಂತ ಹೇಳ್ತಾರೆ ಕನ್ನಡ ಕನ್ನಡ ವರ್ಡ್ ಕನ್ನಡ ಪರ್ವ ಗಂಧ ಪರ್ವ ಅಂದ್ರೆ ಇನ್ ಉರ್ದು ಇಟ್ ಇಸ್ ಕಾಲ್ಡ್ ಎಸ್ ಸಂದಲ್
ಗಂಧ ಪ್ರೋಗ್ರಾಮ್ ಅಂತ ಹೇಳಿ ಸ್ವಾಮಿ.
ಇಟ್ಸ್ ಆಲ್ ಸೇಮ್
ಉರ್ಸ್
program ಅಂತ
ಉರ್ಸು
and the program is
ಗಂಧ
Urs.
ಪರ್ವ ಸಂದಲ್ ಉರ್ಸ್ ಆಲ್ ಆರ್ ಸೇಮ್ ಥಿಂಗ್ಸ್. Now, apart from that also, if he has any grievance under 89, he has to go for the tribunal.
Every year ಪ್ರತಿ
Now-
ವರ್ಷನೂ ಕೂಡ ಮಾಡ್ತಾ ಇದೀವಿ.
Now, if it is for specific dates, my lord, in the urgency, considering the urgency has invoked the provisions of 226. Now, my lord, the dates are over. If at all any grievance is there against that order, he can go for the tribunal.
ಏನಿಲ್ಲ ಸ್ವಾಮಿ, my lord, if last permit, my lord, next Saturday, Sunday ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾರೆ.
That cannot be done, my lord.
No,
They cannot change the
permit and
tradition.
we have to do anything according with law. It is not that we can do like that. But what are the significance of those dates? That is the birth date or?
Yes, my lord, it is the birth anniversary of the saint. My lord, that is to
That
be,
is-
yes, that has to be conducted on a particular day, my lord.
And it's already been conducted.
What has happened is that the managing committee had sought permission to celebrate that.
Has it been conducted now?
Yes, then that,
Has it been conducted?
my lord, that I have to get the information, my lord, that I will take instruction. I don't have instruction, whether it was conducted or not.
If it is conducted, then it is
Probably, my
infraction.
lord, this is what has happened is that, my lord, the managing committee sought permission to conduct celebrate that this thing, my lord, event. Then, my lord,
So, Usman,
yes,
the logic is simple that what we are applying. If it's been conducted and it's been celebrated, infractions.
yeah, I will.
If it is not been conducted because both of you are fighting, that saint's birthday should not go without celebration.
I'll have it after tomorrow. I'll get it.
Should be done.
I'll get the information.
The Usman seeks for 3 days' time to make a submission as to whether the concerned festival has been celebrated on 18th and 19th of July or not. Released on 24th July.
In a preliminary list.
In preliminary hearing.
Final hearing, serial number 27. Manmohan PA.
The government is yet to file its stand. Government is yet to file its stand in this matter.
There was one terrible mistake which happened on our side. There was a very detailed order which your lordships had passed, identifying policy gaps and noting some substantial questions.
But this is that MSME matter.
Yes, that had missed our attention.
In fact, it's been flagged by the Supreme Court also the other day.
Yes, but it came to my notice only yesterday. I've immediately sent communications to Ministry of Law, Ministry of Finance, and the principal chief commissioner of CGST she has responded, so I will need, since it is policy gaps, my lord.
But also check whether if the Supreme Court is seized of it, then we can't get
That
in.
also will verify.
That also
But
will check
indeed,
on
my lord, there appears to be some gap. and we
very,
need to do something.
from what the newspaper report indicated, it was the same. So
We'll-
just
we'll
verify
examine.
that
We'll
it should
examine.
not be a mistake from our part. And the ASG seeks fund is granted.
4 weeks. So many departments. my lord. I don't.
ಯಾವತ್ತು ಇದು ಆರ್ಡರ್ ಮಾಡಿದ್ರು
Whenever it is policy, my lord, it generally.
26/11 ಒಂದು ವರ್ಷ
No, my lord, it's a routine matter. Okay, if there is a policy, my lord, generally there will have to be a discussion at the highest.
They're suffering on this. Their demand is wiped out.
Bank
And
is
then
after-
you are,
Meantime,
all of you are asking them to pay.
Any protection, my lord, which is
That protection
entitled to can
we-
be given, but since it is a policy matter, I would seek 4 weeks time. And in the meantime, he is carrying out some amendments. So by the time those are carried out, I will.
You're filing any amendment application?
Yes, but I have filed not IN number 1,
Is IA number 1 for?
1 of 26.
Now you have sought for those reliefs.
Yes.
IA 1 of 26 has been filed by the petitioner to place on record certain subsequent events, including the demands which have been made on the petitioner to make payment, repay the loan, as also to make payment of certain amounts to various authorities. The amendments made, as also the prayers sought for, would be required to be considered to decide the complete list between the parties. Hence, IA 1 of 26 is allowed counsel for the petitioner to carry out the necessary amendment and file amended petition. The respondents are restrained from initiating any coercive steps for recovery of any amounts
Lord, in respect of
till from the.
respond number 5, Lord, Canara Bank. Lord, Lord, we have already, Lord, issued notice and Lord, other things, Lord, in this proceedings it can't.
Only notice, let it be, but don't take
They have
any
filed
action
OA
until a
also, Lord.
policy decision is taken.
Some short date, Lord, what is, Lord, we put up.
They have also filed OA.
The difficulty for me, Lord, I have nothing to do.
Yes, he is asking for 4 weeks.
Lord, it can, Lord, in respect of my submission, Lord, I may put the property for auction. I'll just take an instruction. Lord, I have nothing to do with him, Lord.
That is the problem. You'll just put the property for auction.
No, but
That is the exact problem.
there, my Lord.
They have already approached DR team, not filed OA also.
That is why we are restrained from taking any coercive steps for recovery of any of the amounts from the petitioner till the next date of hearing, since questions of seminal importance have been raised in the present matter, and ASG has sought for 4 weeks' time to address them. Released on 24th August at 2:30 p.m.
Please.
Madam, remind the ASG 2 weeks in advance. No, now it has come to my attention. But
This requires some, this one, because it is not only them, everybody will have this.
I also quickly went through the UK Act, but I think we can probably.
Clean slate shall not be unidirectional. Of course, we considered this in section 11 matter, but in section 11 we could not consider it, left the arbitrator to decide that. That was a very interesting matter where the petitioner had, on ground of insolvency, said that I don't need to pay. It went to the CIRP process, successful CIRP process. So the slate was wiped clean for the petitioner in section 11. Thereafter, a section notice was issued to the respondent to say that you have to pay me the money. The respondent has contended that your CIRP is over, mine also is over, it is
zero,
wiped out. Both of us are on the clean slate. But the judgment, Ghanshyam Das and everybody says it is one way.
One way. True.
And that one way is what is affecting them here.
True. It is true.
That it has to be done through policy only.
Currently, it seems like a double whammy. He is not able to recover his money, but tax is being demanded on the money which is not recovered. So
Here, the service tax is, forget Mr. Shetty. Shetty at least may have something because they have borrowed money. But on a service tax, 4 crore of rupees, which they have
Various
supplied,
amounts are there.
the invoice is raised, they've been paid only some 25 lakh of rupees. They are now required to pay service tax on 4 crores.
The UK Act does refer to that kind of a situation. We do not have an analogous provision here. So I will see if we can draw some inspiration from that.
Even
because what happens to all the things, if they don't pay the labor, they are in trouble. If they don't pay rent, they are in trouble. If they don't pay Vignesh, they are in trouble. If they don't pay
GST,
GST, they are in trouble. If they don't pay electricity, they are in trouble. The transport, it's a domino effect. How do you safeguard a person who is a creditor in a CRP process is not taken care of in the...
Particularly someone who has set up industry with borrowing some money here and there.
Whatever it may be, their own anything. If they had got that money, they would have paid all of you. Because that CRP process which they have no control over. And their the recovery has been wiped clean. And because of that, they become a debtor. And they will now undergo insolvency.
I think lordships are rightly observed. The dirty slate is still in their hand, whereas the others have got clean slates.
It's
This requires consideration.
please. Why we explain now is to remind you what
That order is very clear. Your lordship's order, as it is, I have forwarded to the ministry.
there we have covered only the legal element. Why we are explaining is the human element.
Yes.
Human element also needs to be looked into.
Great.
please.
Key group matters, serial number 28. Ravi Shankar, yes.
Yes, Mr. Ravishankar.
That furnish the details of the account which has been.
My humble submission, the respondent poor condition is very serious, please lordship. She is in ICU just 3 days back. She is discharged from the hospital.
Have you received the money is what they have to pay? They gave the details saying that they have paid.
That was withdrawn due to that she is admitted to hospital, please lordship. They have with request they have withdraw the amount and they have paid to the hospital expenditure. But her condition is very serious. She is not able to take any food and only she has to give a food to through nose only. Now the doctor says that her condition is very serious. You please discharge from the hospital and
She is your mother.
Mother.
I can produce
the daughter
the
is not leaving.
copy of the. I'm
They are
sorry.
not leaving me to see the mother, the daughter. She is residing along with the daughter.
Who is not leaving you?
The daughter, the sister of my sister, she is not living. She is residing with the sister. Earlier, she was residing with me. Thereafter, a gift deed was executed in favor of the sister in respect of other property. Thereafter, she started residing there. And thereafter, the dispute started.
There is, as per my
As per-
information,
Like how we have in the JJ Act child welfare officer. We need a senior welfare officer. These are
in
senior
the
citizens
DC order, the specific
in need
allegation
of,
against the
in
petitioner.
need
please,
of
Lordship.
protection.
The DC has referred in his order the attitude of the petitioner. It is referred in the order portion, please, Lordship, in page number 5, after third para, please, Lordship.
Senior Citizen Act, put it.
And I have produced the photograph of the seriousness of the.
Intercaste marriages. ಅವ್ರ ಕಂಡೀಷನ್ ಮೇಂಟೆನೆನ್ಸ್ ಹೆಂಗೆ ಅಂತ ಅವ್ರು ಯೋಚನೆ ಮಾಡ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
what is there in 20?
Act itself, there can be an order that the criminal can pass in such cases if nobody is paying. There's other case also where they said there is no pay for the medical.
Shall only provide beds. Shall it provide treatment? What are you reading? Which provision? 22, yes. District magistrate, who will go? Which officer do we say? District magistrate, deputy commissioner.
DC.
The deputy commissioner will get authorized something. Now in section 20, hospitals funded fully or partially by government shall provide beds for all senior citizens. Does it also include treatment? Separate queues to be arranged, facility for treatment of chronic, terminal and degenerative diseases is expanded. Research activities for their earmark facility for geriatric patients in every district hospital duly headed by medical officer with experience in geriatric care. So where is respondent number 4 now?
Now she is staying with her daughter house.
In the hospital or at home?
Now she is discharged, please lordship. Now she is stay with the daughter house. The hospital has told that condition is very serious. So giving the further medicine also, survival is a doubt. That purpose they have discharged the fourth respondent, and now presently she is a bed ridden in the daughter of fourth respondent. Please.
We'll pass the direction for them to visit. Tomorrow we'll need that.
Moreover, she is not able to take any food or any medicine through mouth. Please, lordship. I have produced the photograph. ಮೂಗಿಂದ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು. That is what the children need to understand.
Please, lordship. But my humble submission, instruction from my client, the son has not met till today. Please, lordship.
I think lordship could direct the commissioner of the social welfare department a kind of SOP in this matter.
This is not done. Parents took care of the children during their this one.
They're not taking one step ahead. This district government unless intervention is poor. Any officer, matters can take up.
That will come to later. Today, let us do this because emergency is there. The details of the payments made by the petitioner to respond number 4 were furnished to counsel for respond number 4. On verification, he submits that the payments have been made.
Please, Lordship.
The amount withdrawn
Withdrawn by the fourth respondent.
by fourth respondent and expended for her medical treatment.
Please, Lordship.
His submission is that the medical condition of respondent number 4 is precarious and that even the hospital has discharged her
Please, Lordship.
on the ground that no further treatment would help her. His further submission is respondent number 4 is staying with her daughter. There are a large number of matters which are coming up before this court as regard the senior citizens' right being violated. Section 20 of the Maintenance and Welfare of Parents Senior Citizen Act 2007 requires for the state government to ensure that the government hospitals or hospitals funded fully or partially by the government shall provide beds for all senior citizens as far as possible, as also facility for treatment of chronic, terminal and degenerative diseases is expanded for to be expanded for senior citizens, and earmarked facilities for geriatric patients in every district hospital duly headed by a medical officer with experience in geriatric care. Section 22 requires the district magistrate to implement the provision of the Act. Rule 20 expands on the duties and powers of district magistrate. In terms of sub-rule 2 of Rule 20, the district magistrate is required to ensure that life and property of senior citizens of the district are protected and they are able to live with security and dignity. In that view of the matter, the district magistrate in Mysore is directed to depute a suitable person to visit respondent number 4. Address idena?
Please.
21904.
Now present address. This. I will furnish the address, please.
At so and so address, preferably with a competent medical practitioner, with a qualified medical practitioner, to ascertain the status of respondent number 4 and place on record the way forward to protect the health and liberty, health and life of respondent number 4. Report to be submitted, learned AGI to inform the Deputy Commissioner orally about the above order. The Deputy Commissioner to take action without waiting for the order to be uploaded. The report to be submitted by the afternoon session tomorrow. Released 22nd at 2:30 p.m.
Great.
And AGA to also secure instruction and make a submission as to whether there is a comprehensive action plan prepared in terms of subsection 2 of section 22, read with Rule 21 of so and so rules 2009. If so, to place the same on record.
Great.
Serial number 29. Vasudevan Idol.
appearing for petitioner. Copies has been served.
No, you've not given me the copies. To whom you've sent? No, it's directed to serve to me, sent it by post. I'm not. I got to know.
Adam is
yesterday's
here. Where
cause
are you
list.
going all over the place? The counsel for the petitioner undertakes to furnish 2 sets of the petition. On the counsel for respond number 1 to 3 by end of day 24 July. How much time do you want?
1 week, my lord, because this
Counsel
pertains
for
to the old
respond
premises.
2 and 3 has been freezing, account
In fact,
freezing.
this is not actually, my lord, on going through the online details. This appears to be dormant, my lord. That is my instructions. But let them furnish the copy because I don't know the account number also.
There's no police.
No. This is the petitioner is the old premises owner. Some dispute was there. I'll just verify.
Takes for a week's time thereafter to obtain instruction, make a submission. Released on 5th August.
Great.
Submission, please, Lord. 22nd is tomorrow. The Honorable Court has directed to visit tomorrow and release the matter on.
Immediately oral submit, oral information.
Release the matter on 20.
Tomorrow at 2:30.
Tomorrow matter will be.
Tomorrow it will be taken.
Grateful, Lord.
These are the way that you submitted, it's emergency. If something has to be done, it has to be done now.
Yes, sir.
Serial number 30, MS Venugopal.
Appear for petitioner.
Appear for respondent number 1, please. On the last occasion, my lords were pleased to direct me to take instructions with respect to order dated 17/2/2026.
17/2.
Wherein they have agreed that they will pay 5% rather than the disputed 3%. Now, my lords, on instructions I am submitting that the tender which was floated
Revised, it's contested the revised payment for security deposit at 5% as against 3%.
Essentially.
Yes.
The tender which was floated was in pursuance to, my lords, a Sagarmala scheme which was proposed by the Union Ministry of Port Shipping and Waterways. And they have, my lords, removed sanction or withdrawn the sanction for the same place.
It's no longer available.
No, it is no longer available. And it has become infructuous. Copies, please. At serial number 40, please, my lords, page number
June
6.
24.
This was 2 months prior to their acceptance letter, which was done without knowledge of the same.
Then you cannot cancel the REMD. You'll have to return the REMD.
We have to refund the EMD. That may be ordered.
Please.
Petitioner is before this court seeking for the following leaves. The petitioner is engaged in the business in the execution of project works relating to marine, shipping, civil construction, dredging, bridge construction, disaster management works, etc. Respond number 1, having invited tender for capital dredging at Old Fort Mangalore. The petitioner participated and was successful. Acceptance letter came to be issued on 25/3/2024. The acceptance letter was required to be issued but was not. Hence, the petitioner followed up for issuance of such acceptance letter, which came to be finally issued on 10/7/24. Insofar as the security deposit was concerned, the petitioner, in terms of the contract, was required to make payment of security deposit at 3%. But however, since there was a demand made for 5%, the contract could not be executed, and it is in that background that the petitioner approached this court seeking for the aforesaid relief. When the EMD submitted by the petitioner was also sought to be forfeited by the respondents. Notice having been issued, Shri Bharat Kumar V has entered appearance for respondent number 1 and has today filed a memo stating that the entire project has now been shelved since the budgetary funding, since the funding to the said project has been withdrawn by the Government of India, Ministry of Ports, Shipping and Waterways on 4th June 2024. In that view of the matter, he submits that the work cannot carry on since there is no funding for the same. If that be so, then the question of either calling upon the petitioner to submit a security deposit at 5% or 3% would not arise. And if the work is not to go on account of lack of funding on part of the respondent, the petitioner cannot be held responsible for the same, forfeiting the EMD, while there was a dispute as regards the percentage of security, and a coordinate bench of this court, while order dated 17/2/2026, had observed, had taking note of the submission of learned counsel for the petitioner that he is willing to offer 5% security deposit, had called upon the respondent to obtain instruction and make the submission. It is thereafter that today it is submitted that there is no funding. In that view of the matter, the respondents cannot retain any amounts which have been deposited by the petitioner with the respondent. As such, this court passes the following order. Writ petition is partly allowed. The forfeiture of the EMD, the cancellation tender is upheld. The forfeiture of the EMD made by a respondent is set aside. The EMD amounts may have
24.48 lakhs.
The EMD amounts we won't are directed to be refunded to the petitioner within a period of 3 weeks from the date of receipt of a copy of this order.
31.
Yes.
Only number 2, my lord. Last hearing date, my lord, directed to furnish the available of the flats, my lord. That I have filed, my lord, along with the memo.
On 3rd July, my lord
You have
directed.
furnished the details of the
Details
flats?
of
Availability.
And my
I have
lord-
sent my parties there to that. There are none of the flats are in condition. Actually, everything is, doors are taken away, everything is taken away.
That's the government
flats,
property, my
they are
lord. We
offering.
have completed the project. After that, yaru bandila andre,
ಯಾರು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಯಾರು ತಗೊಂಡು ಹೋಗ್ತಾರೆ?
that we can make it properly and we'll give hand over.
If you are offering apartments which are not proper,
Some are already residing there, my lord, residing there.
we'll appoint a commissioner
We are
with full
residing.
videography, photography and everything.
We are, some
your
people
cost.
are residing, some are which are not allotted, which is vacant, my lord. Alli,
Madam, when you are offering something, you have to offer something where they can go and reside.
if we select,
Offer
my lord,
something
we'll
that they
complete
cannot go and
properly.
reside.
No, this is completed project only, but door yaro ಕಿತ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ
ಅಲ್ಲ
ಇದ್ದಾರೆ.
ಒಂದಲ್ಲಮ್ಮ 26 ಫ್ಲಾಟ್ಸ್ ಅವ್ರು ನೋಡಿ ಬಂದಿದ್ದಾರೆ, ಒಂದಕ್ಕೂ ಒಳಗಡೆ ಹೋಗಕ್ಕಾಗಲ್ಲ ಆ ತರ ಇದೆ. ಇವ್ರು ಅವ್ರೇ ಇದ್ದಾರೆ ನೋಡಿ.
ಅಂದ್ರೆ ಅದು ಪಾರಿವಾಳ ಎಲ್ಲ ಆಕ್ಯುಪೈ ಮಾಡ್ಕೊಂಡಿದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. Since it's a
ಅದಕ್ಕೆ
vacant.
ನಾನು ಐ ಮೇಡ್ an alternate suggestion, my lords. Kindly see page 30 of my writ petition.
ಕಬೂತರ್ ಖಾನ ಮಾಡಿದೀರಾ?
ಸೆಕ್ಯೂರಿಟಿನೂ ಇದ್ದಾರೆ, ಆದ್ರೂನು ಅವರು ಮೇಂಟೈನ್ ಮಾಡಿ.
How can it be that doors?
ಏನಿದೆ ಡ್ಯಾಮೇಜ್ ಏನಿದೆ ಎಲ್ಲ ಪ್ರಾಪರ್ ಆಗಿ ಮಾಡಿ ವಿಲ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಇಟ್ ಮಲ್ಲ. ರಿಸೈಡಿಂಗ್ ಯಾರು ಇಲ್ಲ
Kindly see
ಅಂದಾಗ
page 30, my lords, for a second. Writ petition, page 30. When they said that whatever is allotted to me in that scheme is failed. If you want, you can apply from in 1 lakh scheme of the present chief minister then.
So now what do you want, Mr. Kulkarni? You want them to,
I am ready to take this 31, page 31, kindly see for a second. I have paid 15 lakhs. This 14 lakhs 2 BHK available here in 1 lakh scheme. She is ready to take that. They are to offer that as a part of settlement of this writ petition.
they've offered you something which is not habitable is what you are saying.
Yes, my lords. Yes, my lords.
You want the apartment or you want return of the money now?
Return of money along with the interest I asked last time. Your lordship said that how can I decide interest part? So
Because it says no interest.
my submission to your lordship is my money is held by them, and they have not completed their part of the contract. Actually, they say that our
What is
project
the
is
interest
failed.
that you charge them, madam, if they delay? Page? Statement of obligation. Yes.
In that application, my lord, the first preference of the flat which he selected, my lord, Kesle village, Mysore. The project is not started, my lord.
Yes.
The second option is Kalaguppa, my lord. Kalaguppa we have allotted, but due to technical reason, my lord, that is stopped. We'll complete it another few months, my lord, then we'll hand over it if she waits. Otherwise, the third option she is seeking, my lord, Singanayaknalli. Which I have produced now, my lord, along with memo. Third option, she herself is wanted a flat in Singanayaknalli. The Singanayaknalli flats, 28 flats are available, my lord. That cost is 6 lakhs to 11 lakhs, my lord. Rest of the amount will return it on back, my lord. If she select any flat, my lord, it clean and hand over with the good position, my lord.
Actually,
Now,
my
which
lordship,
apartment did they, which project did they go and visit now? Singanayaknalli doesn't have doors, windows, and it has only.
no, that project was completed in the year 2016. If they have offered it in 2016, that project, one of the flats there, they would have happily lived by this time, 2016 to 2026.
ಆಯ್ತು ಇವಾಗ ಮಾಡಿಲ್ಲ ಇವಾಗ ಏನ್ what could be done
2016
now?
ನಲ್ಲಿ ಅದು ಹೊಸದೇ, ಈಗ ಅದು ಹಾಗಾಗಿದೆ ಅಷ್ಟೇ. 2016
ಆಯ್ತು ಇವಾಗ ನಿಮ್ಗೆ ಸಿಂಗನಾಯಕನಹಳ್ಳಿಯಲ್ಲಿ ಬೇಕಾ ಅದು ರಿಪೇರ್ ಮಾಡಿ ಕೊಡಕ್ಕೆ ಇಲ್ಲ ತಾಳಗುಪ್ಪ do you want to wait for 4 months?
In 4 months you can wait, man. Talguppa, if 4 months can be given.
ನಮ್ಗೆ ಹೇಳ್ಬೇಡಿ ವೆಕೇಟ್ ಮಾಡಿ ಅಂತ. ಅದು ಮುಂಚೆ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ ನೀವು? ಅದಕ್ಕೆ ನಾವು 4 months ಅಂದ್ರೆ ಇವಾಗ ಸ್ಟೇ ಅಂತ ಹೇಳ್ತೀರಾ? ಮುಂಚೆ ಹೇಳ್ಬೇಕು. All of you speak to each other and see what it is, understand.
I have spoken with her everything. If necessary, I will go and see her managing director and I will explain him everything.
Please go see what it is
Kindly.
and find out if check the status of Talguppa also, examine the litigation aspect. If finally you have to advise your client.
I have advised sufficiently, my lords. Only thing is that they have gone another area, this Ganiganahalli, Chikkabanavara Hobli. There the flats are available and they are ready to move there. But what they say is that is another scheme and therefore that can't be offered.
Total 228 flats for SC/ST, 282 flats for general, 57 for minority. But already
Nothing is available.
if available, then website they can file themselves, madam. Any flats in other 1 lakh houses, madam.
They went there and that board itself is taken away. That scheme board is not there.
ಅಂದ್ರೆ ಸೇಲ್ ಆಗೋಗಿದೆ ಅಂತ ಇದ್ರೆ ಇರೋದು ಬೋರ್ಡ್. Madam is right in saying that. If there is any apartment which is flat is available in any of this one,
They are moving
you can
pillar
give it to
post
them.
actually. For the last so many years they are suffering.
Correct. That's why, Mr. Kulkarni, we got all these details for you.
But this, if this Ganiganahalli, Chikkabanavara Hobli, Kempapura area, if one site is allotted to them, they are ready to go there flat.
This is not available is what they say.
No, that is.
if you have any details of availability, please show it to us, we'll direct them.
That-
If they're making a false submission, we'll deal with them. But you will have to show us that it is available.
How I should find out that, my lord?
How do we know? When they are saying that
If
it
the
is
court
not
can
there.
direct, they will provide the information. If the court can direct, they will provide the information, that information.
How many projects did you do?
My lord, the flats are wherever the location available, my lord, that is in the 1 lakh houses, we have provided to them, my lord. The website is open, the vacant flats are available, my lord, the project. They can select and apply it and give it to us, we'll allocate to them. This is the process.
This is in this writ petition, a part of settlement, they can give it to us, that's all.
They cannot give something which has already been given to somebody else.
Yeah, the procedural aspects of the matter, I will complete it.
Find out which is available and let us know, then we can.
Yes,
direct.
my lord.
Both the councils seek for and are granted 2 weeks' time to ascertain which flats are available and the project in which the flat is available. Relist on
This,
12th
this
August.
area, this particular, for this thing, you are last time note down this. Ganigar Haldi, Chikkabanamar Hobli, Kempapura.
Then we'll have to note down their submission that is not there. So go find out and then come back.
Yes. Yes, ma'am.
Serial number 32.
Date may be given, ma'am.
12th August.
I am grateful.
32.
Petitions. Petitions.
PDO Kadur.
Please, ma'am.
Yaar hai tu?
Okay, Nayak.
The Ashok Naik is direct.
Petitioners will not only seeking for a mandamus.
That give it to Mr. Ashok Naik.
Please.
He is direct to accept notice for respond number 3. Counsel for the petitioner to furnish 2 sets of the petition along with annexures and said counsel. Released on 11th August.
Obliged. 11. Yeah, 20th.
20th August.
Please.
20th August.
Serial number 33.
ಇದೆಲ್ಲ ಇವತ್ತಿದೆಯಾ?
Recommendation.
All the matters are today or tomorrow?
21/7.
21/7. 33. Relist on 21 ಇವತ್ತೇ ಅಲ್ಲಮ್ಮ? ಎಲ್ಲ ಇವತ್ತಿದೆಯಾ? ಕಾಣಿಸ್ತಾ ಇಲ್ವಲ್ಲ? ಇದೊಂದೇ ಇದೆ. Anything else? When are these matters?
No, my lord, I have only one of this. My lord, if it may
Large
be
number of
posted,
matters.
if it may be posted day after tomorrow, my lord, I
We'll
will.
pass over, find out Marty, then we'll take it up together so all arguments could be considered of everybody at one go.
Allah.
ಒಂದು 20-30 ಮ್ಯಾಟರ್ ಇದಾವೆ.
I also have a few matters, my lord.
ಮತ್ತೆ ಅದು ನಂಬರ್ ಕೊಡಿ. Give the numbers.
I may be permitted to hand it over tomorrow, my lord. Allah,
give it.
right now, I don't have them, my lord.
Let's see in the afternoon when those matters are listed, we'll post this on that day.
Very fine. My lord, my presence may kindly be dispensed. Obliged, my lord.
Wait, please, Manoj. Manoj, 34, 53.1 and 53.2.
Which one?
53.1 and 53.2. Same issues there, but last time Malad had observed we should try and settle 34, 53.1
and 2, yes.
and 2.
Oh, this is a consumer matter.
Yes, 53.2, Malad, we have settled.
Yes.
As far as 34 is concerned, Malad, we reached out to them, but there is no response. The team tried to.
Now,
even
what
get
have we
in
done
touch.
with 34? We'll come to 53 later.
Yes, 34, Malad, we sent a mail, there is no response. We are ready to offer, Malad, may kindly see the mail.
Mr.
We are ready.
Mr. Rangramu is here. Last time also you
Because
said
I talked to my learned senior, I requested him to, I in fact gave the number, my senior's number to the company representatives. They tried to reach out. They sent a mail, but there is no response. We are ready to even offer an alternate flat, but it is not a 3-bedroom, it's a 2-bedroom at the same rate as then. We have spelled it out in the mail. I can share that mail with my.
You want only money.
National Consumer Forum.
Means appeal.
Supreme Court decisions regarding many possible state forum, they have to approach the national forum.
You don't want the apartment, you want money.
It's, as far as money is concerned, I conveyed to my learned senior that the amount with interest is working out to 17. Because it's an ex parte award, I cannot say anything on merit except what I've challenged here on
The
procedural.
interest will go up because we'll send you to National Commission another 2-3 years. Then come back for execution.
In fact, this is an execution. I don't want to touch on merit today, my lord. The only thing is that we had offered maximum 10 lakhs, my lord. They are asking for 16 to 17.
See, we are going to dismiss your petition. Only thing that you came up with is you're trying to settle. They said, okay, try and settle. But if your settlement is that you are...
We had offered an alternate flat, my lord.
And they're not interested on
They're
that.
not interested, yes.
Then go to the National Commission.
My lords may hear me on merits then, my lord. My lords may kindly hear me on merits. Because
Yeah,
what
go
had
ahead.
fallen from my lords was that I have a alternate statutory remedies.
Yes, go ahead.
My contention was if my lord may kindly have section 72 of the Consumer Protection Act. I have a very limited argument, my lord. The proposition for my lord consideration is, firstly, my lord had said, observed that I have an alternate remedy if 72 is read. Please read 72 with me, my lords. I have a remedy of an appeal provided I am found guilty in terms of 72.
What are the facts? The District Commission passed an order.
Yes, my lord. They passed an order. They filed an execution under 71.
After District Commission, you did not go to the State Commission.
I did not, my lord. They filed an execution under 71.
And thereafter, you come to the High Court.
So, my lord, 71 is similar to Order 21 CPC.
Yes.
72, which is the old 27 on which there is a judgment of this Honorable Court, is identical to 27 of the old code or of the old Consumer Protection Act. Now, my lord, the difference between 27 and today's 72 is this Honorable Court had held that 27 is bad in law because it does not provide a procedure. There is a judgment of Paramjit, my lords. I believe I had handed it over last time. It's filed by the memo also, or I'll give a fresh set, my lords.
You've handed over a memo of 7 judgments. Jolly
It's not in that, my lords, I believe. It's
Paramjit is there.
Paramjit is there, my lord?
Yes.
My lords, may kindly have Paramjit for a moment.
Yes.
1 second. My lords, in Paramjit, the issue as set out in para 3 is about 3 lines from the top.
That is where constitutional validity is
Yes.
challenged.
Now,
You're not
yes.
challenged.
So what this Honorable Court held, my lords, may kindly have.
You're not challenging the constitution.
No, I have not. I am in fact relying on it because please have para 8. I am saying the procedure in 72 after it was held to be unconstitutional to a limited extent. Please have para 8.
72 was not held unconstitutional.
No, 27.
27 was held unconstitutional.
Yes, 27.
There's
So the
72
difference
new provisions.
in language, my lord, the difference in language is between 27 and 72.
There's a problem, Mr. Vinay. You are thinking everything will be on some other things. Flat, money is the same. 27 is not the same as 72.
No, my lord, so there is
If
a
you
difference.
don't challenge 72 valid.
Because I
you
don't want to
can't
challenge 72. I'm relying on 72.
Yes.
72 provides the only difference between 27 and 72 is that 27 did not provide the procedure. 72 says that the consumer forum will be deemed to be a judicial magistrate.
Yes.
And the procedure to be followed is as set out in the CRPC. That procedure, my lord, is 190 CRPC. There has to be a formal complaint by virtue of section 4 and 5.
Let us read 72. What?
Please have 72, my lords.
Yes.
Whoever fails to comply with any order made by the district commission or the state commission or the national commission, as the case may be, shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 3 years, or with fine which shall not be less than 25,000 rupees, but which may extend to 1 lakh, or with both. Notwithstanding anything contained in the Code of Criminal Procedure, the district commission, the state commission, or the national commission, as the case may be, shall have the power of a judicial magistrate of first class for the trial of offences under subsection 1 and on the conferment of such powers, the district commission or the state commission or the national commission, as the case may be, shall be deemed to be a judicial magistrate of the first class for the purposes of the Code of Criminal Procedure.
Yes.
Now, my lord, if that is the case, the moment they file a complaint under 72, which they have not done, they have filed an execution petition. The judicial magistrate, by virtue of section 4 and 5 CRPC, please have section 4, my lord. It is reproduced in Paramjeet also, my lord. Because Paramjeet, what was dealt with was this portion was missing, that the trial will be as per CRPC. So kindly have section 4, my lord. Even BNSS, it remains the same, my lord. Kindly have section 4.
CRPC.
In fact, in 53.1, the learned consumer forum goes to the extent of saying, my lord.
Let's restrict it to
Yes.
34.
Yes.
Argue only 34. The counsel for 34 is here.
Yes.
53 is not here.
Kindly have 4, my lord.
Yes.
Trial of offences under CRPC and other laws, all IPC and other laws, all offences under so and so shall be investigated, inquired into, tried and otherwise dealt with according to the provisions hereinafter contained. All offences under any other law, this being any other law, shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying or otherwise dealing with such offences. Now 72 is very clear, CRPC will be followed. So now my lord may have 190 CRPC. Like my lord, a defamation complaint or a 138 complaint. It has to be in that format, there has to be a prayer. Subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class specifically empowered in this behalf under subsection 2 may take cognizance of any offense upon receiving a complaint of facts. So this would come under 191A, my lord, because this is not a case of a police report. And it is not a case under C also. And then what would follow is, my lord, 204, which is 227 of the new code. Issue of process. If in the opinion of a magistrate taking cognizance of an offence, there is sufficient ground for proceeding, and the case appears to be a summons case, he shall issue summons to the accused for his attendance. This is not a warrant case, my lord. This is a summons case. Then what would follow, my lord, is 251 CRPC, my lord. And this is what the Honorable Supreme Court has held in the other judgment I've relied upon, Kamlesh Agarwal, my lord. That is part of the citation. Consumer matter.
You have not relied anything until you start relying on it.
Right.
Just because you say you'll rely on it.
I'm so sorry. Yes. So 251, my lord, is like a normal trial in all private complaint cases. The charge will have to be drawn up or a notice has to be put to me. Like in any private complaint, best example being defamation or 138.
Yes.
So none of that is done here. What the learned consumer court has done, if my lord will have the peculiar facts of this case, please have, my lord, page 25. What is filed is an execution petition and the prayer is very interesting. Prayer is under 71. Please have page 25, my lord. In fact, my lord, what I just handed over, my colleague who had filed this petition earlier, he did not file the complete petition, execution petition.
You may be right in, we are not saying anything. Whatever you may be saying. If the wrong order, you have to go to the state commission.
Well, it's, now coming back to 72.
Yes.
72 contemplates me going in an appeal provided there is a final order of holding me guilty. There is no final order, my lord. It is only an order. In fact, the oddities, my lord, what the consumer is going and representing there is because I have not paid, therefore issue warrants, which again goes contrary to Inder Mohan Goswami, my lord.
Yes, but 73 provides for an appeal.
But appeal provided,
Notwithstanding anything
well, it's
contained in
provided
the
72(1) comes into
where
play.
an order is passed under subsection
Well,
1.
please have 72 for a second again. 72, that threshold has not been passed. That threshold is passed provided I'm held guilty under 72(1). I have not been held guilty. I have
You have come before that.
No, I have come at a stage because warrants are being issued, my lord.
Okay. The warrant has been issued as if you are guilty, is what your contention
Yes.
is, without following the process.
Yes.
So you have been held guilty.
No, it's not a judgment, my lord. My lord,
Under 73.
my lord, if there was a judgment, then there would be a judgment in terms of, my lord, the procedure prescribed, and therefore I would request, my lord,
You
to
may
have
be
the.
right that there is no judgment.
There's nothing.
The Act provides for you as an appeal to the State Commission. The High Court is excluded from the whole thing.
Well, it's,
District Commission, State Commission, National Commission. After that, you can come to the High Court. Not before that.
Well, it's when an order is passed. May I read 73? my lord?
Yes.
Notwithstanding anything contained in the Code of Criminal Procedure, when an order is passed under subsection 1 of 72, there is no order holding me guilty and punishing me for 3 years. Not
That is
even a
what you
whisper.
that is what you can take up before the State Commission.
Then Malas may give me that liberty, because today my situation is there is no order. And if I show, my lord, 53.1, the learned consumer court says, because I'm not
Section
settling.
2 is also clear. It shall not lie before any court from any order of the District Commission, State Commission or National Commission.
Provided, my lord, there is an order of conviction under 72(1). There has to be an order of conviction, my lord. There is no order of conviction. I can show to, my lord, the impugned order. The impugned order, my lord, will find the first order I have challenged is page 13. The very cognizance of the proceeding is bad. 72 will not come into play, because if my lord sees the prayer is arrest or detain him in custody. The prayer is not to punish him. Nothing of 251 to 257 has been followed, my lord. And therefore, I would request, my lord, to take the second judgment of Kamlesh, my lord.
We'll come to it. Let us see what is the orders which have been passed.
Malas may kindly see the first order, which I have challenged, page 13. This order itself is bad in law, because there cannot be an execution application under 72. There has to be a formal complaint under 190. Read with 200. There has to be a summon then. What the consumer court has done is it has converted the execution application as if it is a complaint, which is not the case, and it cannot be.
This is as a decree. They are asking for attachment and arrest.
That is 71. That is not 72, my lord. 71 is already dismissed.
Where is the order under 72?
The order under 72, purportedly the order under 72, my lord, is at page 14. That's it. I'm aggrieved by this order, because what this order has been passed on is an execution petition and not a complaint.
Come to page 13 and read the order of 8/2/24.
Page, my lord?
13, order dated 8/2/24.
Yes, my lord. From the top, my lord?
The order DHR
yes.
complainant.
Decree holder, complainant and advocate for decree holder present and filed complaint under 200. There is no complaint under 200.
This is what the order sheet says.
No, but my lord, see the complaint. This is not a complaint under 200. Please have 25. And I've just handed over, my lord, the complete execution petition, which is being treated as a complaint. You've given it.
Sworn statement of is duly recorded. Peruse the complaint filed on 200. Sworn statement. At this stage, it appears that the prima facie case cognizance has been taken.
Malas, the law is well settled. The law is well settled. There has to be a complaint. There has to be a prima facie view against me.
This is the order sheet.
But please see the complaint, my lord, 25.
According to you, that is what it is. But the order sheet, we don't know what you have produced, what you have not produced.
Let's kindly see.
The order sheet says this.
The order sheet, but that's why I'm assailing it, my lord. I'm saying the learned Consumer Forum has proceeded on an execution
Till now
petition.
you are saying that there was no order passed under 72.
There was no complaint.
Please, your client may be smart. You don't get smart like that in the court.
Please, Manoj.
Till now you are saying there's no order under 72.
No, I'm saying
Order under 72.
no, the order under 72.
Right or wrong is a different issue.
Manoj, my contention is this. The order, what is purportedly under 72, has to be preceded by a formal complaint under 200.
Is what you are saying.
That is my entire argument.
If there is an order under 72, your this one is to State Commission.
Well, it's, this is not a
right. Or
allow
wrong
me,
is a
allow me, my
different-
lord, allow me. If this is an order under 72, read with section 190, it's a cognizance order.
Yes.
This is not an order holding me guilty under 72(1), which is a requirement in law. Before, my lord, I can go in and appeal.
Then you have to file a 482.
Manoj, may
Not
give me
a
that
writ
liberty, I'll file a
They are not
482.
going to give you any liberty.
Manoj, may observe, Manoj, it's a label of the petition, my lord.
They are not going to give you
Manoj,
any
it's a
liberty.
label of the petition.
Ex facie, you are trying to deprive them of everything.
Manoj, I'll not go into the morality
Sir,
of it, my lord.
Your conduct is not, so equitable jurisdiction of those
I
will not be
understand,
exercised.
I understand.
You wanted to settle it, you settle it.
Manoj,
It's like
give-
this.
Manoj,
They have
may
been
at least
without-
tell my learned senior to give me a contact of the client. I'm not able to get in touch with the client. My mails which I have sent,
They are here in the court.
I'll talk to them then, Manoj. I'll talk
They
to
are
them.
here in court.
I'll talk to them.
They don't want to talk to you. They want to talk to only the money that you are going to give them.
Well, it's
And
the
you don't
money
want to
amount
give
I
them.
have
They'll
quantified.
pass over, try and sort it out, otherwise.
Manoj, I realize, Manoj, my argument is on a purely technical ground, my lord.
Not technical, hyper technical, and it amounts to cheating them. I'm not impressed by that. Yes, Mr. Chandrasekhar. CL number?
It's passed over, my lord.
Huh. CH-10 ಅಂತಿದೆ ಅಲ್ಲ?
CHAD it is written, Manoj. That is why he has missed.
N miss.
Malad, may I request one thing? Then Malad,
Registry is direct correct the name of the council appearing for respondent number 2 as PV Chandrasekhar. And ಯಾವಾಗ ಬೇಕು?
Day after tomorrow. Day after tomorrow.
Day after tomorrow. Relist on 23rd.
Malad, 34, Malad, may kindly have it on 24th. I'll talk to them in the meantime.
34 relist on 24th.
My lord, serial number 84.
For further hearing at 2:30 p.m.
Well, as interim till then may be continued.
Interim order earlier granted is extended till next day.
Much of.
My lord, serial number 84.
84. Yes.
14%.
Yes. Yes, really.
Hearing is requested, my lord. Earlier hearing is requested.
You filed some affidavit, counter dated has to be filed. ಏನಿದೆ affidavit ಏನು explain ಮಾಡಿ ಅವ್ರಿಗೆ ಏನಾಗಿದೆ ಅಂತ.
ಅದು ಇವಾಗ 24 34 ಅಲ್ವಾ ಡೇಟು 24/7 ನಾಳೆ ಅದು 84 ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ಮೆಮೊ ಅಂತ ಹೇಳ್ತಾರೆ ಯು ನೋ ವಾಟ್ ಇಸ್ ದಟ್ ಅಫಿಡವಿಟ್ ಅದೇ ಕೊಡ್ತಿದ್ದೀರಾ ಏನು ಅಂತ ಗೊತ್ತಾ ಅದು ಅಕ್ಸೆಪ್ಟ್ ಯಾಕೆ ಮಾಡಬೇಕು ಏನು ಅನ್ನೋದು ನಿಮಗೆ ಗೊತ್ತಾ ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ ಫೈಲ್ ನೋಡಿ ಹಾ ಸರಿ 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 ಮಧ್ಯಾಹ್ನ ಹಾ 24 ಪಾಸ್ ಓವರ್ ಅಲ್ಲ ಇವಾಗ ಟೈಪ್ ತಗೊಂಡು ಹಾ 24 ಪಾಸ್ ಓವರ್
ಎಷ್ಟಿದೆ
ಇಂಡಸ್ ಲಾನ ಅದಿದೆ ಅದು ಇದೆ ನೀವು ಅಲ್ಲಿ ಕೊಡಿ ಬರ್ಕೊಡ್ತಾರೆ ನೀವೇ ತಗೊಂಡು ಕೊಡ್ಬೇಕು ನಾಳೆ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಲ್ವಾ ಬೇಗ ನೀವೇ ತಗೊಂಡು ನಂಬರ್ ಅಸೋಸಿಯೇಷನ್ ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ ಅಲ್ಲ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಯಾವತ್ತು ಹಾಕಿದ್ರು ಮೆಮೊ ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹೇಳಿ ನಾವು ನಿಮ್ ಮೆಮೊನ್ ಕಳ್ಸಿದೀವಿ ಅಲ್ಲೊಂದು ಬುಕ್ ಇದೆ ಮೆಮೊ ಬುಕ್ ನಿಮ್ ನಂಬರ್ ಹೋಗಿದ್ಯಾ ಇಲ್ವಾ ನೋಡ್ಕೊಳ್ಳಿ, ಅದೊಂದು ಫೋಟೋ ತಗೊಳ್ಳಿ. ಅವ್ರು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ವಾ, ತೋರಿಸಿ. ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್. ಬೆಳಗ್ಗೆ ಏನಾಯ್ತಾ? ವಿಸಿಗೆ ಬನ್ನಿ, ಫೈಲ್ ಸೇರಿಸ್ಬೇಕಾ? ಏನದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ? ಸರ್ 84 ಅಂದ್ರೆ ಸೀರಿಯಲ್ ವೈಸ್ ರೀಚ್ ಆಗಲ್ಲ. ನಮಗ್ ಬರುತ್ತೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ವಲ್ಲ, ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ನನಗೆ. ಇಲ್ಲ ಖಂಡಿತ ಇಲ್ಲ. ಹೌದಾ? ಹಾಗೆ ಚೇಂಜ್ ಆಯ್ತಂತ ಸಿಸ್ಟಮ್ ಚೇಂಜ್ ಮಾಡಿರಲ್ಲ.
14% ಅಲ್ವಾ ಮೇಡಮ್ ವೆಂಕಟೇಶ್
ಕರೆಕ್ಟ್.
ಇದು ರೀಡ್ ಆಗಿರೋದು ರಾಂಗ್ ಆಗಿದೆ.
ನಾನು ಮರ್ಯಾದೆ ಜಡ್ಜ್ಗೆ ಇಲ್ಲಿ ನೋಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರ್ತೀನಿ. ಡೇಟು ಅಲ್ಲಿ ಫೈಲ್ ಎಲ್ಲ ಸ್ಕ್ಯಾನ್ ಹೋಗ್ತಾ ಇದೆ ಸರ್. ಯಾವ ಫೈಲ್ ಸಿಗುತ್ತೆ ಅದನ್ನ ಹಾಕ್ತಾರೆ. ಕೆಲವು ಸತಿ ನಾಳೆನೂ ಬಂದ್ಬಿಡುತ್ತೆ, ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಅಲ್ಲೋ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹೇಳಿ, ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಧಾರವಾಡ ಫಸ್ಟ್ ತೋರ್ಸಕ್ ಬರಲ್ಲ ಅಲ್ಲ ಅದು. ಅಷ್ಟೇ ಅವರೇ ಕೊಟ್ಟಿರ್ತಾರೆ. ಯಾವ ಲಿಸ್ಟ್ ಸರ್? 6 ನಾಟ್ ಬಿಫೋರ್ ಮೀ. ಅದೇ ಅವರೇ ಕೊಟ್ಟಿರ್ತಾರೆ. ಫಸ್ಟ್ ಧಾರವಾಡ ಕಲಬುರ್ಗಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಾಸ್ಟ್.
List 1, serial number 63. The petitioner's counsel has met with a minor accident. May request it to be taken up after 2 weeks.
63.
In list 1 month.
Have you informed the respondent?
I'll inform them.
63.
That is the morning submission.
Ah.
I have objection for the adjournment, but the accident.
Can't do anything. 63.
Inquiry is held up.
The base suffered an accident.
It is going to take some time.
2 weeks. What has
weeks,
happened?
my lord.
What has happened?
I was told that he met with an accident while on the way back from Tumkur. Road accident. Is what I was told.
It's submitted to the arguing counsel for the petitioner has been involved in a road accident. 6-4 and is granted 2 weeks time. Relist on 11th August. Interim order earlier granted is extended till next year.
ಧಾರವಾಡ bench matters. Serial number 1, government advocate.
Appearing for response. Please, Millards. This is review, Millards. Last time, Millards, brought to your lordship's notice that, Millards, at para number 16, Millards, the necessary party, Millards, to the writ petition was Millards.
16.
Yes, Millards. 16 of review petition.
Review petition.
Please.
Twenty-three. It is 23.
Yes.
Please, my lord, I'm appearing for respondent, my lord, in this case, my lord. My lord,
SLO, you not made a party.
my lord, may I make one humble submission before honorable court, my lord? I have filed a memo, my lord, dated 2/7/2026, my lord. It is before honorable. Please, my lord.
No idea number. 27. Yes, 27.
2026, my lord. And at page number 5, my lord, there is a letter issued by the, my lord, land acquisition Hidkal Dam, my lord. It is dated 23/1/2026, my lord. With lordship kindly, may I read it, my lord?
I can't read anything in this letter. It's not legible at all.
Sorry, my lord. My lord, today, my lord, the government is also filed the same documents before honorable court, my lord, but it is not, my lord.
They filed the same document?
Same documents, my lord, but it is not, my lord. They be in the file, my lord. Today only they have also filed same documents, my lord.
Other legible?
Other legible. None legible.
Not legible.
Sorry, my lord. I will, my lord, produce and, my lord, typed copy of these documents.
Even the next documents.
I will find all the documents, my lord, typed copy file ಮಾಡ್ಕೊಡ್ತೀನಿ.
Photocopy ಅಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಆಗಿ ಪ್ರಿಂಟ್ ತೆಗೆದಿದ್ದಾರೆ.
ಹೌದು, that is the reason, my lord. I will file, my lord, a typed copy of these.
And is granted a week's time to file legible copies of documents produced along with the memo dated 2/7/26.
Please,
Mr. Upar, look into those documents. What is your submission on the basis of the documents?
Millards, it seems, Millards, there is no development, Millards, as per the instructions received, Millards. Meanwhile, Millards, also Millards, get instructions from SLO Hidkal Dam.
Lord, already, my lord, this SLO has given the report that, my lord, I am the, my lord, person, my lord, who loses the land in the Hidakal Dam project, my lord. Now, my lord, the deputy commissioner and the
Intention is that the concerned authority is the SLO. SLO has not been made a party. You are required to make SLO a party. These concerned officers cannot pass any orders, is what their contention is.
please, my lord, he has given letter, my lord, ಅದನ್ನ typed copy hastin ಸ್ವಾಮಿತ್ತ ಮುಂದೆ.
Letter ಇರ್ಬೋದಪ್ಪ. That letter doesn't make any difference. He is the authority to pass the order.
He has already, my lord, passed the order, my lord, in that letter, my lord, it is written, my lord. I will produce the, my lord, typed copy, my lord. By
Produce
please, please, my lord.
released on 13th August.
Please.
I'll also tell you.
Serial number 2.
It is also same, my lord.
This memo has come from the AGA.
Yes, my lord. Due to, my lord,
SLO letter in the
same documents were produced, my lord.
This is a little more legible. 23/126.
23/126, my lord.
Yes, this is a little legible.
My lord, at ninth line, my lord, may I read, my lord? ಉಲ್ಲೇಖ ಒಂದರಲ್ಲಿ ತಾವು ನೀಡಿದ ವರದಿಯಂತೆ, my lord, lordship find, my lord.
ತಹಸೀಲ್ದಾರ್ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು. Yes.
Please, my lord. ಉಲ್ಲೇಖ ಒಂದರಲ್ಲಿ ತಾವು ನೀಡಿದ ವರದಿಯಂತೆ ಮಾಸ್ತಿವಳಿ ಗ್ರಾಮದ ರಿಜಿಸ್ಟರ್ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ, ಗ್ರಾಮದ ರಿಜಿಸ್ಟರ್ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ, ಮಾನುಗುತ್ತಿ ಗ್ರಾಮದ ರಿಜಿಸ್ಟರ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ, ಸರ್ಕಾರಿ ಜಮೀನು ಫಾರೆಸ್ಟ್ ಅಂತ ಅದರ ಪಹಣಿ ಕಾಲಂ ನಂಬರ್ 11ರಲ್ಲಿ ನಿರಾಶ್ರಿತರಿಗೆ ಕಾಯ್ದಿರಿಸಲಾಗಿದೆ ಅಂತ ದಾಖಲಾಗಿದ್ದು, ಸದರಿ ಮೇಲ್ಕಾಣಿಸಿದ 3 ಸರ್ವೆ ನಂಬರ್ಗಳ ಪೈಕಿ ರಿಟ್ ಅರ್ಜಿದಾರರಾದ ರುದ್ರಪ್ಪ, ಸೆಕೆಂಡ್ ಒನ್ ಇಸ್ ಬಾಳಪ್ಪ, my lord, ಇವರಿಗೆ 5 ಎಕರೆ 8 ಗುಂಟೆ ಜಮೀನುಗಳನ್ನು ಮಂಜೂರು ಮಾಡುವ ಕುರಿತು ಕೃಷಿ ಯೋಗ್ಯ ಜಮೀನಿದ್ದು ಜಮೀನು ಗುರುತಿಸಿ ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಹುಕ್ಕೇರಿಯವರ ಸಹಯೋಗದೊಂದಿಗೆ ನಕ್ಷೆ ಸಿದ್ಧಪಡಿಸಿ ಅತಿಕ್ರಮಣ ಮುಕ್ತ ಕೃಷಿ ಯೋಗ್ಯವಿದ್ದ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಪಂಚನಾಮೆ ಅತಿ ತುರ್ತಾಗಿ ವರದಿ ನೀಡಲು ಕೋರಿದೆ, my lord. This is the letter issued by the SLO, my lord. My humble submission before honorable court is, my lord, the respondent authorities, sorry, my lord, the petitioner authorities, my lord, only to drag on the, my lord, case, my lord, they filed this review petition, my lord. After proposal of writ appeal, my lord.
Writ petition file ಆಗಿದೆ. The special land acquisition officer has in turn returned to the Tahsildar, Mr. Uppal. The
Yes,
grant
my
has to be made by the Tahsildar, not by the SLO.
Yes, my lord. But SLO is not a party, my lords. Thereafter, my lords, the last document at page number 8, my lords.
Not necessary.
Tahsildar
Not
Hukkeri
necessary.
stated that.
Not
Tahsildar
necessary that
Hukkeri-
SLO has to be a party. The final order has to be passed by Tahsildar.
Only, my lords, for demarcation of the, my lords, land is concerned, my lords, the Tahsildar and ADLR were, my lords, requested to demarcate the land. Wherein, my lords, the
They
Tahsildar
can
has
get
replied.
any input, any report from the SLO. SLO is not required to be a party for this.
But, my lords, the intern letter number, letter at page number 8 would reflect that, my lords, the Tahsildar has requested the land acquisition officer to provide the documents with regard to deforestation of the land which they have
Yes, you collect
provided.
everything and pass orders. Finally, the order has to, grant order has to be passed by Tahsildar, not by SLO.
Yes.
You may
Yes.
require information from so many people. You get it.
Please.
So there's no ground for this review then. Petitioner is state is before this court seeking for review of the order dated 27th February 25. The submission of Shri Praveen Uppal and AGA is that the SLO is not made a party to these proceedings, and as such, the directions have to be issued to SLO to perform certain actions. Without the SLO performing action, the Tahsildar cannot grant the land. A memo has been filed on 27/26, enclosing a letter dated 23/1/26, wherein the SLO has written to the Tahsildar stating that land needs to be identified and granted to the petitioner on account of the acquisition made. The report of the SLO addressed to the Tahsildar and the additional director of land records has been placed on record. Subsequently, the Tahsildar has on 10/2/26 returned to the SLO to identify the land available for allotment, for grant. Any and all information and or actions required of the Tahsildar to be done through the SLO or any officer would have to be got done by the Tahsildar. The granting authority being the Tahsildar, it is not required for the SLO to be a party to these proceedings and or for a direction to the SLO to be issued. The Tahsildar could always request and or direct the concerned to do certain things which are required to be done for the discharge of his duties. In that view of the matter, no ground being made out, the review petition stands dismissed.
Please, both.
Review, same order in 2.
Please, much
Please.
Kalburgi bench matters. Serial number 1, R.V. Nadagowda.
Matter is relating to APMC cases which are to be onboarded to CCMS.
Yes, madam. What has happened?
The affidavit is filed on 15 July 2026. The Principal Secretary of E-Governance has filed an affidavit as per the direction of the Honorable.
Is it done, madam?
It has been
15
done.
June is there.
15
15
July.
June we have. 15 July we don't have.
In July.
And AGA submits that there is a compliance report filed on 15/7/26. Registries they have put up the same and relist on 5th August.
Serial number 2, Rodavira Shetty.
Yes, madam.
This is relating to ex-servicemen's application which are to be digitalized.
Yes,
On
what
the
is
last
happening?
date of occasion, out of 14,000, 7,000 were digitalized. Now it has been instructed to me that more than 10,000 applications have been onboarded. However, I have to receive the formal communication in this regard.
And AGS on instruction submits that the digitalization of more than 10,000 applications have been completed. She seeks for and is granted 8 weeks time to file a further compliance report, released on 24th, 8 weeks time, released on 21st September.
Two 30 matters. List number 2, serial number 1, Nagraj IN.
Short accommodation. Short accommodation. My colleague is appearing.
Yes, but in order. Yes, madam. Yes, sir.
Directions.
They need a copy of this.
Please, ma'am.
And AG has filed an affidavit of the Joint Director of Food and Civil Supplies and Consumer Affairs Department. The same is taken on record. Copy thereof is directed to be furnished to the petitioner and respond number 4.
Para 11, my lord, from para 11. 10 and 11. Why,
So there are 2 authorizations.
please, my lord, 2 authorizations, and insofar as directions passed by my lords,
That will take 6
they have
months.
produced annexure R1, my lord. Some of them are already there in the department website, my lord. Some of them, they require some time to include it, my lord. That is what they have stated in the para 15 onwards. Para 14, 15.
From this, how do we get to know how many they have?
They have produced annexure, my lord, wherein
Really, the allegation is that there are 2 shops.
please, my lord.
But how will we get to know in respect to others? Other people get to know. How many authorization each
That
person?
data is not yet entered in respect of all the district.
That you should be able to see. What you are asking for as regard number of cards, you may take some time.
Please, my lord.
But number of authorization must be available with you.
I'll seek instructions.
That you give us.
Please, my lord.
Both the counsel for the petitioner and respondent for seek for and are granted 10 days time to go through the said affidavit and make the submission. And AGA is also directed to place on record the number of authorization for each of the authorization holder across the state of Karnataka.
Please, my lord.
By next date. Relist on 13th August.
Petitioner may be directed to serve the
Kotilva. Ivagle is biduwadi.
They have not carried out the amendment.
Carry out the amendment also, otherwise your petition will go. 10 days time is granted to carry out the amendment. If the same is not complied with by next date of hearing, petition will be liable to dismiss to non-prosecuted.
Further hearing, serial number 2, Nagaraj Hegde.
Pay for. The last date of hearing, Lord. Honorable Lord, heard for some time. Why Lord temple
Yes.
has been dismissed. For the inquiry report at page number annexure C, my lord. The allegation is, my lord, 2 charges have been framed. One is, my lord, duplication of receipts and tampering of that receipt. For the
no show cause notice has been issued, no show cause notice has not been issued. Straight away, my lord, come to your page number 40, in page number 40.
But you replied to it, the allegations. Show cause notice, what they pointed out was you replied to it.
Correct, my lord. Why, when I have appeared before the inquiry officer, I have given the reply. That has been produced.
So only after considering your reply, the matter is proceeded with. No prejudice has been caused.
Correct. When I have summons has been issued from the inquiry officer, thereafter I appeared. Thereafter, my lord, I have taken the records and given the statement. Reply statement has been given along with, that has been produced, my lord, and it's my humble submission. Kindly give me paragraph number 40.
Paragraph?
In page number 40.
In page 40.
Yes, inquiry report.
Yes.
Second paragraph. ಈ ಪ್ರಕರಣದ ಬಗ್ಗೆ ತಾಂತ್ರಿಕ ವರದಿ ನೀಡಿದ ಶಿವಶಕ್ತಿ ಟೆಕ್ನಾಲಜೀಸ್ ಕುಂದಾಪುರ ಇವರ ವರದಿಯನ್ನು ಗಮನಿಸಲಾಗಿ 1ನೇ ಆಪಾದಿತರು ಸೇವಾ ಕೌಂಟರ್ ಕೆಲಸಕ್ಕೆ ಸೇರಿದ ಹಿಂದಿನ ಅವಧಿಯ ಬ್ಯಾಕಪ್ ಲಭ್ಯವಿದ್ದು 1ನೇ ಆಪಾದಿತ ನೌಕರರು ಕೌಂಟರ್ನಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದ ದಿನಾಂಕದಿಂದ ಯಾವುದೇ ಬ್ಯಾಕಪ್ ಸರ್ವರ್ಗಳಲ್ಲಿ ಉಳಿದಿಲ್ಲವೆಂದು ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಆದರೆ ಸರ್ವರ್ನಲ್ಲಿರುವ ಬ್ಯಾಕಪ್ ವಿವರಗಳನ್ನು 1ನೇ ಆಪಾದಿತರು ನಾಶಪಡಿಸಿದ್ದಾರೆ ಎಂಬುದು ದೃಢಪಟ್ಟಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ 1ನೇ ಆಪಾದಿತರು ಸಾಕ್ಷಿ ನಾಶ ಮಾಡಿರುತ್ತಾರೆ ಎಂಬ ಆರೋಪ ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲ. This is the report of the inquiry. Next, my lord. There are 2 employees, lord, which they have been charged. 2ನೇ ಆಪಾದಿತ ನೌಕರರು ನಕಲಿ ರಶೀದಿಗಳು ವಿತರಣೆಯಾಗಿರುವ ವಿಷಯವನ್ನು ದೂರುದಾರರ ಶ್ರೀ ಜಯರಾಮ್ ಪುಲಿಯಾರ್ ಅವರಿಗೆ ತಿಳಿಸಿದ ಕೂಡಲೇ ಮುಖ್ಯ ಗುಮಾಸ್ತರಿಗೆ ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿರುವಂತೆ ಕೋರಿರುವುದಾಗಿ ಸಾಕ್ಷಿದಾರರ ಹೇಳಿಕೆಯಿಂದ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಅಶೋಕ್ ಕುಂದರ್ ಇವರು ದೇವಸ್ಥಾನದಲ್ಲಿ ಯಾವುದೇ ದೂರುಗಳಿಲ್ಲದಂತೆ ಕೆಲಸ ಮಾಡುತ್ತಿರುವುದಾಗಿ ಸಾಕ್ಷಿದಾರರು ತಿಳಿದಿರುತ್ತಾರೆ. ನಕಲಿ ರಶೀದಿ ವಿತರಣೆ ಮಾಡಿದ ಬಗ್ಗೆ 2ನೇ ಆಪಾದಿತ ನೌಕರರು ವಿಚಾರಣೆ ಮಾಡಲು ಮುಖ್ಯ ಗುಮಾಸ್ತರಿಗೆ ತಿಳಿಸುವುದರಿಂದ ಅವರನ್ನು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ರಾಜೇಶ್ ನಾಯ್ಕ್ ಅವರಿಗೆ ನಕಲಿ ರಶೀದಿ ವಿತರಿಸಲು ಸಹಕರಿಸಿದ್ದಾರೆ ಎಂಬ ಅಂಶ ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲ. Therefore, my lord, second employee, my lord, has been discharged from the charges.
Yes.
So far as this employee, my lord, has been removed from the service. Though it is inquiry report is clearly held, my lord, charges have not been proved. And my lord,
For 2ನೇ ಆಪಾದಿತ ನೀವು 1ನೇ ಆಪಾದಿತ ತಾನೆ?
The charges leveled against the employee, my lord, was one and the same.
Charges are leveled, but
this document, which has been referred by the inquiry officer, it further state, my lords, that has been, I have read out on the last date of hearing, my lord, from the records of the wherein, my lord, in page number 23 of the records, that document where the inquiry officer is referred, my lord, it further state, my lord, that has not been stated in the inquiry report, my lord. It further state, my lord.
Records. Page 23, na?
The records, it was page number 23, my lord, but in this case,
This copy you have not received?
now, just now I have received.
Then you go through this and make your submission as per this, both of you, so that the page number is the same. How many documents do you want to rely on this? Only one or more?
That is only one document.
Only one.
Which
Then
says,
you-
my lord,
Yav page of 23? Page 4. Page 4 is document number 3 is Flexsoft's letter.
yes, my lord.
This is what you want to rely
That is what, my lord, ತಮ್ಮ ಸೂಚನೆಯಂತೆ ಶ್ರೀ ದೇವಳದ ಸೇವಾ ಕೌಂಟರಿಗೆ ಅಳವಡಿಸಿರುವ ಸರ್ವರ್ ಪರಿಶೀಲಿಸಿ ಅದರಲ್ಲಿ ನಕಲಿ ರಶೀದಿ ಪಡೆದ ಬಗ್ಗೆ ಮಾಹಿತಿ ನೀಡುವಂತೆ ಕೋರಿದ್ದು, ಈ ದಿನ ನಾನು ತಮ್ಮ ದೇವಸ್ಥಾನಕ್ಕೆ ಭೇಟಿ ಇತ್ತು ಸರ್ವರ್ ತಪಾಸಣೆ ಮಾಡಿರುತ್ತೇನೆ. ಮಂದಾರ್ತಿ ದುರ್ಗಾ ಪರಮೇಶ್ವರಿ ದೇವಸ್ಥಾನದ ಸೇವಾ ವಿಭಾಗಕ್ಕೆ ಅಳವಡಿಸಿದ ಬ್ಯಾಕಪ್ ಪರಿಶೀಲಿಸಿದಾಗ ದಿನಾಂಕ 30/3/2017 ನಂತರ ನಕಲು ರಶೀದಿ ತೆಗೆದ ಮಾಹಿತಿ ವರದಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ದೇವಳದಲ್ಲಿ ದೊರೆತ ನಕಲಿ ರಶೀದಿಗಳನ್ನು ತೆಗೆದ ಬಗ್ಗೆಯೂ ವರದಿ ಲಭ್ಯವಿಲ್ಲ. ಸೇವಾ ಸರ್ವರ್ನಲ್ಲಿ ಹಾಗೂ ನಂತರದ ಬ್ಯಾಕಪ್ನಲ್ಲಿಯೂ ವರದಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಹೆಚ್ಚಿನ ಮಾಹಿತಿಗಾಗಿ ದೇವಸ್ಥಾನದ ಸೇವಾ ವಿಭಾಗಕ್ಕೆ ಸಾಫ್ಟ್ವೇರ್ ತಯಾರಿಸಿ ಅಳವಡಿಸಿರುವ NIC ಅವರನ್ನು ಸಂಪರ್ಕಿಸಬಹುದು ಎಂದು ವರದಿ ಮಾಡಿ. Who have installed the software have not been examined. That is what the report says. None of the document is available to show that
You have taken a print of the same receipt twice. It is not that you have fabricated with a different number. It is the same receipt you have printed twice and given it to one more devotee.
No,
and collected. That is the allegation against you.
That is Kindly come to my lord, allegation, my lord, kindly come to my allegation, page number 33
Of the petition.
of my petition.
Yes. Yes.
That is allegation, my lord, charges when Rajesh Naik,
Hmm.
ಶ್ರೀ ದುರ್ಗಾ ಪರಮೇಶ್ವರಿ ದೇವಸ್ಥಾನ ಮುಂದಾರ್ತಿ ಬ್ರಹ್ಮಾವರ ತಾಲೂಕು ಉಡುಪಿ ಜಿಲ್ಲೆ ಇವರು ದಿನಾಂಕ 1/5/2017 ದೇವಸ್ಥಾನದ ಸೇವಾ ಕೌಂಟರ್ ಸಿಬ್ಬಂದಿಯಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸೇವಾ ಕೌಂಟರ್ನಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುವಾಗ ಈ ಸೇವಾ ಸಾಫ್ಟ್ವೇರ್ ತಂತ್ರಾಂಶದಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಸೂಪರ್ವೈಸರ್ ಹಾಗೂ ಅಡ್ಮಿನ್ ರವರ ಬಳಕೆದಾರರ ಐಡಿ ಮತ್ತು ಪಾಸ್ವರ್ಡ್ ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಭಕ್ತಾದಿಗಳಿಗೆ ದಿನಾಂಕ 23/8/2018 24/8/2018 ಮತ್ತು 25/8/2018 ನಕಲಿ ಸೇವಾ ರಸೀದಿಗಳನ್ನು ವಿತರಣೆ ಮಾಡಿರುತ್ತಾರೆ. ಇದರಿಂದ ದೇವಸ್ಥಾನದ ಮೇಲಿನಿಂದ ಆದಾಯಕ್ಕೆ ನಷ್ಟ ಉಂಟು ಮಾಡುವುದರಿಂದ ಕರ್ತವ್ಯ ನಿಷ್ಠ ತೋರಿಸದೆ ಭಕ್ತಾದಿಗಳಿಗೆ ಚ್ಯುತಿ ಉಂಟು ಮಾಡಿ ಅವಿಧೇಯತೆ, ನಂಬಿಕೆ ದ್ರೋಹ, ಭಂಡಾರಕ್ಕೆ ಆರ್ಥಿಕ ನಷ್ಟ ಮತ್ತು ಆಸ್ತಿ ನಾಶ ಉಂಟು ಮಾಡಿ ದೇವಸ್ಥಾನದ ಸಂಸ್ಥೆಗಳಿಗೆ ಸರೋಗದ ರೀತಿಯಲ್ಲಿ ಅಪ್ರಾಮಾಣಿಕತೆಯನ್ನು ನಡೆಸಿಕೊಂಡಿದ್ದು ಕರ್ನಾಟಕ ಅಧಿನಿಯಮ 1900. This is the allegation. No document has been placed on record, and none of the other than the employees of the temple, no independent witness has been examined.
Which
And
other
who has
independent?
the PW2, he says, Lord, kindly come to Lord, the cross-examination in the first time, Lord, in the charges of imputation, Lord, only 2 witnesses have been named, but they have examined, Lord, 6 witnesses. Kindly come to Lord, the answer given, who has given the complaint, PW1, at page number 67. 68 is the cross-examination, wherein, my lord, he admits. Question number 6, my lord.
Yes.
ನಾವು ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಪ್ರಸಾದ ಕೌಂಟರ್ನಲ್ಲಿ ನಕಲಿ ರಸೀದಿಗಳು ಸಿಕ್ಕಿದ್ದೆಂದು ತಡವಾಗಿ ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಕಾರಣವೇನು? ದಿನಾಂಕ 23/8/2018 6 ರಸೀದಿಗಳು ಸಿಕ್ಕಾಗ ಈ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳಿಗೆ ಮೌಖಿಕವಾಗಿ ಅವರ ಗಮನ ತಂದಿರುತ್ತೇನೆ. Lord, the charges of imputation doesn't say about anything about the bills, how many bills, how many receipts. The first time, Lord, he says in the cross-examination. ಅದು ಹರಿದ್ಬಿಟ್ಟು ಭಕ್ತಾದಿಗಳಿಗೆ ಕೊಡ್ತೇವೆ ಅಂತ ಒಪ್ಕೊಳ್ತಾರೆ ನಾವು. ಹರಿದ್ಬಿಟ್ಟು ಭಕ್ತಾದಿಗಳಿಗೆ ಕೊಟ್ಟರೆ ಅದು ಆ ರಸೀದಿ ಎಲ್ಲೋಯ್ತು, ಅದು ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್, ದಟ್ ಬಿಲ್ ರಿಸಿಪ್ಟ್ ಹ್ಯಾವ್ ನಾಟ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. He says the said receipt is duplicated. On what basis, my lord? He says, Lord, the software, Lord, has been installed by the NIC. They have to say. That is what the report also says, my lord. None of the receipts are available, and no, Lord, tampering of the receipts. And, my lord, duplication also is not found in the, as per the report I have read out.
Yes.
Therefore, my lord, my humble submission to my lord, none of the witnesses have been supported, except no independent witness have been examined by the. Whereas inquiry report, inquiry officer says, my lord, no independent witness examined insofar as second employee is concerned. So far as first employee is concerned, my lord, he says, my lord, that his charge has been proved. One charge has not been proved according to the inquiry officer. Duplication of receipts is not proved according to the inquiry officer's report. When, my lord, when there is no duplication, how the receipt can be shown? That is what my position.
So from 1/5/2017. Counter 2. Yes. Hmm.
Is given a complaint saying that on 23/8/2018, 6 24/8/2018, 15 applications, and 25/8/2018, 6 applications. But all these are the applications which is available on the record. Which is produced.
Has it been marked? Is it? Yes. As what exhibit is it? ಎಲ್ಲ ಸೇರಿ ಒಂದೇ ನಿಶಾನೆನಾ? ಸೊ ಇದೆಲ್ಲ ನಿಶಾನೆ ಒಂದು ತೋರಿಸಿ.
ಮೂರು ರೀತಿ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಮಾಡೋದು ಫಸ್ಟ್ ಟೈಮ್ they are submitting.
These are the receipts, total 25 receipts. Kindly come to next page.
So it was printed twice.
It is printed twice. Original receipts also available in the record.
Page number? Page number? Beginning of it.
Laminated. Blue color ಮಧ್ಯದಲ್ಲಿ ಲೈಟ್ ಇದೆ ಅದ್ರ ಮಧ್ಯದಲ್ಲಿ ಬರೀತಾರೆ ಡೂಪ್ಲಿಕೇಟ್.
ಎಲ್ಲಿದೆಯಪ್ಪ ಡೂಪ್ಲಿಕೇಟ್ ಅಂತ? It is not seen.
ಲೈಟ್ ಮಧ್ಯದ ಲೈಟ್ ಮಧ್ಯದಲ್ಲಿ ಇಲ್ಲಿ ಬರ್ತದೆ ಇದರಲ್ಲಿ ಬರೋ ತರ ಮಾಡ್ತಾರೆ ಈ ಲೈಟ್ ಮಧ್ಯದಲ್ಲಿ
Yeah. Can't make out here. Oh, okay. Oh. So all of this get covered by the blue band. Yes. ಹುಡುಕಿದ್ರೇನು ಕಾಣಿಸಲ್ಲ.
So plan was printed in the line, that blue line. After that, after the complaint, document number 4 in my compilation. Page 4, document number 3. We requested university because 26 complaint at 25/7, 25/8, and 27/8 we requested this university. ತಮ್ಮ ಸೂಚನೆ ಅಂತೆ ದೇವಾಲಯದ ಸೇವಾ ಕೌನ್ಸಿಲ್ಗೆ ಅಳವಡಿಸಿದ ಪರಿಶೀಲಿಸಿ ಈ ವೆರಿಫೈಡ್ ದಿ saying that whether the data is available.
Hmm.
Document number 5.
Review ನಲ್ಲಿ responded.
They have been suspended.
Review ನಲ್ಲಿ responded.
Document number 6, Your Lordship. FIR, the Deputy Commissioner directed to initiate FIR, Your Lordship. Document number 7, Your Lordship, is a complaint given by executive officer to the station. Document number 8, FIR has been registered on 30th 8 or to 8th of 8. Right number 180. Page 12.
This was on 38/28. 38/2018. Yes.
Page 70, document number 10, charge, charge system.
Yes.
Thereafter, document number 11, page 22, inquiry officer has been appointed. Rule 17. Conduct inquiry. And kindly see page 42. The reply given to
Enquiry report ಎಲ್ಲಿದೆ?
Inquiry report to page 75, document number 20.
Yes.
Page 42 plus the reply given by him, and he admitted that 1 to 4 has been issued. Page 43. So as for his answer, page 40 from page 44, evidence learning.
Hmm.
Evidence loss. Point number 3, ದೇವಸ್ಥಾನದಲ್ಲಿ ಗಣಕಯಂತ್ರ ಉಪಯೋಗಿಸಿದ ಬಗ್ಗೆ ಸಾಫ್ಟ್ವೇರ್ ಸರ್ವಿಸ್ ನನಗೆ ನೀಡಲಾಗಿರುತ್ತೆ. ನನಗೆ ಮತ್ತು ಸಂಜು ಬಿಡಾಲ್ ಅವರಿಗೆ ನೀಡಲಾಗಿದೆ. Admitted software training in page 44.
Hmm.
And other things that he denied ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. So kindly come to page 45. He saying that point number 50, ನಿಮಗೆ ದಿನಾಂಕ 2/1/2019 ನಿಮಗೆ ಯಾರು ಪಟ್ಟಿ ತಯಾರಿಸಿ ನೋಂದಣಿ ಆಗಿದೆ. ಈ ಸೈಟ್ ಸ್ವೀಕರಿಸಲಿಲ್ಲ. ಬಟ್ ನಂತರ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪಡೆದುಕೊಂಡಿದೆ.
ಸ್ವೀಕರಿಸಲಿಲ್ಲ.
ಸ್ವೀಕರಿಸಲಿಲ್ಲ, but he received from the temple because he address was not correct. Came back to the temple subsequently.
ಸ್ವೀಕರಿಸಲಿಲ್ಲ ಅಂದ್ರೆ ರೆಫ್ಯೂಸ್ಡ್. Yes.
Subsequently, as all the other witnesses they have specifically stated that Mysore NIC later is software training and implemented the software in the temple. Is the admin of the temple, the software was available in the temple. And the important university complete given by the Jayam Pujari is witness page number 54.
Yes.
Page 54, document number 16. Point number 4. ನೀವು ಪ್ರಸಾದ ಕೌಂಟರ್ನಲ್ಲಿ ಯಾವಾಗಲಿಂದ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೀರಿ? ದಿನಾಂಕ 23/8/2018, 24/8/2018 ಮತ್ತು 25/8/2018 ಪ್ರಸಾದ ಕೌಂಟರ್ನಲ್ಲಿ ನೀವು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದೀರಾ? ಮೇಳದ ತಿರುಗಾಟ ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ದೇವಾಲಯದ ಕಚೇರಿ ಪ್ರಸಾದ ಕೌಂಟರ್ನಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸಿದ್ದೀರಾ? ಪ್ರಸಾದ ಕೌಂಟರ್ ನಿಮಗೆ ನಕಲಿ ರಸೀದಿ ಯಾವ ದಿನಾಂಕದಂದು ಸಿಕ್ಕಿರುತ್ತದೆ? ದಿನಾಂಕ 23/8/2018, 24/8/2018, 25/8/2018 ಸಿಕ್ಕಿರುತ್ತದೆ. ನೀವು ನಕಲಿ ರಸೀದಿ ಬಂದ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳಿಗೆ ಲಿಖಿತವಾಗಿ ತಿಳಿಸಿದ್ದೀರಿ. ದಿನಾಂಕ 25/8/2018 ಲಿಖಿತ ವರದಿ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಮೇಲಾಧಿಕಾರಿಗಳಿಗೆ ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿದ್ದೀರಾ. ದಿನಾಂಕ 23/8/2018 ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿರುತ್ತೇನೆ. ಯಾವ ಸೇವೆಯ ರಸೀದಿಯನ್ನು ನಕಲು ಮಾಡಿ ನಿಮಗೆ ಸಿಕ್ಕಿರುತ್ತದೆ, ಅದರ ಸೇವಾ ದರ ಎಷ್ಟು? ಹೂವಿನ ಪೂಜೆ ಮತ್ತು ಅಲಂಕಾರ ಪೂಜೆ ಸೇವಕರ ನಕಲು ಸೇವಾ ರಸೀದಿ ಹಿಂದೆ ಬಂದಿರುವ ಬಗ್ಗೆ ಗಮನಕ್ಕೆ ಬಂದಿರಲಿಲ್ಲ. ಇಲ್ಲ. ದಿನಾಂಕ 23/8/2018 ನಕಲಿ ರಸೀದಿ ಆಗುತ್ತಿದೆ ಸರಿಯಾಗಿ ಪರಿಶೀಲಿಸಿ ಎಂದು ಯಾರಾದರೂ ಮಾಹಿತಿ ನೀಡಿರುತ್ತಾರೆ? ಇಲ್ಲ. ಪಾಯಿಂಟ್ ನಂಬರ್ 14 ದೇವಸ್ಥಾನದಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ನಿರ್ವಹಣೆಯನ್ನು ಯಾರು ಮಾಡ್ತಿದ್ದರು? ಈ ಬಗ್ಗೆ ರಾಜೇಶ್ ನಾಯಕ್ ಅವರು ಮೈಸೂರಿಗೆ ತರಬೇತಿಗೆ ಹೋಗಿದ್ದಾರೆ. 2013ರಂದು ಗಣಕಯಂತ್ರ ನಿರ್ವಹಣೆಯನ್ನು ರಾಜೇಶ್ ನಾಯಕ್ ಅವರೇ ಮಾಡುತ್ತಿದ್ದು, ಈ ಬಗ್ಗೆ ತರಬೇತಿ ರಾಜೇಶ್ ನಾಯಕ್ ಅವರೇ ಮೈಸೂರಿಗೆ ಹೋಗಿದ್ದಾರೆ. Then cross examination at page 55. Point number 6 and 7. ತಾವು ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ಪ್ರಸಾದ ಕೌಂಟರ್ನಲ್ಲಿ ನಕಲಿ ರಸೀದಿ ಸಿಕ್ಕಿದೆ ಎಂದು ತಡವಾಗಿ ವರದಿ ಮಾಡಿರುವ ಕಾರಣವೇನು? ದಿನಾಂಕ 23/8/2018ರಂದು 6 ರಸೀದಿ ಸಿಕ್ಕಾಗ ಆ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳಿಗೆ ಮೌಖಿಕವಾಗಿ ಅವರ ಗಮನಕ್ಕೆ ತಂದಿರುತ್ತೇನೆ. ನಕಲಿ ರಸೀದಿಯನ್ನು ನಿಮ್ಮ ಗಮನಕ್ಕೆ ಬಂದ ಮೊದಲ ದಿನವೇ ಏಕೆ ಬರಹದ ಮೂಲಕ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ ಏಕೆ ದೂರು ನೀಡಿಲ್ಲ? ದಿನಾಂಕ 23/8/2018ರಂದು 6 ರಸೀದಿಗಳು ಸಿಕ್ಕಾಗ ಈ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳಿಗೆ ಮೌಖಿಕವಾಗಿ ಮತ್ತು ಅವರ ಗಮನಕ್ಕೆ ತಂದಿರುತ್ತೇನೆ. ಅವರು ಸಾಕ್ಷ್ಯ ಸಂಗ್ರಹದ ಬಗ್ಗೆ ನಕಲಿ ರಸೀದಿಯನ್ನು ಸಂಗ್ರಹಿಸಲು ತಿಳಿಸಿದ್ದರಿಂದ ಈ ಕುರಿತು 2 ದಿನಗಳ ನಂತರ ಅಂದರೆ 24/8/2018ರಂದು 15 ನಕಲಿ ರಸೀದಿ ಹಾಗೂ ದಿನಾಂಕ 25/8/2018ರಂದು 2 ನಕಲಿ ರಸೀದಿ ಆ ದಿನ ನಾನು ಲಿಖಿತವಾಗಿ ದೂರು ನೀಡಿದೆ. Other than this, is not all these then we have produced the exhibits. Ultimately, he filed his written statement at page 67.
Yes.
And 70 is the statement filed by the temple executive officer. On 8/6/2020, at page 75, the report has been submitted to the committee of the temple. Document number 21, page 84. That is the committee temple have taken decision on 19/8/2020. But this decision has not been challenged. As for the act, the management committee is the competent authority to take disciplinary action. Now this order has been not challenged. The order has been challenged at page 86. The communication issued by the executive officer.
Google Mano.
On the basis of the resolution passed by the committee.
Yes.
Subsequent to that, we challenge that the order dated 18/10/2020 passed by the executive officer before the committee at page 89. Thereafter, we file a petition for the court.
So this is challenging the communication.
Please, sir.
Right.
Expedition at page number 96, page document number 35. Office question at page number 100. Allowed and demanded at commission to the page 102, include order. Commission to even the recent order. Connection before the commission Notice has been issued, Rule 17 as per the procedure contemplated under Rule 17 and he participated in the inquiry. The witnesses are also examined before the inquiry. Now
But so far as receipts now have been produced more. Nowhere in the inquiry report the inquiry officer first time Lord they have produced it. I don't know how the second Lord. I don't even have the opportunity to look into the said document. Kindly come to the Lord report whether none of the receipts have been shown in the inquiry report. Page number Lord 32 minutes. Inquiry report.
32 of the petition.
32 of the petition. This is the inquiry report. Note. Kindly go to note paragraph number page number 35. Unnumbered paragraph number 4. 35. Page number 35. Unnumbered ಆರೋಪ ಪಟ್ಟಿಯ ಅನುಬಂಧ 4ರ ಸಾಕ್ಷಿದಾರರಾದ ಪ್ರದೀಪ್ ಶೆಟ್ಟಿ ಇಂಜಿನಿಯರ್ ಶ್ರೀ ದುರ್ಗಾ ಪರಮೇಶ್ವರ ದೇವಸ್ಥಾನ ಮಂದಾರ್ತಿ ಅವರು ದಿನಾಂಕ 15/10/2018ರಂದು ಲಿಖಿತ ವ್ಯಕ್ತಿಯಲ್ಲಿ ನಕಲಿ ರಸೀದಿಗಳನ್ನು ವಿತರಣೆ ಮಾಡಿದ ಬಗ್ಗೆ ಜಯರಾಮ್ ಪೂಜಾರಿ ಅವರು ನೀಡಿದ ದೂರಿನನ್ವಯ ದಾಖಲಿಸಿದ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ವಿಚಾರಣೆಗೆ ಪೊಲೀಸ್ ಇಲಾಖೆಯ ಮಹಜರ್ ಸಂದರ್ಭದಲ್ಲಿ ಸಾಕ್ಷಿದಾರರಾಗಿ ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ. ಸೇವಾ ಕೌಂಟರ್ನಲ್ಲಿ ಆಗುವ ಲೋಪದೋಷ ಡೂಪ್ಲಿಕೇಟ್ ರಸೀದಿಗಳ ವಿತರಣೆ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾದ ಮಾಹಿತಿ ಇಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. 1ನೇ ಆಪಾದಿತರ ರಕ್ಷಣಾ ಸಹಾಯಕರು ನಡೆಸಿದ ಪಾಠಶಾಲೆಯಲ್ಲಿ ಸಹ ಸಾಕ್ಷಿದಾರರು ಸೇವಾ ಕೌಂಟರ್ ಸಣ್ಣ ಕೆಲಸಕ್ಕೂ ಏನು ಸಂಬಂಧ ಇಲ್ಲ ಎಂದು ತನಗೆ ಮಾಹಿತಿ ಇಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. Not he admits not except this nowhere in the inquiry report those documents have been referred. If at all that those documents have been produced, the inquiry officer should have been referred those documents. Why the document has not been referred in the inquiry report? Now, my lord, along with the record, now they are producing. Even I don't have the opportunity to look into the receipts. They are saying, well, it is a duplicate bills. Where they got the receipt, my lord? Who has to say, my lord? The software has been installed by NIC. They have not been examined.
That you already argued. Please don't re-argue. Don't re-argue. Only reply.
Please, my lord. My humble submission is, my lord. I may be permitted to look into those documents. Kindly have tomorrow, my lord. If my lord is
Every time on
receipt, my lord, first time they have produced before this honorable court. Nowhere in the
cross-examination you asked questions on this in cross-examination.
The report
Can't say that.
The document which has been relied upon by the inquiry officer.
Report may not have it, but your cross-examination, you are cross-examined on that.
Lord, kindly come to my lord the cross-examination where Melo says, Lord, he says, Showcase notice sequence illa anta ಹೇಳಿದ್ರು. Where is the document to show that, Lord? They have sent it through post, Lord.
That's your answer.
Correct, Lord. Where is the document, Lord? In the first time, last time that took the document, I have seen the document.
Even if you
come to Lord Showcase notice where now they have tampered, they have written, Lord, her wife has received the notice. Kindly come to. Last time I have read the paper, Lord, that is not there. That was not there. Now today it is there. Kindly come to Lord.
All the allegation that you are making against your employer, you want to continue with the employer.
No, my lord. That is what, my lord. They have written as, my lord, wife has ಬರ್ದಿದ್ದಾರೆ. Last time ಇರಲಿಲ್ಲ, ನಾನು ನೋಡಿದ್ದೇನೆ. ತಾವು ನೋಡಿದ್ದೀರಿ ಸ್ವಾಮಿ. Last time ಬಂದಾಗ ಅದು ಇರಲಿಲ್ಲ. ಇವತ್ತು ಬಂದಿದೆ ಆ ಸಿಗ್ನೇಚರ್.
ಎಲ್ಲಿ ಪೇಜ್ ನಂಬರ್?
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಸ್ವಾಮಿ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ.
ಪೇಜ್ 5.
ಅದ್ರ ಕೆಳಗಡೆ ಅವ್ರ ಹೆಸರು ಹಾಕ್ತಾರೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹೆಸರಿದೆ?
ಶೋಕಾಸ್ ನೋಟಿಸ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಅದು ಇರಲಿಲ್ಲ, ನಾನು ನೋಡಿದೆ, ತಾವು ನೋಡಿದೆ.
ಏನು ಹೆಸರಿದೆ?
ಇಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್.
ಪೇಜ್ ನಂಬರ್ ಯಾವುದು?
ಅವ್ರದಲ್ಲಿ ಪೇಜ್ ನಂಬರ್
7.
ರಕ್ಷಿತಾ ನಾಯಕ್ ಅಂತ ಅವ್ರ ಹೆಂಡತಿ ಹೆಸರಿದೆ ಸ್ವಾಮಿ.
ಅದು ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಲ್ಲ.
ಕರೆಕ್ಟ್. ಬಟ್ ಅಲ್ಲಿ
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 4.
ಎಸ್.
This is ಅಧಿಕೃತ ಜ್ಞಾಪನ ಪತ್ರ, ಅದು ಬೇರೆ. Document number 5 is not showcase notice.
This document, my lord, doesn't refer, my lord, postal. If they have sent through post, or there should be some document. By giving the answer, my lord, inquiry officer may be recorded, my lord, in the manner, but there should be some document Without, my lord, they are admitting, my lord, that it has been sent to speed post. Where is the acknowledgement, my lord, having refused the show cause notice? And,
Yes.
my lord, Rule 17, Rule 17 of the, my lord, Endowment Act, my lord, clearly, my lord, says, my lord, the inquiry has to be completed within 6 months from the date of the suspension. But even, my lord, the inquiry officer himself is not appointed within 6 months. Kindly, my lord, kindly see the date of appointment of the inquiry officer, my lord. Lord, he has been suspended with effect from 28/8/2018. Charges of imputation have been framed on 2/1/2019. The inquiry officer has been appointed, my lord, 18/3/2019. That is after, Lord, 5 months from the date of suspension. Inquiry officer himself has been appointed after 5 months, 5.5 months. And, my lord, inquiry has not been commenced. And 21/5/2019.
But the rule. Rule 17.
Rule 17.
This is for Archakas, other temples. Yes.
Lord, within 6 months they have to completely.
It can be extended by 6 months.
10 months. They have to obtain a permission from the commission, Lord. That document is not forthcoming. They have not obtained any permission for extension of time, Lord. Even, Lord, the inquiry itself is.
Inquiry need not be completed. In suspension is for 6 months.
No, Lord. Kindly come to Lord.
Provided that for any reason, if the inquiry is not completed within the period of 6 months, the committee or man may continue the period of suspension beyond 6 months.
Beyond 6 months.
That is
With
continuance
the
of suspension
with the
is
permission
with the
of
commissioner, not for the inquiry.
Inquiry only. The inquiry is not completed within period of 6 months. The committee or management may, with the permission of the commissioner, continue for a period of suspension beyond the 6 months.
The period of suspension beyond 6 months. There is no need to seek for permission to extend the period of inquiry.
That has not been sought, my lord.
Not required. Suspension you're not on suspension right now. They should have come at that time.
Rules specifically state permission is
For what?
for, my lord, the continuation of the proceeding is beyond 6 months.
Right. Next point to ban.
Lord, and Lord, Rule 17. Lord, provide, Lord, coercive measure has been taken, Lord, by
The council, if you read the provision wrong, we can't help you. Next point.
Lord, that is what, Lord, I want to bring to notice of this one. Lord, Rule 17.
We have seen that.
Uh,
Rule 17.5.
No, not Rule 17.1. No.
Right. 17.1,
17.1 says, Lord, the following penalties may be imposed or on Archika or another temple servants by the committee of management for any disobedience, misconduct, breach of trust, incapacity, so specified that other first measure, they have taken the last measure, removal of employment. Removal from the service is the last measure. No duplication of bills, Lord, has been proved, Lord. Now they are producing it. Lord, my humble submission would be, Lord, I may be provided an opportunity to look into those documents, Lord.
Look into that. We gave you the entire file the other day to look into.
Now, my Lord, the inquiry officer doesn't refer to those documents.
Only fact
And
is,
the commission doesn't refer to
your
documents.
client knows where the duplicate is. We also could not see it. You also could not see it.
Lord, how the duplication of bills have been produced, Lord? Who has given the duplication of bill, my Lord? When I have given the duplication bill to the devotees? Once again, Lord, how the, Lord, duplication bills have been produced before this one, Lord? How they got it, Lord? That has to be said, Lord.
That was explained to them that when they come and give the receipt, ಪ್ರಸಾದ ತಗೊಂಡೋಗಿ receipt ಕೊಟ್ಟರೇನೆ ಪ್ರಸಾದ ಕೊಡೋದು.
ಅವರೇ ಒಪ್ಕೊಳ್ತಾರೆ. ಅವ್ರು ಕೊಟ್ಟಾದ್ಮೇಲೆ ಅದನ್ನ ಹರಿದು ಅವರೊಳಗೆ ಹಾಕಿ ಕಳಿಸ್ತೀವಿ. ಅದನ್ನ ತಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ
ನೋಡಿ
ಹೇಳಿಲ್ಲ.
ಯಾರು ಬೇಡ ಅನ್ನಲ್ಲ, ನೋಡಿ ಮೊನ್ನೆನೂ ಕೊಟ್ಟಿರಿ ಫುಲ್ ಫೈಲ್ ನೋಡಕ್ಕೆ, ಇವತ್ತು ಇನ್ನೊಂದ್ಸತಿ ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ನೋಡಿ. But that won't be a ground for adjournment.
My humble submission would be, my lord, my humble submission would be, my lord, highly coercive measure has been taken by the temple. My lord. This without, my lord, implicating, my lord, following this procedure. My humble submission would be, my lord.
You wanted only censure, they have dismissed you. 17(1), that is what your submission is.
Yes,
Aitu. We are hearing you on that. Complete the argument.
The report itself, my lord, says, my lord, no, there is no duplication of bits. It is not available in the records.
Repeat ಮಾಡಬೇಡಿ, ಮುಗಿಸಿದ್ರ ಅಷ್ಟೇನಾ?
And my lord, kindly come to, my lord, the annexure G
Of your petition.
Annexure G to the petition, my lord.
Page number?
Page number 53, my lord.
53. Yes.
The second respondent has appointed the inquiry officer, my lord, at the first time, after the suspension of 5 months. My lord. That is what the date. And, my lord, an annexure H, page number 55. The second respondent has issued a letter requesting the third respondent to conclude the inquiry. The inquiry itself is not commenced as on 21/5/2019.
Yes.
There are almost, my lord, 1 year gap between from the date of suspension. My humble submission would be, my lord, in the charges of imputation, they only refer, my lord, 2 witnesses, and other 4 witnesses they have not mentioned. And charges of imputation doesn't refer these documents, my lord. How many receipts have been duplicated? How many receipts have been produced? That is also not forthcoming in the charge.
Yes.
Charges of imputation, my lord. And, my lord, these charges of imputation have not been provided. It has been after the request they have provided. And I have no opportunity to cross-examine on the receipts, which has been showing by my learned friend in the records.
Yes.
Therefore, my humble submission would be, my lord, there is no proof of record to implicate the petitioner under the charges. The inquiry officer himself has held one charge is not proved, basing on the report.
Mr. Counsel, you have
That's all.
repeated it 10 times.
That's all.
Everybody is waiting for
That's all.
for their matter. There's some patience, there's limits to it. You can't be doing this kind of.
Sorry, sir.
ನಾಳೆ ನಿಮ್ಮನ್ನ ಅಲ್ಲಿ ಕೂರ್ಸ್ಬಿಟ್ಟು ಅವ್ರು ಯಾರು ನಿಲ್ಸೋಣ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ.
My apology, my apology.
Third, so on.
Lordship,
We are not even wasting time dictating here because it will take away time of people.
My apology.
Lordship, may I make one last submission? Lordship, page 44, insofar as the exhibits are recorded in his statement itself, our evidence, please, Lordship, page 44 only, point number 12 in my compilation, exhibits Nishane 2 and page 46, point number 7, Lordship. Cross examination ಅಲ್ಲೇ ಬಂದಿದೆ ನಿಶಾನೆಗಳು. It is produced before the executive inquiry officer. Please, I'm ready.
Obliged.
Third, Shri Nagaraj Hegde, learned counsel for the petitioner, Shri Harishchandra Muar for respond number 4, reserved.
Obliged.
Records it. We'll return the records later.
Please.
ಇದು ಇದೆಲ್ಲ, you have given the records ವಾಪಸ್.
Please.
Not record. A compilation of photocopy of the original record has been filed. The same is taken on record.
Serial number 3.
My lords.
Petitioner minutes. Yes.
Lords,
Yes, madam.
Yes, my lords. My lords, on the last day, my lords, they have relied upon a judgment of this honorable court. Give me the synopsis. We kindly see the judgment of the, my lords, that synopsis if it is taken, my lords.
Yes. Which judgment are you referring
My
to?
lords, Jayamma,
Yes.
31, my lords.
Yes.
My lords, may kindly turn to page 61 of this judgment. In this matter, my lords, this single judge of this honorable court has interfered with the provisional attachment order on the ground that second proviso was not followed. May kindly come to para 52. Insofar as the contention that the authority has failed to adhere to the statutory mandate provided under second proviso to section 5, the matter requires consideration. As noticed above, there must be a written record of reason to believe on the basis of material that if the property involved in money laundering is not attached, then such non-attachment of the property is likely to frustrate the proceedings under the PMLA. Now, my lords, may kindly turn to page 58. What is this proviso, second proviso?
Yes.
Provided further that notwithstanding anything contained, any property of any person may be attached under this section if the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section has reason to believe on the basis of material in his possession that if such property involved in money laundering is not attached immediately under the said chapter, the non-attachment of the property is likely to frustrate any proceedings under this act. Now, my lord, in this particular case, the reason to believe was not written in the provisional attachment order. May kindly come, my lords, to again to para 62, 61, my lords.
Yes.
As noticed above, there must be a written record of reason to
61.
My lords, page 61, para 53.
Page 61, para 53. Yes.
As noticed above, there must be a written record of reason to believe on the basis of material that if the property involved in money laundering is not attached, then such non-attachment of the property is likely to frustrate the proceedings under the PMLA. A detailed perusal of the order of the provisional attachment order would reveal that the authority no doubt has evaluated evidence relating to commission of offence of money laundering. However, in so far as requirement of second proviso to section 5(1) of PMLA as refers supra, the finding recorded that para 9 of the provisional order does not satisfy the legal requirement. Then, my lords, may kindly come to 55. I have reason to believe that the proceeds of crime involves subject case as discussed in the POA. If the said identified immovable property are not attached under the non-attachment property are likely to frustrate any further proceedings under this act. In addition, if the proceeds of crime which are involved in money laundering are not, I have reason to believe such procedure out further laundered and that it will affect on the financial system and can break the economic backdrop. Except para 9, there is no recording of any finding that the competent authority has reason to believe on the basis of material in his possession that if the property involved in money laundering is not attached immediately, such attachment would likely to frustrate the proceedings under the PMLA. It is necessary where the statute provides for exercise of power in a particular manner. Now, power must be exercised strictly in accordance with such procedure or not at all. Such principle has constantly followed in so and so, so and so. Now, my lords, in this particular, then my lords may kindly come to 65, para 65, page 67. The discussion in the provisional order of attachment relates to material that would throw light on the probable commission of offence of money laundering, which material cannot constitute material for reason to believe as regard a requirement under section proviso of section 5 of PMLA. This is a clear distinction between material that would indicate prima facie commission of offence of money laundering on one hand vis-a-vis the material that would enable the competent authority to entertain reason to believe that the material in possession would necessitate attachment of property involved in money laundering, which if not attached would frustrate the proceedings. Further, it is also necessary to note that sale deeds executed in favor of the petitioner by Muda relate to period from 14/6/2024 until date. The property has not been dealt with. As rightly pointed out by the learned counsel for the petition, there is no possibility of dealing with the property so as to create third-party rights in the light of absence of khata. It could be stated that there is no possibility of dealing with the property so as to frustrate the proceedings under the PMLA. Now, my lords, here the case is put up by the petitioner is that khata is not muted. Therefore, sale is to create third-party right is not possible. My lords, what has been held in this particular case is My lords, may kindly take the petition copy. And my lords, in similar Muda case, the another bench of this honorable court has dismissed the petition.
Whatever you place on record, we'll look into. Similar, if that judgment is
My
not
lords, I have placed on record. I will take.
place it on record, you make your submission.
Yes, yes, my lord, I'll take.
Yes.
May kindly see, my lords, may kindly come to
The
page
petition.
33 of the petition.
Yes.
My lords, I 33, my lords.
Hmm.
The last paragraph, my lords, in page 33.
Yes.
On perusal of bank accounts of Hanuman Mineral, it was found that amount of 2 crore 30 lakhs advanced by Manipal Global Services had been received in its bank account maintained with the Bank of India, Capital Panaji Bank. From this bank account, part of the amount was withdrawn as cash and portion of amount had been diverted to the bank account of Rohan Prakash Lotia and Shankar Mahadevan Iyer. That is petitioner herein, my lords. Now, my lords, receipt of 2 crore 30 lakhs by cash from the by Hanuman Minerals has been diverted in 3 forms, my lords. One is 53 lakhs 80,000 was withdrawn as a cash, which we cannot attach. Then, my lords, 196 lakhs, and out of that 96 lakhs was given to one Phonics International. 32 lakhs 55,000 has been withdrawn. Then, my lord, 17 lakhs was given to this particular petitioner's company. Then, my lords.
What happened to the balance amount?
Please, my lord.
What happened to the balance? 96 plus 53 is 150 plus 17, 167. There must be a balance of nearly around 80 lakhs.
Yes, my lords. We could not trace, my lords. It's not available in the bank account. We have attached, it is 1 rupee.
From Hanuman Minerals, it must have gone out somewhere.
Yes, my lords. From Hanuman Minerals, it has gone. They have withdrawn it as a cash, 53 lakhs 80,000.
53, 96 plus 17.
Yes, my
comes
lords.
to around 167.
Yes, my lords.
What happened to the balance?
It's in bank accounts, this amount is not available, my lords.
Then send it to me. Yes.
May kindly come, my lords, to proceeds of crime 3.6. The
Page?
fact, my lords, before that 36 Roman 3, my lords.
36 Roman 3. Yes.
This is the petitioner, my lords. Shankar Mahadevan, the proprietor of SS Maritime, had cheated the Manipal Global Services, issuing bogus stock certificate to Manipal Global Services Private Limited, clarifying that the jetties pertaining to his concern, located at Alkan Marine, were having 40,000 metric ton of iron ore mines on insistence of Giri Sangapa Jaggal, by receiving consideration of rupees 70 lakhs for his above mentioned collusion in the crime committed. The detail that, my lords, next is proceeds of crime. The details of advance received by Hanuman Minerals are 2 crore 30 lakhs, my lords. This is on account. After several rounds of negotiation between municipal and so, they had returned 10 lakhs only to the company and no further payments were made. Thus, total proceeds of crime derived by Girish Sangapas Jekal, Rohan Prakash Loka and Shankar Mahadevan Iyer by way of cheating works out to be 2 crore 20 lakhs. Now, details of immovable property and movable property in the name of accused person reflecting value of any such property in lieu of proceeds of crime. Lords, we were very specific mentioning that this is the value of any such property.
Yes.
Now, my lords, 38, 2 properties of petitioner is attached. One was purchased in 2004, one is purchased in 2009. The check period, my lords, is from my lords, period in which the crime has initiated is at page 15.
Yes.
As per the charge sheet, my lords, 2.2. As per the charge sheet, Girish Jaggal entered into agreement with the complainant Maritime Global Services Private Limited on 7/7/2009 and 23/3/2010. Now, my lords, we are saying that this is value thereof. Then, my lords, may kindly turn to page 38. One property is 6,97,000. In the next column, we have mentioned value of any such property in lieu of proceeds of crime. Then Shankar Mahadevan Iyer, another 10 lakhs, value of any such property in lieu of proceeds of crime. Then, my lords, totally we could attach only 1 crore 61 lakhs 25,000. Now, we try to attach movable properties, the bank accounts, my lords, the bank accounts that Phoenix International, my lord, serial number 2, which received substantial amount of 1 crore, received a fund of rupees 96 lakhs, had only 1 rupee in his account.
Yes.
Then, my lord's total bank account which is attached is 3,27,223. Then, my lords, next is the second proviso, reason to believe, at page 43.
Yes.
5.1, whereas I have duly considered the facts and circumstances of the case and the material evidence placed before me by the investigating officer in case of ECIR against Hanuman so and so and Shankar Mahadevan Iyer, description of documents. Then, my lords, the next page at 46. Hanuman Minerals entered into an agreement with Manipal Global Private Limited
Come to the proviso 2.
Yes, my lords, may.
This is again only a summary of everything.
Yes, my lords, may kindly come to 49, my lords. 4. Roman 4, my lords.
Yes.
Hence, based on the material placed before me, I have reasons to believe that the accused person so and so have committed the offence of money laundering and immovable and movable properties mentioned in table 7 and 8 respectively, pertaining to so and so reflect value of any such property in their possession as defined under clause U of subsection 1 under section 2 of the PMLA 2000.
PMLA. Yes.
Also, the act of Shankar my lord's next paragraph. 5 lines from the bottom, my lords. Also, the act of Shankar Mahadevan Iyer issuing fake certificates to third party to get his own amount given to Girish also clearly reveals that he may go to the extent to preserve his own interests. Further, most of the properties identified are bank accounts, and if filled unattached, there is a very possibility that the funds lying in the accounts might be diverted or withdrawn. Then, my lords, next paragraph, 4th line from the bottom, the intention of the act is not to let the properties involved in money laundering be available for enjoyment of either of the offenders themselves or for the members of their family, but to confiscate the properties involved in money laundering to the GOI. My lords, then 70, second para, 3 lines from the bottom. If the further, it is also possible that trial of offence both under PMLA also with respect to schedule may take considerable time if power of provisional retirement is not exercised here when there are demands of circumstances and existence of jurisdictional fact. It would result in defeating the very purpose of which the act has been enacted. If the properties are transferred and changed hands, it could lead to creation of bona fide third party interests, which may make it difficult for the authorities to retrieve the same at a later point. Hence, for the reasons I have reasons to believe that if no provisional attachment is made, the proceeds of crime amounting to 1 crore 2 lakhs is likely to be concealed, disposed, parted with, transferred, or dealt with in such a manner that it may result in frustrating the proceedings relating to confiscation under Chapter 3 of PMLA. After having perused the documents available on the record, taking into consideration the facts and circumstances, evidence available on record, including the above said material placed before, I have reason to believe that accused person are in possession of value of property in lieu of proceeds of crime amounting to 1 crore 2 lakhs. Also have reason to believe that if the said properties are not attached immediately under the act, it may result in frustrating proceedings relating to confiscation of crime under the Chapter 3 of the act. So, my lords, that case and this case has quite a bit of difference. Here we have done the financial analysis, bank analysis, and found out that what are the amounts which has been withdrawn as cash which it cannot retrieve. That is the reason, my lords, we have identified these two properties as value thereof and attached it. Now, my lords, I may be kindly take to the judgments which I have relied upon on 15/7. My lords, I had relied upon Amit Suri's judgment in that
15/7.
axis. 15/7/2026, my lords. Amit Suri, I had relied upon Delhi High Court. In that Axis Bank judgment was relied. My lords asked me to produce the Axis Bank judgment.
Memo along with citations. You had relied on.
My lords, 7155 of 2026, my lords, of Delhi High Court, my lords.
7155 of 26 is Bangalore.
Order dated 18 March 2018, my lords.
That is of Karnataka.
That's Karnataka. After that,
My lords, Karnataka High Court judgment is at page,
7155.
yes, my lords, at page 63.
63 of your memo of citation.
Please, my lords.
Sorry, 1375.
The memo of citation has only two
Judgments, my lords.
7155 and 2019 SEC Online Delhi.
Yes, my lords. My lords, I'll take to Delhi High Court at a later point. I'll just show the judgment of this honorable case. Page 63. My lords.
Judgment of this court ends at page 6. Delhi High Court starts at 7 in your memo.
My lords, 7155, my lords, have the judgment.
Your numbering and our numbering are different.
That day,
You're given
445, we filed it out.
What you're given is already 18 March is. You tell us what is the para number in 7155.
Yes, my lords. My lords, the whole judgment is 3 pages. If my lords permit, I'll read this 2 paragraph.
Read what is relevant. Everybody
My
is
lords,
waiting.
petitioners called in question the provisional attachment order dated 2/1/2026. Petitioner contended they had purchased site form number so and so. It is contended Mysore Urban Development Authority without issuing any notification proposing to acquire so and so, so and so. The petitioner submitted the relinquishment deed was executed on 21/2/2023, in terms of which so and so square feet of land was granted to the petitioner vendor. However, in terms of endorsement issued Muda, it was stated that further stay is not taken to confer title. The petitioner vendor questions the correction of the said. My lords, may kindly come to fourth line from the bottom. Out of the said site, they were identified by Muda. The owner conveyed one of the sites to the petitioner in terms of sale deed dated 19/7/2023. It is contended the land was wired in litigation under the provisions of PMLA, that several proceedings were pending before several authorities, and later only the site allotted to the purchaser was provisionally attached under section 5(1). The petition therefore agreed by the said order provision are before this court. Learned counsel for the petitioner contended the petitioner have lawfully purchased the site from the vendor, and that as on the date of purchase there was no proceeding pending, hence the property in question cannot be provisionally attached under section 5(1) of the PMLA. Besides this, he contended that the property cannot be exposed to long-drawn litigation as the property purchased by them is not out of the proceeds of crime. A perusal of the proceeding initiated against the petitioner's property shows that it is under section 5(1) of the PMLA, which is provisional in nature. The right to challenge order of attachment would arise only after an order is passed under section 8 of the PMLA. Therefore, this petition is too premature, and this could be exercise jurisdiction to set at naught the proceedings for provisional attachment of the property. In view of the matter, this petition is dismissed. However, liberty is reserved to the petitioner to challenge the order that may be passed by the adjudicatory authority. Which I'll recent Supreme Court judgment also.
Arguments like that advanced by Mr. Ravi Shankar were
Yes,
considered. There are arguments which have been advanced. On that arguments of the petitioner, you have to make your submission.
Yes, my lords. The first point, what the petitioner argued is that the concurrent bench of this honorable court have said that provisional attachment order can be challenged.
Argued on the basis of Pavana Dibur.
Yes, my
that
lord.
proceeds of crime would
Yes.
have to be established. On Pavana Dibur, you have to make your submission
Yes,
if at all.
My lord, in Pavana Debur, what transpired was that these two properties were the property involved. There were two properties, my lord. Both these properties were, when provisional attachment order was issued, they included as a proceeds of crime directly or indirectly received. But in this case, it is value thereof, because we could not lay hands on the proceeds of crime. We had, my lords, I will take my lords to the Pavana Dibur judgment also to distinguish. Then, my lords,
left to
that
you
is the
what you
reason
want
I have relied upon Amit Suri, my lords. In Amit Suri's judgment, my lords, they have relied upon Axis
Missouri
Bank
is
judgment.
Delhi. They're arguing on Supreme Court judgment.
Yes, my lords.
The Supreme Court judgment is there. You can't refer to any other.
My
High
lord,
Court.
I will distinguish Pavana Dibur, my lords.
Yes, please do.
My lords, may kindly take the synopsis filed by the petitioner.
What do you want us to
At
take?
page 4, my lords,
Yes.
the Pavana Dibur, my lords, at page 16. Acquisition of first and second property.
Yes.
The allegation against the appellant in the complaint is that she purchased the property worth crores, though she did not have the source of income which would generate enough money to buy the subject properties. That's not the case here. The allegation against the appellant is that she allowed and facilitated accused number 1 to conceal and siphon off amounts by using her bank account. Another allegation is that she is shown to have purchased a second property from accused number 1, though she did not have the source to pay the consideration. The allegation is that she allowed accused number 1 to use her bank accounts to facilitate siphoning the proceeds of crime. Another allegation is that both first and second properties have been acquired out of the proceeds of crime. In that case, in provisional attachment order is saying that these two properties were bought out of the proceeds of crime. In this case, we are saying that value thereof. It is not my case that it is acquired out of the funds. We are saying that this is value thereof. The first property ex facie cannot be said to have in connection with the proceeds of crime, as the acts constitute the scheduled offence took place after its acquisition. The case of the appellant is that she possessed a substantial amount, as can be seen from the declaration made by her under the income declaration scheme in 2016 September. Therefore, at the time of acquisition of the second property, more than sufficient money was available with her to acquire the second property. The issue of whether the appellant used tainted money to acquire the second property can be decided only after evidence is adduced. This is not a case where any material is placed on record to show that the sale consideration was paid from a particular bank account of the appellant. Therefore, it is not possible to record a finding at this stage that the second property was not acquired by using proceeds of crime. We also make it clear that we have considered the issue only in the context of applicability of PMLA. We have not dealt with the issue of valuation and illegality of sale deeds. My lord, this judgment of Pavana Dibur has been discussed in Amit Puri. In Amit Puri, the court have gone that value thereof. In value thereof, the Delhi High Court held that even ancestral property can be attached as value thereof. For that purpose, the Delhi High Court relies upon Axis Bank judgment. My lords, on the last date, my lords asked me to produce the Delhi High Court Axis Bank judgment. That, my lords, in the same that.
It is not there.
My lords,
no, this is
Deputy
Delhi.
Director.
This is Delhi, yes. Yes, page 7.
Yes, my lords. Lords, may kindly come to page 58. Page para 171, my lords.
Yes.
The empowered and for Roman 2, my lords, 171 Roman 2.
Yes.
The empowered enforcement officer is expected to assess, even if tentatively, the value of proceeds of crime so as to ensure such proceeds or other assets of equivalent value of the offender of the money laundering are subject to attachment, the equivalent being open to modification in the light of evidence gathering during the investigation. The empowered enforcement officer has the authority of law in the PMLA to attach not only a tainted property, that is to say a property acquired or obtained directly or indirectly from proceeds of crime, proceeds of criminal activity constituting a scheduled offense, but also any other asset or property of equivalent value of the offender of money laundering, the latter not bearing any taint but being alternative attachable property on account of its link or nexus with the offense of money laundering or offender. If the tainted property respecting which there is evidence available to show the same to have been derived or obtained as a result of criminal relating schedule of is not traceable, or the same for some reason cannot be reached, or to extent found is deficient, the empowered enforcement officer may attach any other assets, the alternate attachable property or deemed tainted property of the person accused of or charged with offense money laundering, provided it is near or equivalent in the value of the former, the order of confiscation being restricted to take over by the government of illicit gains of crime. Now, my lords, this judgment and Pavana Degur and Prakash Industries has been relied upon in Amit Suri's judgment by the Delhi High Court. Now, my lords, I may be permitted to read the Prakash Industries judgment.
Is there a Supreme Court judgment?
Yes, my lords, there is a Supreme Court judgment also in that point.
Don't multiply the judgments.
My lords, to make it clear as to value thereof, my lords, only to that extent. The difference between that Pavana Degur, it says that it's a directly, indirectly procured from the
all
fund.
these judgments they are referring to a Supreme Court judgment.
Please, ma'am.
So you should know what you have to refer to.
My lord, this is 2026 SSC Online Supreme Court 161, where, my lords, the Vijay Madanlal has been discussed.
Yes. Spara?
My lords, my lords, may kindly turn to, just go back to the main page. May turn to para 19. The definition of proceeds of crime under section 21U of the PMLA is wide enough to include property which is equivalent in the value to the property that is directly or indirectly obtained from a criminal activity relating to the scheduled offense. Thus, such a property can also be attached if the proceeds of crime as such are not otherwise available. Section 21U of the PMLA, despite being a definition clause, indicates the very objective of the enactment to secure proceeds of crime in any form. The scope and applicability of the provisions has been dealt with by this court in case of Vijay Madanlal. Then, my lords, may kindly come to my lords 172 extract of Vijay Madanlal, my lords.
172.
My lords, Vijay Madanlal judgments are culled out. 172, my lords.
Page number 7, my lords. The page number is on the top of the page.
Yes, page number 7, 172.
7, my lords. The last line, the definition of property as in section 21V is equally wide enough to encompass the value of the property of proceeds of crime. Such interpretation would further the legislative intent to recover the proceeds of crime investing in the central government for effective prevention of money laundering. We find in force in the stand taken by Union of India that the objective of enacting the 2002 Act was the attachment and confiscation of proceeds of crime, which is quite essential so as to combat the evil of money laundering. The second proviso therefore addresses the broad objective of 2002 Act to reach the proceeds of crime, whatever name they are kept by, whosoever they are held. The buttressed reliance has been made to so and so, so and so, so and so. Now, my lords, in this case, the special court had confirmed the confiscation order. The court said, let it follow the course provided under the Act, let the adjudicatory authority decide. So, my lords, this judgment clarifies that value thereof can also be attached. And my provisional attachment order doesn't say that it is obtained out of the proceeds of crime. It says it's a value thereof because I could not retrieve.
Yes. Yes. Supreme Court judgment is there.
Lords, I have seen this judgment. Yesterday night, Lords, I looked into this judgment. Lords, may kindly see what has been extracted. Can I pursue your Lords? May kindly come to paragraph 19. Number 19.
19.
Yes. The definition proceeds of crime.
Yes.
Lords, in that, the definition proceeds of crime under 21U is wide enough to include a property which is equivalent in value of the property that is directly or indirectly obtained from a criminal activity relating to the schedule offense. Thus, thus such a property can also be attached if the proceeds of the crime as such are not otherwise available. 21U of the PMLA, despite being a definition clause, indicates the very object of the enactment to secure proceeds of crime in any form. The scope and applicability of the provision has been succinctly dealt with by this court in the case of Vijay Madan Lal Chaudhary. Lords, Vijay Madan Lal Chaudhary is what is laid upon. Now, your Lords may kindly see that the highlighted portion, the fact that is also includes any property which may directly or indirectly be derived as a result of any criminal activity relatable to the schedule offense does not transcend beyond the original provision. In that, the word relating to, associated with, has to do with, used in the main provision is a present particle of a word relate, and the word relatable to is only an adjective. The thrust on the original provision itself is to indicate that any property is derived or obtained directly or indirectly as a result of criminal activity concerning the schedule offense, the same be regarded as proceeds of crime. In other words, property in whatever form mentioned in 215 is or can be linked to criminal activity relatable to or relatable to schedule offense must be regarded as proceeds of the crime for the purpose of the 2002 Act. It must follow that explanation inserted in 2019 is merely clarificatory and read statement. 106 minutes in Vijay Madan Lal Chaudhary's case. Proceeds of crime being the core of the ingredient constituting the offense of money laundering, that expression needs to be construed strictly. In that, all properties recovered or attached by the investigating agency in connection with the criminal activity relating to a schedule offense under the general law cannot be regarded as proceeds of crime. There may be cases where the property involved in the commission of the schedule offense attached by the investigating agency dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of so and so long as the whole or some of the property has been derived or obtained by any person as a result of the criminal activity relating to the schedule offense to be the proceeds of crime. Therefore, the property must be derived or obtained directly or indirectly as a result of the criminal activity relating to the schedule offense. To put it differently, the vehicle used in commission of the schedule offense may be attached as property. I'll skip that, then again the highlighted portion. For being regarded as proceeds of crime, the property associated with the schedule offense must have been derived or obtained by a person as a result of criminal activity relating to the schedule offense concerned. This distinction must be borne in mind while reckoning any property referred to in the schedule offense as proceeds of crime for the purpose of 2002 Act. Dealing with proceeds of crime by way of any process or activity constitutes an offense. Lords, I'll just pause here. Lords, may kindly go to the provision itself. Lord, this last portion, Lords, may kindly go to the provision. 21U.
Yes.
Proceeds of crime means, Lords, I'll just say this. First category, any property derived or obtained directly or indirectly by itself, once it is qualified in the earlier clause as a property derived or obtained, my lords, lords will see that there is no. Now, lords may kindly see the last portion, my lords, of this judgment, which I am reading at page number 6. For being regarded as proceeds of crime, the property associated with the schedule offence must have been derived or obtained by a person as a result of the criminal activity relating to the schedule offence concerned. This distinction should be borne in mind while reckoning any property referred to in the schedule offence as proceeds of crime for the purpose of 2002 Act. This is essentially what the Supreme Court said. That any property, my lords, unless it is relatable to the crime, there is no question, because lords, where does the offence start? Under the PMLA Act, the offence starts with the proceeds of the crime being in the hands of one person in relation to the schedule offence. That is when the offence starts. Lords, now I go to the basic principles either under Article 20 of the Constitution or coming back even to the extended principles under Article 21. If I am holding a property at a point of time, then when it was not an offence, where is any question of me being lugged into, my lords, a situation where it should be treated as an offence? Very basic principles. Now, lots of may come.
Such property could also be money.
Lords, that's the reason. I'll go to the next point also, my lords. Now, what happens? It can be anything. Now, I read only first two things. My lords, what happens? This page 106 referred to a situation where, lords, let us assume that is the reason why I gave an example. Lords, with reference to Madan Lal Chaudhary's case only, I had given this example. Lords, let us assume there is an allegation that I have defrauded somebody of 1 crore. I purchase a property worth 100 crores. Now they want to attach the property because there's nothing else. That 1 crore I have invested here only. Proceeds of crime. Can they attach the property of worth 100 crores? They can't attach it. Now what they are required to do is, they are required to attach the value thereof, which is relatable to the crime. They can't say that I'll go and come and attach your 100 crores worth of property because you are alleged of swindling or holding the proceeds of crime to an extent of 1 crore rupees. Now, lords, may kindly come to the next part of it. Very interesting, lords. It's such a comprehensive definition. Now, lords, will kindly see what is the next part. I deliberately held it back because what gives clarity is the next part of this definition. Or the value of any such property, or where such property is held or held outside the country. Which property? Not any property. Such property refers to the property which is derived out of the proceeds of crime, directly or indirectly. It may even be converted. That's what the Supreme Court in Madan Lal Chaudhary's case itself said is, let us assume that, as I said, 1 crore I take it out in the nature of cash or in the nature of some commitment by means of account transfer. I convert this into the nature of a property, an immovable property. I purchase a car, I purchase a Porsche car. They can attach that property once they relate it to the proceeds of the crime. It is not the same property which is actually the proceeds of the crime, but is converted indirectly. Now the second part of the third part of the definition makes it very clear. Three things. One, the entirety of such property which is derived out of or obtained out of this proceeds of the crime, or the value of any such property. Any such property means The property derived or obtained directly or indirectly from the proceeds of the crime. Milords, now, if this is not the definition, Milords, let us assume, I wanted to ask this question to myself. Under Article 20 of the Constitution, if I have acquired any property in the year 2004, 2007, 2009, when the allegation is made in the year 2012, holding of this property was never a crime. Now, holding of this property for the purpose of confiscation is to be treated as a crime under the PMLA Act, because unless there is an offense against me under the PMLA Act, there is no question of attaching my properties. If the offense is commencing from 2012, Lords, after the act comes into force, now the allegation is pertaining to 2012. If the allegation comes into existence in the year 2012, any property held by me, Milords, if it is to be treated or tainted with the allegation that it is subject matter of an offense, it violates Article 20. Such an interpretation militates against the very concept under Article 20. This is definitely, Milords, certainly not the objective. Whatever they are arguing, Milords, is to say that all right, you may not have acquired any property from out of the proceeds of the crime. We are unable to receive this 17 lakhs. The proceed, ultimately, it should be in his hands in any form. Now, we will attach a property which is not the proceeds of the crime as long as it is the value of the property. That is the argument advanced. Where are they getting it? From which language of this section are they getting it? Because the offense starts from the fact that I hold the proceeds of crime. After that, what happens is what they're entitled to reach out. Before that, whatever has happened, Milords, is not their concern, because the offense itself is not there till that time. So first there should be an offense for the purpose of the jurisdiction to start.
Go forward, don't repeat
Now,
it.
Milords, kindly have a look at the next judgment, next paragraph, 107. Milords, definition what I indicated. Be it noted that the definition clause includes any property derived or obtained directly, indirectly as well. This would include property derived or obtained from the sale proceeds or in a given case in lieu of the exchange of the property, which has been directly derived or obtained as a result of the criminal activity related to scheduled offense. In the context of explanation in the 2019 to the definition of the expression proceeds of crime, it would inevitably include other property which may not have been derived or obtained as a result of criminal activity relatable to the schedule offense. This is how it is. What is meant by indirect? That is what is defined under 107, paragraph number 107 in Madan Lal Chaudhary's case. As noticed from the definition, it essentially refers to any property, including abroad derived or obtained directly or indirectly. Explanation in 2019 in no way travels beyond the intent of tracking and reaching up to the property derived or obtained directly or indirectly as a result of the criminal activity relating to the schedule offense. Therefore, the explanation is in the nature of clarification and not to increase the width of the main definition, proceeds of crime. The definition of property also contains explanation which is for the removal of doubts to clarify the term property includes any property of any kind. But just that 3 lines before that makes it very clear. Object is to track the property derived as a proceeds of the crime in any form. Next, in earlier part of this judgment, we have already noted that every crime property need not be termed as proceeds of crime, but converse may be true. Additionally, some other property, if purchased or derived from the proceeds of crime, even if such subsequently acquired property must be regarded as tainted property and actionable under the Act, for it would become the property for the purpose of taking action in 2002 Act, which is to be being used in the commission of an offence of money laundering. Such purposive interpretation would be necessary to uphold the purpose. Then 172 is very important. That's essentially what brings about the parity between the second part and the third part of the definition 2(1)(u). It was also urged before us that the attachment of the property must be equivalent in value of the proceeds of the crime only if proceeds of the crime are situated outside India. This argument, in our opinion, is tenuous, for the definition proceeds of crime is wide enough to not only refer to the property derived or obtained as a result of criminal activity related to the scheduled offense, but also of the value of any such property if the property is taken or held outside the country. Even in such a case, property equivalent in value held within the country or abroad can be proceeded with. The definition of property in 2(1)(v) is equally wide enough to encompass the value of the property of proceeds of crime. Now your lords may kindly see 2(1)(v) is property. It says that it includes all forms of property. The Madan Lal Chaudhary's case put shackles on the very definition of the word property to be understood as a property which is the proceeds of crime. Lords, now this is a judgment, my lords. Yesterday night I was going through this judgment. Madan Lal Chaudhary's is merely reiterated in this judgment with Madan Lal Chaudhary's case. Now, if your lords were to see Pavna Dibbur's case dealt with a very specific situation as to whether a property which is attached or for which provisional attachment is made, when acquired prior to the alleged offence having been committed, could be subject matter of an order under Section 5, and that is all what was considered. Two properties were there. One property, the Supreme Court said, it is acquired prior to the date having no semblance of relativity with the proceeds of the crime, because proceeds of the crime comes later and what the property is purchased earlier. Therefore, you can't attach the first property. Second property, they say that it is relatable because it's a bank account. Some money has gone there. So value thereof can be attached. That is Pavna Dibbur's case. Now, so far as maintainability is concerned, there is a fully considered view expressed by a coordinate bench. Now, one subsequent development which has taken place, which is not placed on record, is that after filing of this petition, an interim order was granted. There was a challenge to the proceedings before the under Section 482. That's 528 minutes of the Act. There, an interim order is granted. Then again, a question came about as to whether ED can parallelly proceed in respect of the provisions of the PMLA Act when the predicate offence is state. That was a question which was raised. Can I just pursue it, Lords? May I kindly have a look at this judgment, Lords? Madam, please. Lords, Vijay Madan Lal Chaudhary's case is referred to extensively in para 13. At page 467, Lords, the Vijay Madan Lal Chaudhary's case, para 467 is extracted. Lords, may I kindly have a look at 5D at page number 15. The offence, my lords, 5D, my lords, that's at 550, page number 15, the highlighted portion. Yes. The offence under Section 3 of the 2002 Act is dependent on illegal gain of property as a result of criminal activity relating to a scheduled offence. It is concerning the process or activity connected with such property which constitutes the offence in the money laundering. Authorities under the 2002 Act cannot prosecute any person on notional basis or on the assumption that a scheduled offence has been committed unless it is so registered with the jurisdictional police and or pending inquiry or trial, including by way of criminal complaint before the competent forum. If the person is finally discharged, acquitted of the scheduled offence or the criminal case against him is quashed, the court or competent jurisdiction, there can be no offence of money laundering against him or any one claiming such property being the property linked to stated scheduled offence. Section 5 of the Act is constitutionally valid. It provides for balancing the arrangement to secure the interest of the person, as also ensures the proceeds of the crime remain available to be dealt with in the manner provided in 2002 Act. The procedural safeguards are delineated. I'll not trouble your lords with other observations. Now, lords may kindly see at page number 20, para 14. In these circumstances, the offence alleged under the provisions of the PMLA cannot be sustained and cannot be permitted to be continued. Therefore, if the allegations in the predicate offences are considered to be the flesh and offences under the PMLA is the blood, therefore, if the predicate offence is not permitted to move forward, the impugned proceedings cannot. It would have been altogether a different circumstance if the petitioners were well acquitted of the offences in the IPC or any other predicate offence to which the offence under the PMLA is linked. The situation in case on hand is not with regard to acquittal. However, the proceedings are stayed. Therefore, they are eclipsed and not extinguished. The Apex Court does not deal with circumstances as to what should happen in a case where it's eclipsed. The Apex Court only dealt with the situation where there is an extinguishment of the predicate offence. Therefore, it is necessary to consider taking a cue from the findings of the Apex Court as to whether the attachment order should be permitted to be confirmed or otherwise. It cannot be disputed that at a later point in time, if the petitioners are acquitted, no proceedings under the ECIR can continue. In the event they are convicted, it's always open for the Enforcement Directorate to pass orders on the attachment conviction as the case would be. If that be right of the Enforcement Directorate, since there is no determination of crime, of so and so in the light of the interim order being granted by this court, so long as the interim order is in operation, impugned proceedings of attachment in considered view of this court cannot be permitted to continue, failing which it would run completely counter to the findings of the apex court. In somewhat similar circumstance, a division bench of the High Court in Madras High Court in Shanmugam's case considers this very point as to what would be the effect of stay order and held as follows. Lords, in that, if your lords were to see page number 27. Therefore, the impugned proceedings, summons do not have any legal sanctity. Lordship gets it, Lords, the highlighted portion. Interim order of stay granted will be subject to final orders in the main proceedings, after which the eclipse would also wane away. In such circumstances, we are not inclined to enter upon the merits and demerits of the proceedings initiated by department, as it is at the stage of budding. It may either blossom into a full flower or wither away. Hence, we leave it open all the questions that are raised on the merits and demerits of the proceedings initiated by the respondent to be dealt with in appropriate proceedings. Generally, the summons are issued for appearance of party on a particular date. If the party does not appear on the given date, fresh summons demanding appearance of the person have to be issued. In the present cases, in view of the reasonings and findings as stated supra, the last of the summons issued by the petitioners on their appearance have elapsed. Therefore, we have concluded that in view of the quashing of the proceedings in CC number so and so and staying of proceedings in number so and so, as highlighted, schedule offence for the present is eclipsed, suspended, or to stop operating during the period of stay. The respondent department has to await the finality of the said proceedings. Needless to mention, if the proceedings in so and so are quashed pursuant to the orders of the applications filed by the respective persons to quash the proceedings, in which event the respondent cannot step in or initiate any proceedings under the Prevention of Money Laundering Act as held by the Honorable Supreme Court in Vijay Madan Lal Chaudhary so and so. Lords, and then, my lords, the submission is at paragraph number 18.
You got a stay in your
Yes,
mind.
we have a stay, my lords.
Why have you not pointed out till now?
Lords, after filing of this petition, my lords, he had.
That was the first thing. Now
I
you
know, my
should
lords,
have
that's
pointed out.
essentially what I told him. Lords, I'll file it along with a memo. Lords, I'll share a copy with my
We are also not aware.
And even if so much of Pavana Dipu.
Mr. Ravi Shankar is saying he was also not aware.
Now, the morning they told me, my lords, that this is the, my lords, ultimately, my lords, what is required to be done by them is that in the event if there is any property which is relatable to the proceeds of the crime, no difficulty, they are entitled to proceed. Yes.
The Madras High
That's the
Court says
judgment.
so. The coordinate bench also says that once it is stayed. Yes.
At page number 21.
Yes.
Even if an accused shown in the complaint under PMLA is not an accused in the schedule offence,
That
he
is
will
a
benefit.
different. That's a different.
Yes, my lord. Even the, my lord, there are
The
judgments of.
predicate offence is quashed.
Yes, my lord.
There are judgments of coordinate bench of this court saying that PMLA cannot continue.
Yes, yes.
Now this judgment is, even if a stay is there, Madras High Court has also said that.
Yes, my lord.
You cannot continue
My lord, there
until
are.
the stay is vacated or.
My lord, the jurisprudence have developed. I will place on record those judgments where even if stay in the predicate offence, provisional attachment order can proceed. Attachment order can proceed.
45 minutes.
My lord, at least we have proceeded from value thereof, my
Now
lord.
again you'll do
Lords,
a
that's the
recap.
reason. Lords,
My lord,
this is the
this
reason
if
why
it
I
was-
said,
if
Lords,
it
it
was
is
so
simple.
long-
Get ready with everything and address argument. Everybody is.
My lords, we
waiting.
didn't know that there is this argument is going to get canvassed.
2-1 new, my lords, is such simple provision that it says that value of such property.
Yes,
If the
when we-
enforcement directorate does not want to understand the value of such property, my lords, which is very explicitly spelled about, 2 times this such property is used.
When will you address arguments?
My lords,
I have concluded, my lords. I have nothing further to say.
My lords, may have it. It's what 21st, 24th, my lords.
24 at the request. At the request of
2:30.
respondent. Relist on 24th at 2:30 p.m. Interim order
order
earlier
will
granted
also-
is extended till next date.
Serial number 4. Chandraprabha TS.
Petitioners Council. Yes, Mr. Kambi.
My lord.
Yes, you are.
With my lord's kind permission, my lord, I may be permitted to appear through VC, my lord.
As long as you appear, we are fine. Yes, Mr.
Lord, in this, I have to, my lord, amend the prayer, because subsequently, my lord, I have filed an application for modification, my lord, which is also produced as an annexure. Our prayer
Filed an application for modification of the order.
Modification of the order and, my lord, modification of the plan itself. That prayer, my lord, has
Modification of the plan or modification of the order?
Plan, my lord.
Plan is different. We can take it up. Modification of order would have to go to the bench which had passed the order.
Correct. Only thing is, my lord, if this application is allowed, then, my lord, it will have some ramification on that.
What is the application?
Prayer, my lord, I have to seek. Because now what has happened is,
You filed the amendment application or yet to file?
Yet to file, my lord.
And filed.
They are not received.
They are not filed it only.
I'll give it.
When will you file?
My lord, give me 10 days time, my lord.
My lord, can I make some submissions?
Yes.
The petitioner had already submitted an application in the month of December 2025. And as per the order of the Chief Commissioner, the statutory appellate authority, none of the amendments what he is seeking shelter under is not applicable to him. Hence, the ADTP, who is the granting authority, had clearly stated that and rejected his application in December itself.
What application?
The modified sanction plan that has been produced in my memo of 5 January 2026 this year, my lord. Can I request the court to kindly peruse that?
5th January
5th January 2026. So it is clearly stated none of these amendments can be taken shelter of by the petitioner. In fact, that was the reason why we had moved a vacation of stay.
One more under hinge. Under what provision of law?
Your application for modification is already rejected.
It's already been rejected.
Lord, there is another application which had been filed.
There's the same application, my lord. There is no new application on record till date. That is what we have found out from the ADTP's office. I believe the respondent 1 to 3 could vouch for that.
Yes, Lord, please have it next week. I'll show that because our we have filed that, under the, Lord, the amendment to the Town and Country Planning Act. Like we can, Lord, add, Lord, that additional, Lord, FAR. That is permissible. On the application hakidare. That's all that I'm saying.
16, 12, 25.
Adu bere. Amel hakidare. Subsequently, they have filed. Even the, Lord, the GBA, the 249 of the Greater Bangalore Governance Act also, Lord, provides for, Lord, that.
If it can be brought in accordance with the building bylaws, yes.
My lord, can I make submission after that, man?
Mr. Party in person.
I understand,
Not
man.
saying
Sorry.
anything.
I apologize.
You are a party in person.
I will finish. I'll wait for them.
Interrupting every time.
No, my lord, no. Sorry.
Yes.
In fact, I shouldn't say that. His own house, he's my neighbor. His own house, my lord, there's illegality and the corporation has passed some orders. If you want to bring all that to your lordships. Anyway, that's a different thing altogether. But I have filed, my lord, an application for, my lord.
In LB jurisdiction, if you are not good with your neighbor.
I agree with you. This is what will happen. Both of them, my lord, are fighting like this.
So at least because of that, you have to be good to the neighbor.
I know, of course, my lord, the city will be better.
The submission of Shri Udayalal.
My lord, can I request you to kindly allow me to make my submission, my lord?
Yes, please.
My lord, I will submit this amendment, what he is referring to.
We can't hear you on a hypothetical basis.
No, he has told that PWCC amendment. I'm only referring to those. The premium FAR is not applicable to him. It has already been written in the final order of the statutory appeal because his property is 1080 square meters, which is more than 11,000 square feet. None of these amendments can be taken shelter to by the petitioner. This amendment is only for up to 500 square meters.
Mr. Kuber, we are not in the mood of demolishing any building just because you as a neighbor don't like him.
No, my lord.
By what the law is.
Yes, that's what I am also
And
explaining.
if you have a loud voice and you scream,
No,
it
man,
doesn't-
I can switch off the.
it doesn't make any difference. And please don't interrupt unnecessarily.
I'm sorry for interrupting. Now can I make the submission?
You have made your submission. What more?
This is only for up to 500 square meters.
We'll consider it once the application comes before us, not before that. Can we say you are going to do that when you go out of the court and then pass any order?
No, my lord, kindly turn to Annex A, what they themselves have submitted.
There's a problem when you don't know law, you don't know the court decorum.
Lord, I may not know the
You
court
may-
decorum, but
you may as well-
I have graduated in law, my lord.
Then it is even worse.
That's true, my lord, that's true.
If that is what,
My lord, can I make humble submission? Please turn to Annex A.
for what reason, Mr. Kuber?
My lord, it has been clearly stated that these amendments have been pressed into service in the statutory appeal.
Now, if you are going to persist again, we'll refer it back to the party in person committee for revocation of your permission. Udavala and Senior Counsel submits that apart from the application dated 25/11/25 for modification of plan, there's one more application which has been filed, which is pending consideration by the GBA. He seeks for and is granted a week's time to place the same on record. Relist on 5th August. Please.
May I please request for 230 again?
This is in 230 list. So it will repeat in 230.
Also let me
You know?
know.
Yes.
Much of
It's all right. Interim order earlier granted is extended till list.
And let the, I have supplied a IA for vacating the stay, my lord. Can it be detached with the main and the current at least?
We will detach and keep it aside. You should know what submission you are making.
Serial number
Yes.
5.
8 months since we have started this litigation.
Yes.
Serial number 5, Shanta Kumar.
Madam. What is the position of law?
Can I just show few documents, and we have one compilation, I'll pass it on. Let's the counter which they filed, my lords. The threat assessment report. The lordships will have it at
Threat assessment report.
the state. It should be in page number 7, my lords. 11/7/20. I'm sorry, yesterday they filed affidavit. Counter.
There is objections that they have filed yesterday.
Yesterday, my lord. It's
No,
called as an
objection to threat assessment you have filed. Threat assessment.
ಅಲ್ಲ ಅವರೇ ಹಾಕಿರೋದು ಅವ್ರು ಮುಂಚೆ ಖಾಲಿ they had just passed it on yesterday with the affidavit they passed on. I have filed objections to that. What happened on the last date of hearing?
The objection that you have filed, affidavit along with annexures is what they have filed yesterday.
Yesterday, my lord.
Yes.
The same
There
thing
is
they had
the
filed
affidavit
earlier.
of the Assistant Commissioner of Police.
Please, my lords.
Yes.
Lords, in that, if your lordship kindly come to page 7, my lords, in that. It is a report of 11th of July 2026. Lordships have that, my lords. In that, my lords, what they say, if your lordship sees, in the first para, they say about the order passed by this court.
At page 7.
Yes.
Annexure R2.
Annexure R2. Yes, it's marked as Annexure R2, my lords.
Yes. Ashok Nagar Police Thane.
Howdu.
So it's 32 of 25.
Please, my lords. First para is, my lords, that the order for threat assessment. Second para they refer to, my lords, is about the incident where I am accused, my lords, in the offense is the second para. Third para, my lords, about the same thing where the dishonorable court has granted a stay insofar as I am accused in that offence. Then, my lords, fourth para, they talk about the earlier writ petition where I had given my representations. 4, 5, 6 is that. Then, my lords, inspection at, it is at para 6, after culling out, my lords, page 10, after culling out the previous writ petition order, at internal page 10 of that, running page 10. Then, my lords, they talk about the spot inspection conducted on 16/4/2026. That's after culling out the order, my lords.
Yes.
16/4 they say, ಸುತ್ತಮುತ್ತ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದೀವಿ, ಯಾವುದು ಬೆದರಿಕೆ ಇಲ್ಲ ಅಂತ ದೇ ರೈಟ್, my lords. ಲಾಸ್ಟ್ ಲೈನ್, ಇಫ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ ಇನ್ ದಟ್, ಪೇಜ್ 10 ಇಂದ ಶುರುವಾಗುತ್ತೆ. ಅರ್ಜಿದಾರರವರು ಸೂಚಿಸಿರುವ ವಿಳಾಸದಲ್ಲಿ, ಯು ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಹ್ಯಾವ್ ದಟ್, ಮತ್ತು ಸುತ್ತಮುತ್ತಲಿನ ಸ್ಥಳದಲ್ಲಿ ಜೀವ ಬೆದರಿಕೆ ಇರುವುದಿಲ್ಲ ಎಂದು ವರದಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ವರದಿಯನ್ನು ದಿನಾಂಕ 16/4/26 ಮಾನ್ಯ ಪೊಲೀಸ್ ಆಯುಕ್ತರು ಬೆಂಗಳೂರು ಅವರಿಗೆ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. Then comes para 7, where they themselves say on 26/6/2026, FIR is registered against 12 persons by the organized crime wing on 26/6/26 with a conspiracy to murder me. And at para 8, they refer to the order passed by this honorable court about the threat assessment. Then, my lords, para 9, again they refer to the same case at para 7, that is, which is filed against others for hatching conspiracy to murder me.
84/26.
Yes, crime 84.
Yes.
And incidentally, in that, my lords, crime 84, which is the deceased in the earlier murder case in which I am accused, deceased wife is an accused in this 84, and she also has been arrested.
So revenge.
Revenge. That's what their FIR itself says, my lords. Then, my lords, para 10 at page 12. This, my lords, please see what they say. PSI ಶಿವಪ್ಪ ಸೊನ್ನದೂರ್ ಅವರು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಕೈಗೊಂಡು ಅರ್ಜಿದಾರರ ತಂದೆ ಶ್ರೀ ಆರಿಫ್ ಹುಸೇನ್ ರವನನ್ನು ಮತ್ತು ಸದರಿ ವಿಳಾಸದ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ವಾಸವಾಗಿದ್ದ ಭೋಗ್ಯದಾರರು ಮತ್ತು ಬಾಡಿಗೆದಾರರನ್ನು ವಿಚಾರಿಸಿ ವರದಿ ನೀಡಿದ್ದು, ವರದಿಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಜೋಹರ್ ಅಬ್ಬಾಸ್ ರವರು ಅವರ ತನ್ನ ಅರ್ಜಿಯಲ್ಲಿ ತಿಳಿಸಿದ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿಲ್ಲದೆ ಇದ್ದು ಹಾಲಿ ಎಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿದಿರುವುದಿಲ್ಲವೆಂದು ಬಾಡಿಗೆದಾರರು ಮತ್ತು ಭೋಗ್ಯದವರು ತಿಳಿಸಿರುತ್ತಾರೆ.
So this property is leased out.
One portion. My lords, my father, my parent, my wife, even I have to stay there only. They say ಬಾಡಿಗೆದಾರರವರು ಹೇಳಿದಾರದು ಇವರು ಎಲ್ಲಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. Then please see, PSI ರವರು ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಅರ್ಜಿದಾರರು ಸ್ಥಳದಲ್ಲಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲವೆಂದು ತನ್ನ ವರದಿಯಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಹಾಗಾಗಿ ಅರ್ಜಿದಾರರಿಗೆ ಜೀವ ಬೆದರಿಕೆ ಇರುವ ಬಗ್ಗೆ ಥ್ರೆಟ್ ಅಸೆಸ್ಮೆಂಟ್ ವರದಿಯನ್ನು ನಿಖರವಾಗಿ ನೀಡಲು ಈ ಹಂತದಲ್ಲಿ ಸಾಧ್ಯವಿರುವುದಿಲ್ಲ. Only because I am not present, I don't know when they are going to come. I don't know when they have come. So they say, because I am not present there, I cannot give a report. Then, my lords, para 11, they again say, Sanchu Madi, on the Janana conspiracy, we have already arrested and some of them are in judicial custody. Para 12, my lords, they set out 3 cases in which one I am acquitted, one there is a stay. And then say witness program, it does not arise at all.
103 BNSS. What is the status of item number 3?
Item number 3, my lords, this is stayed. Item 3.
103 is stayed.
My lords, ಇದು 103. Serial number 3, my lords, 103 ಅಂದ್ರೆ ಯಾವುದು?
BNSS question.
Lords, the third matter in the table.
It is stayed, my lord.
That we have produced the stay order copy in the petition, my lords. The accusation against me is that I had financed somebody to kill the person, so-called person. I have produced the stay order copy. That's serial number 3. I am A9 in that. In the first one, anyway, I am acquitted. There is no other case so far as I am concerned.
Yes.
Now, only because I am not present, they say I cannot give a
What is the entitlement of yours to seek for police protection?
This is the.
What circumstances could the police protection?
My lords, that, my lords,
When especially you already have around 4
only
private
one
bodyguards.
No, my lords, that also is not incorrect. We have given in our objections. My lords, your lordships may kindly see the photos.
But in the photographs, they have all the
Alla,
guns
ಆ photos one ನಿಮಿಷ
strapped to their
ತಗೊಳ್ಳಿ.
shoulders.
ಅಲ್ಲ,
and-
one ನಿಮಿಷ photos ತಗೊಂಡ್ರೆ, please see the photos, my lords, which is at page 16 onwards. R4 ಅಂತ ಕಾಣುತ್ತೆ. If your lordship sees,
Yes.
first photo is 1420, no date of mine, when it is taken. Please see the next photo.
This comment is on March 19th.
March 19 posting ಅದು ಯಾವಾಗ post ಆಗಿದೆ ಗೊತ್ತಿಲ್ಲ. March 19 and not my Instagram post, somebody else's Instagram post. And please see the time on top, 1420.
That is from the phone.
1420. I'm only saying, please turn out.
That is the phone, Mr. Panindra.
My lords, all are posted on the same day according to us. Please see the next photo also. It's all why I'm trying to say is it's not even my Instagram post. 1418, 1419, 4 photos they showed. 1417.
It is not Instagram. This is.
Lords, according to us, it is an Instagram post. Nam phone allantu alla.
Instagram ಅಲ್ಲಿ 82% battery percentage ಬರುತ್ತಾ?
ಅವ್ರು ಹಂಗಿದ್ರೆ ಅದು ಪ್ರಿಂಟ್ ಔಟ್ ತಕೊಂಡಿಯಾರ Instagram post. It's a screenshot.
It's a screenshot.
Screenshot of an Instagram post.
Yes.
And that is not even my post.
1418, 1419 ಹಂಗಾಗಲ್ಲ. This is
1417.
Abbas Hussain somebody.
Somebody's post, they have taken a screenshot of that. That is not even mine. I'm only saying, my lords, this.
But this photograph is of yours.
My lords, I can't identify myself. Of course, what I identify some other. I am there in one person. I am one of the persons. I am there. But to say this, my lords, is also we don't know the date line. Also, they should at least tell the date line. If it is March, then my lords, after that they themselves have filed a FIR saying that there is a conspiracy to murder me. I'm only saying today there is not even a threat assessment.
What is your right for this?
My lords, my lords, I'll just show the judgments on that. Lord, so far as our case from Karnataka High Court, one judgment, my lord, your lordship may kindly come to page 58.
Yes.
No, my lords, in that also the person was at least here I'm better off. There it was a rowdy sheeter which your lordship should get at page 60. Lords, this judgment follows the earlier judgment of another coordinate bench. Para 3 at page 60, my lords. The narration of the facts, your lordship gets that, my lords.
Yes.
Of the case at hand would not be required as the petitioner is intermittently before this court seeking so and so, wherein this court had disposed the petition with following observations. Learned AGA appearing for the respondents opposes the writ petition contending that the petitioner is a rowdy sheeter. Regard being had to the high population of the state, it is impossible to provide police protection to everyone at the askance. Whether protection should be offered or not depends on the threat perception of the police, and therefore writ petition ordinarily should not intervene in the matter, so contending he seeks dismissal of the petition. Having heard so and so and having perused the petition, this court is inclined to grant indulgence in the matter inasmuch as when a citizen complains to the jurisdictional
This
police.
was after having been granted, it has been renewed. Initial, where is the initial order?
Lords, the initial order, that itself, then they stopped it. This order, para to 3, my lords, was the earlier order.
Mr. Panindra, what we requested you to assist this court.
Yes.
Then what are the circumstances in which a person can get? This is not a protection for the property, for harvesting,
personal liberty and life.
This is personal liberty and life. To you, your family, armed guard to be
Lords, at my cost. At my cost.
24 hours at your cost.
Now, my lords,
what is your right to seek for? What is the provision
lords,
under
I'll
which
tell
you
your
can seek
lordships.
for?
Now, my lords,
so applicable.
Lords, I'll tell your lordship. Maharashtra guidelines have been formed. That was considered in Mohammad Sadiq Hussain. The government has framed guidelines.
Show us what it
Page
is.
28. running page 28, my lords. That's a judgment dated April 8 to 2026.
Yes.
My lords, in that, if your lordship kindly come to para 5, my lords, at running page 30.
Yes.
In which, my lords, in an earlier case, the guidelines for general guidelines for providing protection for by the police, your lordships have, that's in bold. There, they set out the guidelines. Now, if your lordship kindly turn over at page 31, they have called out clause 3. Before that, my lords, clause 3, your lordships have that, my lords. While granting police protection in terms of these guidelines, your lordships.
Where are those guidelines? Do you have the copy of the guidelines?
Lords, it's the entire guidelines is called out here. That's why.
Yes.
3 is called out at page 31. While granting police protection, your lordships have that. In terms of these guidelines, social status of the persons to whom such protection is being granted would be totally irrelevant. The only relevant factor in this regard would be the actual and factual threat to the life of the concerned person and the extent thereof. The concerned SP of police or the commissioner of police, as the case may be, shall alone be appropriate and or competent authority to take a decision in this regard. Then, my lords, they say what the committee is constituted, 11. There, the committee, who are the committee, 3-level committees, the guidelines stipulate. And the members of each committee is at page 32.
Yes.
Then, my lords, clause 10, how it has to be done, what is the fee, all that it runs into. But for the present clause, please come to page 36, clause 15. It states the government resolution also, your lordships have that. Also take into consideration a situation when there is a need to provide protection to persons having criminal antecedents at their credit, and clause which 17 deals with cases is reproduced herein below. Persons having criminal antecedents may also have threat to their life. However, more often than not, these threats are creation of their own illegal activities, if not misdeeds or misconducts. Upon grant of police protection, such persons are likely to misuse the police.
This is a question where they have refused.
Yes.
That is why you are before us.
They have refused.
So even if this goes, the commissioner is the ultimate authority.
He has to do it. My lords, I am only saying this is how it was. Then, my lord, the court noted in that case, my lords, it sent the person who was here also, it was an accused, and my lords, there were cases against him. So the court said,
the application is made to the competent committee.
To the committee. He in our state there is no committee.
So we'll permit you to make an application.
Only one other thing I want before your lordship sees. The next judgment is, my lords, at page 39. Is the Madras High Court judgment, my lords, where there were a lot of cases pending against him. This followed Bombay High Court Division Bench judgment in Arun Gavli's case. Why I am bringing this to your lordship's notice is, here also free protection was not given, but the view of Bombay High Court, which was agreed to by the Chennai High Court, was Article 21, lords, is only as vis-a-vis state and third-party players, it is not applicable if there is a threat by third-party players. But that view now has changed.
Again, is a direction to consider your application.
Today, my lords, I am only saying they gave an endorsement. The endorsement is the same thing. You are not present there, so there is no threat perception.
They rejected it earlier. You are challenging that.
My lords, the endorsement I have challenged in the present writ. Petition. My lords, your lordship may kindly see the writ, my lords. So. Annexure C at page 25.
Tier 2 we can't grant.
My lords?
At the most we can direct them to consider it. That's what we have been telling you. That's why we asked you to please.
No, but that has to go and reconsider within time bound, my lords.
That's all.
Because their own records show there
should have done.
Lords, this is exactly what we have been asking, but not. My lords, again, they should not say, my lords, the problem is, at least your lordships will have to observe. Lords, they say, I've done an inspection, he is not present. How will I know who has come?
Petitioner is before this court seeking for the following views.
I have only one submission, my lord. In para 11, they say, my lord, ಅರ್ಜಿದಾರರು ಜೋಹರ್ ಅಬ್ಬಾಸ್ ರವರ ವಿರುದ್ಧ ಜೀವ ಬೆದರಿಕೆ ಇದ್ದು ಈ ಬಗ್ಗೆ ಈಗಾಗಲೇ ಕೇಂದ್ರ ಅಪರಾಧ ವಿಭಾಗದವರು ಕಾರ್ಯಾಚರಣೆ ನಡೆಸಿ ಸಂಚು ರೂಪಿಸಿದವರಿಗೆ ದಸ್ತಗಿರಿ ಮಾಡಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಬಂಧನಿ.
Even otherwise, is there a threat perception?
Against whom he has threat, my lord, they have been arrested.
No,
They have
there are
been
others
sent to the
abscond.
custody. That is what they say in
But
the
you will have
report.
to look at whether there is somebody else. If you give a report that there is nobody else, then that is different.
Annexure E, page 30, my lords. They themselves have given a note. Others are absconding.
You have only
He is
given the
accused
report
for
saying
under
that
the
he
Arms
was
Act.
not available, therefore I could not do a
No,
threat
my lord.
perception.
That apart, my lord, he is an accused under the Arms Act. And my lord, it will be a precedent if police protection
Then
is given
if
to
your
such.
police is there with him, he can't commit any offense.
He does not come
Your
under the
police
purview of
person only
the.
can arrest him immediately there. This is a good way of keeping him in check.
Leave it to my lord.
You ask your police person also to put one body on camera, so you'll know what it is. But if there is a threat perception, it doesn't have a matter of right. If there is a threat perception, that report has to come, which report is not proper. Do that report properly and then see what you have to do. Petitioner is before this court seeking for the following: alleging that the threat to the life and liberty of the petitioner, inasmuch as the petitioner being an accused in crime number ಏನು ಅಲ್ಲ
32 bar.
ಇದು SC
special CC number 2348 of 2026.
Petition copy. Entry model.
The relatives of the person deceased in the said matter are inimically disposed to the petitioner, in pursuance of which the state, the police has registered a proceeding in
FIR. Crime number 84 of 26.
No, that is yours.
No. Crime number 84 is registered by police. I am not the complainant. At Annexure D, page 26.
Crime number, that is a CC number. Crime number 84 of 26 by the CCB Bangalore City Police. A threat perception report had been submitted that since the petitioner was not residing at the address furnished, the threat perception could not be carried out. It is challenging the same. The petitioner is before this court. The threat perception report cannot be only on the basis of whether the petitioner is residing in that location or not. The threat perception report would have to be prepared on the basis of the threat from and around not only the neighborhood but from the general society to the life of the petitioner. Hence, the endorsement restricting itself to the residency of the petitioner would not be sufficient. In that view of the matter, this court passes following. Writ petition is partly allowed. A certiorari is issued. The endorsement dated 9/4/26 issued by respondent number 1 at Annexure C is quashed. Respondent number 3 is directed to cause a proper threat perception report to be prepared, taking into consideration all relevant factors, and then pass such orders as may be permissible under law within a period of 2 weeks from the date of receipt of a copy of this order.
And I request 1 week, my lord, because he is a syndicate member. He is unable to
Weeks
attend
ago,
meeting.
we told you we will pass this order. You
My
will
lords,
not.
ಅವತ್ತು ಇಲ್ಲ ಅವರು ಅಪೋಸ್ ಮಾಡಿದ್ರು ನಾನಲ್ಲ.
ನೀವು
Lords, your lordship,
ಇಲ್ಲ,
may I
ನಂಗೆ
please
ನಾಳೆನೇ
may I
ಬೇಕು
seek
ಅಂತ.
your indulgence, your lordship's indulgence. Lords, we have furnished the email address and phone number. I don't want them to again go without communicating.
The respondents could contact the petitioner at the email ID and mobile number as furnished in the representation.
Please.
Yes, at least from today ಅಂತನಾರ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಅವರು ಆರ್ಡರ್ ಕಾಪಿ
2
ಕಾಯ್ಕೊಂಡು
weeks from today.
The number 6.
This is modification.
For the petition in this matter, my lords. Because this is the
Oh.
matter where relinquishment.
What is the application that you have filed now?
Because we filed an application for modification of the judgment and one for amendment of the petition to bring on record the relinquishment deed, my lords.
Then before you file this application, you have to file one more application that you have not filed. The order is a final order.
Sought for modification of the orders, well, my lords.
You are asking for an amendment to the petition after the order has been passed.
Also sought for recall of the judgment.
The
to the
recall
extent-
order application.
Sorry, my lords.
Where have you asked for recall?
My lords, two separate applications have been filed, my lords.
Only two IAs which have been posted, IA 1 and 2.
Please, my lords.
There's a separate IA which you have filed?
No, my lords, in the IA for recall and modification, prayer reads that for the reasons stated, petitioner prays that this honorable court be pleased to recall and modify the order dated so and so.
Apply your mind to it and then file a proper application. Relist on 5th August.
7th. Pass our matter is this. Next
We
7
have
matter.
a meeting to go to, we can't take up
Lord,
anything.
this the Niman's matter, my lord, serial number 17 in list 2. The Niman's matter, my lord, Lordship had asked me to furnish Indian addresses. I'll be filing a memo, my lord.
Serial number?
17. The Niman's matter, my lord.
17, the counsel for the petitioner has filed a memo enclosing the email address. Registry is
Indian
there.
address, my lord. Indian addresses.
Email address or postal address?
Post as well as email.
It was filed a memo. Registry is directly issued a fresh notice to the at the address mentioned in the said memo, as also to issue notices by way of email at the email address mentioned.
My lord,
Returnable
counsel
by-
Suresh Way appears for respond number 6 in the said matter.
Returnable by 24th August.
My lord, I may be permitted.
My lord.
Make a submission.
My lord,
My lord,
next
Now count ಮಾಡಬೇಕಾದ್ರೆ 1, 2, 3.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ನಮ್ದು ಇತ್ತು ಸ್ವಾಮಿ ಅದು
my
7
lord, I could not trace out.
2:30 ಹಾಕಿ ಇಂಟರ್ಮ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ.
All interim orders will be extended, no issue. All matters in the second list which have not reached today will repeat tomorrow.
Serial number 9. Kindly have it tomorrow then, my lord. Tomorrow.
List number 1, serial number 5.
List 1 will not be repeated tomorrow. List 1 dates will be given. Yes. That is what we have been telling you. Please allow us to run our cause list. You want to move all the memos, this is what is going to happen. That is why this week we let you do it. Now you know what happens.
Your lordship.
Let us control the cause list, then
My
it
lord,
will reach.
serial number 80, at least day after tomorrow.
My
My lord.
ಎಲ್ಲ interim orders extend ಮಾಡಿ. Second list ನಾಳೆ repeat. First list date.
My lord, my lord,
matters.
with your lordship's.
Pass our matter.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು. ಅದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಾಳೆನೇ ಇದೆಯಾ? ಅದು ಒಂದ್ ನಿಮಿಷ ಮ್ಯಾಮ್, ಅದು KLA ಮ್ಯಾಟರ್.
ಯಾವುದು? ಅಲ್ಲ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲಾನು 13th ಆಗಸ್ಟ್. ಎಂಟ್ರಿ
Madam.
ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್.
ಯಾವ್ದಿದ್ರು ರೀಚ್ ಆಗಲ್ಲ. ನೀವು ನಾಳೆ ಹಾಕಿಸ್ಕೊಂಡ್ರು ರೀಚ್ ಆಗಲ್ಲ.
ಮೇಡಮ್ 68 ಸೀರಿಯಲ್ ನಂಬರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಅದು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೇಡಮ್, ಎಕ್ಸ್ಟರ್ನಲ್.
ಈಗ 13th ಆಗಸ್ಟ್ ಆಗಿತ್ತು. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದು 10:30ಗೆ 2:30ಗೆ ತಗೊಂಡು.
ಮೇಡಮ್
Madam, serial number 55.
33.
Madam, serial number 55 ಈ ತಿಂಗಳಲ್ಲಿ ಯಾವಾಗಲೂ ಇಲ್ಲ. TFR getting
ರೀಚ್ ಆಗಲ್ಲ.
ಮೇಡಮ್ 33 ಸೀರಿಯಲ್ ನಂಬರ್.
ಒಂದು covered by decision, ಅದು ಸಾಹೇಬರ decision.
ಮೇಡಮ್ 33 ಸೀರಿಯಲ್
ಮೇಡಮ್
ನಂಬರ್.
ಪಾರ್ಟಿಗೆ ಉತ್ತರ
ಯಾವತ್ತು
ಹೇಳಿದ್ರೆ
ಕಾಯ್ತೀರಾ? ಯಾವತ್ ಕಾಯ್ತೀರಾ?
30, 31.
ಯಾವತ್ ಕಾಯ್ತೀರಾ ಹೇಳಿ? ಎರಡರಲ್ಲಿ
Madam.
ನೀವು ಕಾಯೋ ದಿನ ಹೇಳಿ ಅಷ್ಟೇ.
ಮೇಡಮ್ 33 ನೋಡಿ ಮೇಡಮ್ 33 ಸೀರಿಯಲ್ ನಂಬರ್
ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
Connected ಅವೆಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ ಅವು ಅದಲ್ಲದೆ ಅದೊಂದು 42 ಒಂದು ಇದೆ ಮೇಡಮ್.
ಸೀರಿಯಲ್
ಫೈಲ್ ಮುಗಿಸಿ ಪೋಸ್ಟ್ ಮಾಡಿದೀವಿ ಮೇಡಮ್ ನಾವು. 42 ಒಂದು ಪುನಃ 88 ಒಂದು
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 30
ಎಂಟ್ರಿ ಮಾಡಿ ವೆಕೆಟ್ ಆಗ್ಬೇಕು ಅಂತ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33
ಮೇಡಮ್ ನಮ್ದು
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮಾತ್ರ ನಾಳೆ.
ಮೇಡಮ್
ರಿಪೀಟ್ ಆಗುತ್ತಾ?
ಸೀರಿಯಲ್ ನಂಬರ್
ನಾಳೆ.
13th August.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ 13th ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ
33
ನಾಳೆ.
ನಾಳೆಗೆ ಇದೆ ಅದು ಬ್ಯಾಚ್ ಮಾಟರ್ ಆಗ್ತಿದೆ ಅಂತ ಹೇಳಿದ್ರು. KLA ಮಾಟರ್
ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಓಕೆ
ಅಲ್ಲಿ ಫಸ್ಟ್ ಬಿಫೋರ್ ಕೋರ್ಟ್ ಅಂದಿದಾರಂತೆ.
ಹೌದಾ?
ಯಾವಾಗ ಬರುತ್ತೆ ಗೊತ್ತಿಲ್ಲ.
ಮತ್ತೆ ಅಲ್ಲ ಇವಾಗಿರೋ ಡೇಟ್ ಯಾವಾಗ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಥವಾ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಟ್ರೆ ಆಗುತ್ತೆ?
ಫಾಸ್ಟ್ ಅವರ್ಸ್ ನಾಳೆ.
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಯಾವ ಲಿಸ್ಟ್ ಬರುತ್ತೆ ಮ್ಯಾಮ್?
ಎಲ್ಲ
ಫಸ್ಟ್
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 17 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲದು ನಾಳೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 87
ಅದು 13th August.
ನಾಳೆದಿಗೆ ಹಾಕೋಬಹುದಾ?
ಮೇಡಮ್ 83 ಸೀರಿಯಲ್ ನಂಬರ್
13% ಇದ್ರೆ ಮಾತ್ರ ಹೇಳಿ. ಅವ್ರು
13% 83 ಸೀರಿಯಲ್ ನಂಬರ್
83 ಯಾವತ್ತು ಬರ್ತೀರಾ ಸರ್?
ಫ್ರೈಡೆ ಥರ್ಸ್ಡೇ ಆರ್ ಫ್ರೈಡೆ
ಹೇಳಿ, ನೀವೇ ಹೇಳಿ.
ಈ ಥರ್ಸ್ಡೇ ಆರ್ ಫ್ರೈಡೆ
24
ಹಾ
ಫ್ರೈಡೆ.
ಮೇಡಮ್ 90
14%
ಮೇಡಮ್
ಮಾತ್ರ ಡೇಟ್ಸ್ ಅಷ್ಟೇ ಅವ್ರು ಕೇಳೋದು.
14%
ಸೀರಿಯಲ್
ನಂಬರ್ 50
ಯಾವಾಗ ಸರ್ ಅದು?
ನಾಳೆ ಆದ್ರೆ ನಾಳೆ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
ನೀವು ಕಾಯ್ಬೇಕಲ್ಲ ಯಾವತ್ತು ಅಂತ ನೀವು ಹೇಳೋದು.
ನಾಳೆ ನಾಳೆ ಕೊಟ್ರೆ ಕೊಡಿ
ನಾಳೆ
ನಾಳೆ ಕೊಡಿ ಮೇಡಮ್.
ಮೇಡಮ್ 57ನೇ ಮ್ಯಾಟರ್
ತುಂಬಾ ನ್ಯಾರೋ ಮ್ಯಾಟರ್ ಮೇಡಮ್ ಎಂದ್ರು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಸಿಗ್ಬೋದಾ?
57
ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್
57ನೇ
57 13th August.
ಮೇಡಮ್ ಎಲ್ಲಾನು ಮೇಡಮ್
ಎಲ್ಲ ಏನು ಕೇಳಲ್ಲ.
ಅಲ್ಲ 55
13th August 14%
ಮೇಡಮ್ 55 ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ಮೇಡಮ್ 84 14%.
ಯಾವತ್ತು ಬರ್ತೀರಾ ಸರ್?
ಯಾವತ್ತು ಕೊಡಿ ನಿಮ್ಮ ಇದು ಶಾರ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ ಅಂತ.
ಅದೇ ಹೇಳಿ ನೀವು ಹೇಳಿದ್ರೆ ಡೇಟ್ ಅವತ್ತೇ ಹಾಕ್ತಾರೆ. ಒಂದ್ ಹೇಳಿ 27 13th August 13 August ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ನಾಳೆ ಅಂದಿದ್ದಾರೆ ಹೇಳೋಗಿದ್ದಾರೆ. ನಾಳೆ ಹಾಕ್ತೀನಿ. ನಾಳೆ ತಗೊಳ್ಳಿ. ನಾಳೆ ತಗೊಳ್ಳಿ. ನಾಳೆ ಅಂದಿದ್ದಾರೆ. ಪೇಪರ್ಸ್ ಎಷ್ಟಿದೆ? ನಾಳೆ ಬರುತ್ತೆ. ಹೌದು ಎಲ್ಲ ಹೌದು. 13th August 13 August ಗೊತ್ತಿಲ್ಲ. ಪ್ರೇಯರ್ ನೋಡಿದ್ಮೇಲೆ ಗೊತ್ತಾಗೋದು. ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ? ನಾನು ಪ್ರೇಯರ್ ನೋಡ್ತೀನಿ. ಪ್ರೇಯರ್ ನೋಡಿ ಅದು ಫಿಶರೀಸೇ ಆಯ್ತು ಅಂತಂದ್ರೆ ಯಾವತ್ತು ಚೆಕ್ ಮಾಡ್ತೀನಿ ಪ್ರೇಯರ್. ಆಮೇಲೆ 13th August ಅದೇ ಅಷ್ಟು ಆಗುತ್ತೆ. 13th August 13th August ಇಲ್ಲ ರೀಚ್ ಆಗಲ್ಲ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದು 10:30 ಮೆಮೊ ಹಾಕೊಳ್ಳಿ. ಯಾವತ್ತು 13th August. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದು 10:30 ಮೆಮೊ ಕೊಟ್ಟು ಯಾವತ್ತಿಗೆ ಬೇಕೋ ಹಾಕ್ಸ್ಕೊಂಡು